support my right honourable friend's amendment tonight, as I did last night. I'm on the Council of Europe, so I take quite a lot of interest in this. And there is established legal principle that, in fact, the judge was acting ultra vires in 2022, that it was not in his powers to do it. And there is also established legal opinion that our government could actually have ignored it. So how does this relate to his amendment now?
Well, I'll come on to exactly the points that he's making. They're fair and important ones. I think as night follows day, if we don't make changes in this respect, we'll find ourselves in a few months' time in exactly the same position that my right honourable friend, the member for Whittam as Home Secretary, was in the summer of 2022, whereby the Strasbourg court will issue one, potentially many, Rule 39 interim measures. The decision will fall to a minister, perhaps my right honourable friend, the Minister for Illegal Migration, and other colleagues within government, about what to do. The courts will be involved, and we'll find ourselves in a very difficult, indeed intractable situation. It is, as I've said before, a bit like pulling the pin out of a grenade, but not being prepared to throw it. Setting this scheme in train without knowing what you would do when this happens. It's entirely foreseeable. Let's find a way through this challenge. I'll give way in a moment. Now, to answer my right honourable friend's question and to think about the legitimate challenge that's made to those like me who make this argument or who raise this issue, you have to go back to the foundation of the court. And many of my colleagues say, well, it was great conservative and British jurists who were the authors of the European Convention on Human Rights. Why would you want to alter what they created? Well, with respect, that's a misunderstanding of what was done when the convention was founded and the treaty signed. No one signed up to the court being able to make binding injunctions. In fact, quite the opposite. This was considered at the time and was rejected. The UK, like all other signatories to the European Convention, expressly declined to give the court the power to make binding interim measures. This was something that was created by activist judges in 2005 in response to a particular case, which was the Mamat Kulov Askalov versus Turkey case in 2005, whereby the court conferred upon itself a power which was not given in the treaty. And I think it is a mistake that the United Kingdom has, by convention, gone along with this approach that the court has given itself for many years. And don't take my word for it. Take the word of many other eminent jurists and lawyers. When this very point was considered in the other place during the passage of the Illegal Migration Act, a point not dissimilar to the one that I'm making, but I won't put words into their lordships' mouths, was made by the noble Lord Sandhurst, the noble Lord Fuchs, the noble Lord Wolfe, and in a foreword to an important piece related to this, the noble and learned Lord Sumption has made a similar and very important point. In fact, the professor of international law at the University of Oxford, Professor Richard Eakins, that many of us respect highly, has said that to change this approach is not to breach the rule of law, it's to defend the rule of law, because we as signatories of the European Convention expressly objected to this approach. And this has been conferred by activist judges outside of the rule of law, and we shouldn't be following through this. I'll give way to the honourable member because he was first in the queue.
I'm very grateful to the honourable gentleman, and I will say at least he has the strength in being vocal about what he actually believes, which is a lot more than many on that side. And he's made it clear that in his view, he could not care less about what European conventions on human rights say. Will he go further and actually openly say that there is one purpose of this vile, dangerous, inhumane bill, which is to flout international law, and that that side couldn't care less about human rights of the most vulnerable individuals?
But I can't say I'm surprised that the honourable gentleman sinks to those depths and doesn't present a proper legal argument in response, because if he'd been listening to me, I didn't say anything of the sort. The case that I'm advancing is far from undermining the European Convention on Human Rights, and there are many who might wish to leave it. We're defending the original intent of the European Convention on Human Rights and the rule of law, because I don't think that it is sustainable for activist judges in Strasbourg to bend and change the original intent of the signatories of that convention in ways that they would never have accepted and invent new powers. I want us to defend the rule of law, and in this case, that is best defended by saying that interim measures from the European Court are not binding on the UK, either on the domestic plane or upon our ministers. And it is better that we return simply to the position that we were in as a country before 2005. In fact, I think most of that was under a Labour government. I'll give way to the honourable member.
I thank the Foreign Minister for giving way. I just wonder, is this British exceptionalism? Is the case that he's making that the ECHR should only no longer apply to the UK, or is he saying that it's not fit for purpose across the board and should be scrapped entirely?
I feel as if we're having a bit of a dialogue over the deaf here, because that's not what I said at all. I said that the debate about the European Convention is for another day. But what he is saying that the decision of the Strasbourg Court in 2005 to confer upon itself, without seeking the consent of any of the signatories of the Convention, that it should be able to impose interim measures, injunctions, upon other countries which are binding, is the right way forwards. And indeed, that those injunctions should be able to be made at the 11th hour, in the middle of the night, without giving reasons, without asking for our own arguments, without even naming which judge was behind that. I think that poses very serious rule of law questions and is a reason why conventions such as the European Convention are increasingly out of step. I'll give way to my right honourable friend.
My right honourable friend, of course, is right, and that contradicts custom and practice over a very long time indeed. What was the accepted basis for the rule of law in this country? He cites Lord Sumption and Lord Wolfe, but he might have cited A.V. Dicey, who established long ago as a constitutionalist, supported by Lord Denning and many others after, that the relationship between the rule of law in this place is that a polity makes laws because it has the legitimacy to do so, conferred on it by the people, and it can change laws, and that, frankly, means that this House is supreme. That doesn't in any way underestimate the significance of international agreements and treaties, but it does affirm the significance and sovereignty of this House.
I entirely agree with my right honourable friend, and let's move forwards and see what. Well, I'll give way to the honourable lady, but then I'll continue my argument.
For giving way, because as somebody who has served on the Council of Europe and was proud to do so because of the United Kingdom's history in setting it up to protect citizens from overbearing governments, I think it is worth to look at the actual data on interim measures. So for the 3 years that we know about, in 2019, there were 82 requests made to the Strasbourg Court for interim measures against this government. 0 were granted. In 2020, 47 made, 2 granted. In 2021, 51 applications against this government, 5 granted. So that's just 7 out of 180. Is he really suggesting that this government gets things right all the time, that there should be no capacity to legally challenge them, even when irrevocable harm is on the agenda?
Making, and once again, the honourable lady isn't listening. The point I'm making is not about the virtues or otherwise of our membership of the European Convention on Human Rights. I've said that is a matter for another day. The discussion on this amendment is simply whether or not we believe it is right that the Strasbourg Court should confer upon itself, without our consent, the ability to impose binding injunctions. There's a separate question, not unrelated, as to how those injunctions are made, and I think most of us, I'd like to believe, would agree that doing them late at night with an named judge without giving reasons raises serious rule of law questions. Perhaps the Honourable Lady disagrees with that. But the purpose of this amendment is to enable us to return to a position that, yes, of course, the Honourable Lady has her clip for social media now, so the rest of the debate is largely irrelevant. But I'll give way to the Honourable Lady.
I want to address the point of law about the court in Strasbourg. The difficulty with the argument he's making is this, is it not? That under the scheme of the Convention, the court is the body that determines the meaning of the Convention. And not just in the case, the 2005 case, but consistently thereafter, the court has held that failing to comply with interim measures amounts to a breach of Article 34 of the Convention. Now, that's the legal difficulty with his argument, is it not?
No, it may be a good faith disagreement between the Honourable Lady and I, but I don't believe that international bodies and courts should be able to grow organically as a result of the decisions of activist judges. I think this is a matter of the rule of law and of parliamentary sovereignty. And we in the United Kingdom chose to be signatories of the European Convention on Human Rights. I don't think it's correct that the court gave itself this power in 2005. Now, let me return more directly to how this relates to this policy. So, firstly, let's cast our mind back to the summer of 2022. An interim measure came via a Rule 39 interim measure was imposed by the court. This grounded the flight and prevented us from proceeding with the policy. Do we think that anything has changed in the months and years that have passed? My conjecture is no. We will be in exactly the same position in a few months' time unless we take action. In the Illegal Migration Act, we included a provision which merely restated the orthodox constitutional and legal position that, in theory, it is at the discretion of a minister as to whether or not to comply with a Rule 39 interim measure. Belying that was the government's legal advice that, in its opinion, which I believe to be erroneous for the reasons I've just described, it would be in breach of international law to do so. The Attorney General and the government legal service, therefore, as far as I'm aware, continue to advise ministers and civil servants that a decision not to support a Rule 39 interim measure would be illegal and would be in breach of the ministerial code. In fact, my best recollection of that was that no minister should give any indication that they would ignore a Rule 39 interim measure. The Attorney General's position, as I understand it, is that there is a very small number of cases in which it is conceivable that one could do so. But that's a vanishingly slim number of cases and situations. So were that situation to continue, as night follows day, we'll find ourselves in exactly the same situation we were in the summer of 2022. I don't want to be in that position. And I think it would be a huge breach of trust to the British public if we knew something was likely, if we've watched this train speeding down the tracks but moving slowly towards us. We've had ample opportunity to resolve this issue, and we've chosen to do absolutely nothing. We've kicked the can down the road. There's no more road. At the end of the road, there's a precipice. We're moving forward with a scheme, but we don't know how to implement it. We're pulling the pin out of the grenade, but we haven't got the guts to throw it. What we need to do is resolve this. And the way to resolve it seems to me to be quite simple. The government could accept the amendment in my name and that of many, many others. To do so is not to say that we're leaving the European Convention on Human Rights. There are respectable international law arguments behind the amendment. I would wager that the government would have no difficulty finding senior KCs and former judges in the other place who would support my position and its position if it chooses to adopt it. It could change some of the minor documentation that accompanies this, like the Civil Service Code and the Ministerial Code. But I wouldn't place too much emphasis on those. At the end of the day, this isn't about civil servants. This is about ministers, and it's about the law. I think a good captain doesn't blame his sailors. It's on us. We have the power to fix this, and we have the responsibility. So let's use the opportunity we have today with the amendment that we've brought forward to resolve this. Or else, we will be here in 2 months' time. The Strasbourg Court will impose a Rule 39. The government will be scrambling around how to resolve this. And the government will have no one else to blame. I'm here to help the government to ensure this policy works, because I, like everyone, at least on this side of the House, believes passionately that we have to make this policy work and to stop the boats. So I strongly encourage my right honourable friend, and indeed the Prime Minister, to support the amendment in my name and that of many others, and encourage everyone else on all sides of this House who share my determination to fix this problem to do exactly the same.
The question is that Amendment 11 be made. Shadow Minister Stephen Kinnock.
Thank you very much indeed, Madam Chair. It's a pleasure to serve under your chairship again today. So here we go again. Day 2 of committee stage of the third asylum bill in less than 2 years, and day 643 perhaps of the Rwanda psychodrama that the Conservative Party continues to inflict on our weary and baffled nation. And let's not forget that this whole saga started off as Operation Save Big Dog, Madam Chair. That desperate and thankfully doomed attempt to save the skin of Boris Johnson. But then, for some bizarre reason known only to the benches opposite, it didn't fade away once Mr Johnson exited stage right. No, quite the opposite took place. Instead, it took a life of its own. It evolved into an article of faith for the Conservative Party, a purity test that has come to define whether or not you're a true believer. And so vast quantities of political capital and untold amounts of government time, resources and energy have been squandered on a policy that at most might possibly one day enable the transfer of a few hundred asylum seekers to Rwanda. It truly is an extraordinary state of affairs, Madam Chair. And meanwhile, out there in the real world, food bills are spiralling, mortgages are going through the roof. There are 7.8 million people on NHS waiting lists. Raw sewage is being pumped into our rivers, and at least 30,000 people risked life and limb to cross the channel on small boats. And nothing in this bill will address any of the challenges that I've just outlined, not even that last one. As I said yesterday, the Rwanda plan is extortionately expensive, with £400 million on its way or committed to the government of Rwanda without a single asylum seeker ever being sent there. And in addition to that vast sum, it will cost at least £169,000 to send each individual asylum seeker to Rwanda, probably far higher than that, but the government is refusing to come clean on that point. It's also unworkable because there is no evidence that sending just a few hundred asylum seekers will deter the tens of thousands who are crossing the channel each year. Desperate people who have risked life and limb crossing continents to escape from violence and persecution are not going to be deterred by a less than 1% chance of being sent to Rwanda. And, of course, we know the scheme, in addition to being unaffordable and unworkable, is unlawful as found by the Supreme Court due to Rwanda not being, as it stands, a safe country. And yet here we are again, being forced to indulge the fantasies, fixations and psychodramas of the benches opposite. I will be quiet.
That's the narrow legal point. Does he think that it was right for a Strasbourg judge to impose an injunction in the night on his own, giving the British government the chance to make their case? Does he think that was right?
Well, what we are seeing is a complete shambolic incompetence in the asylum system. And if cases are not made clearly and are open to legal appeals will come, and in some cases those legal appeals will succeed. On the broader point, the reality is that the United Kingdom is party to a number of international agreements and conventions, and that reality is extremely important to our national interest, and in many cases strengthens our sovereignty and not weakens it. So we on these benches are absolutely clear that politics is about choices, and when you look at the bigger picture in terms of our country's place in the world, it is absolutely clear that our sovereignty and our national interest is strengthened, not weakened, by being party to these international agreements and conventions. But, Madam Chair, I'll just make a little bit of progress and I'll come back. What is also deeply troubling is that every day seems to bring a new example of the tail wagging the dog. Because we now hear the Prime Minister is assembling 150 judges and 1,000 staff to fast-track Rwanda cases through our courts. Sorry, what? Does the Prime Minister know that under his leadership and on his watch, the Crown Court backlog in this country is at a record high of 65,000, victims of serious crime regularly waiting more than 2 years for their day in court so they can seek justice against their perpetrator, completely and utterly broken system due to 14 years of Tory incompetence and indifference. And yet the Prime Minister clicks his fingers and is glibly apparently able to magic up 150 judges and 1,000 staff. Where on earth have these 150 judges been hiding all this time, Madam Chair? Are they going to be new recruits, or are they currently working? And if the latter, are they going to be told to drop everything and transfer themselves to dealing with asylum cases? I trust that the Minister will be able to answer these questions today, Madam Chair, but I'm not holding my breath. But regardless of the operational issues, just imagine the impact the Prime Minister's glib announcement yesterday would have on you if you were the victim of rape, who has been languishing for years in our broken judicial system. Just imagine the anger and the disgust you would feel at the spectacle of a Conservative Prime Minister sacrificing your fight for justice on the altar of his desperate attempt to cling to power by appeasing his backbenchers. What an utterly shameful and shabby way for the Prime Minister of our country to behave, Madam Chair. And I will give way to the honourable gentleman.
I'm very grateful to the Shadow Minister for giving way, and particularly on the point that he raised about choices and political choices in this. He is valiantly opposing this bill and he voted against it at second reading, just as I did. But does he recognise that, given that this is the last session of this Parliament, that the Parliament Act cannot be engaged and there's plenty that will take place in the other place? The only way the Safety of Rwanda Bill becomes law is if Labour make the political choice to say that fighting it and frustrating it any longer is not in your interest.
But, I thank the honourable member for his comments, but we have made absolutely clear that this bill is unaffordable, unworkable and unlawful, and we on these benches will never support any piece of legislation that is guilty of those three sins. So it is as clear as crystal to us that we will, with pride, we voted against it at second reading. With pride, we voted against the amendments that would just make it even worse. And with pride, we will be voting against this bill at third reading. I will give way.
I'm very grateful to my honourable friend, and he absolutely makes the right point with regards to the issue around the purpose of this bill. And let's not forget that there is only one purpose of this bill. And would he agree with me that this is one of the most flagrant attempts we've seen at directly flouting international human rights law, and that's the only purpose of the bill before us today?
I thank my honourable friend for that powerful intervention. It is a bit difficult to determine what the true purpose of the bill is these days, because it has become, I think, embroiled in various Tory internal wars and fights in terms of the factions. It's become embroiled in certain people's leadership ambitions, I think. So it's not that easy to discern what the true purpose of the bill is. But one thing we do know is it will not stop the Tory small boats chaos. That is the chaos that has to be stopped. The people smuggler gangs are trading in human misery. They must be stopped. But we need practical, sensible, pragmatic measures rather than the headline-chasing gimmicks that we have seen from this government over the last years and months. But of course, the irony, I will give way in 1 second, the irony of the announcement yesterday about the judges was, by definition, it's an admission of failure, because it is a recognition of the fact that the bill before us today will fail to prevent the legal challenges and appeals that the judges are going to be working on. So the Prime Minister's announcement yesterday was also further evidence of the profoundly troubling way in which this government is prepared to disregard and disrespect our judiciary. And I would urge members on all benches to take careful note of what Sue Carr, the Lady Chief Justice, told Parliament's Justice Committee yesterday, and I quote, "I'm afraid that this headline draws matters of judicial responsibility into the political arena. Matters of deployment of judges, the allocation of work for judges, and the use of courtrooms is exclusively a matter for the judiciary, and more specifically, a matter for myself and the senior president of the tribunals. It's really important that people understand that clear division. There speaks a true democrat, Madam Chair."
Minister for giving way. The Shadow Minister will know that it is our view on this side that this problem cannot be comprehensively tackled without a deterrent. I can't think of any examples around the world where it's been tackled without a deterrent. Right. I know the Shadow Minister has spoken before about safe and legal routes, and I've asked him questions before about whether he thinks the numbers associated with these safe and legal routes should be capped or whether they should be uncapped. Has the Shadow Minister had thought about what the cap level would be? What would be the number?
Well, I thank the honourable gentleman for his intervention. It's clear that in order to stop the Tory small boats chaos, we have to smash the criminal smuggler gangs. That will be done through enhanced cooperation with European partners and allies. A crucial part of that is, of course, the Shadow Home Secretary and the Leader of the Opposition visited Europol recently. Hugely important that we get better data sharing, cooperation with European authorities, Europol, Frontex, in order to be able to smash the criminal gangs upstream. As I will go on to say in my remarks, the more you jeopardize cooperation with our European partners and allies by threatening to leave the European conventions, the more difficult you make it to have that European cooperation, and therefore you undermine your own ability to deter the criminal smuggler gangs. If you were looking for a definition of counterproductive legislation and policies, this would be the one that you would go for. I'll give way to the gentleman.
Very good point about cooperation. And he's right, the only way you can tackle this problem is by a suite of measures under umbrella policy. But an important part of that, as my honourable friend just described, is deterrent. Because the criminal gangs that he described, their brand, their marketing message is you'll get to Britain and never leave. And sadly, that's been too often the case, has it not?
Well, I thank the honourable gentleman, and there are pragmatic, sensible things the government has been doing that we support. The Albania deal, for example, fully supported by ourselves on these benches, and the fact that removals to Albania are facilitated by that deal has acted as a deterrent. It's led to a clear decrease in the number of Albanians trying to come over. Why doesn't the government do more of that? Do the pragmatic, sensible stuff, rather than being sucked into endless bun fights about this Rwanda deal, which is unaffordable, unworkable, and unlawful. It's a question of priorities, that's what I would point out to the honourable gentleman. When a government has limited time, resources, and energy, focus it on the stuff that works rather than on the headline-chasing gimmicks.
The mantra has been clear for many months from the benches opposite, including himself, about the need for safe and legal routes. So can we have some indication of what the level of safe and illegal routes would be to address the problem? And I put it to him, as soon as that cap is reached, the rest will come by boat unless there is a deterrent.
Well, in terms of safe and legal routes, what I would look at is, as a priority, things like the Afghan scheme, which is completely and utterly broken. We've seen ARAP collapsed, we've seen ACRS never really working. Which is the nationality that is always in the top 3 or 4 nationalities crossing the Channel? It's the Afghans. So I think what we need to do is make sure we get the schemes that are currently in place working properly, and then we need to look at international cooperation, working with our European partners and allies, and creating a dynamic whereby the United Kingdom does its bit as part of ensuring that those who are trying to cross the Channel on small boats do not do so. Okay.
Drawing him back to the actual amendments and to the interim measures of the Strasbourg Court, to build on the question from my right honourable friend, am I right in understanding the Labour Party's position is that it does not want to see reform of Rule 39 interim measures? Because I find that very surprising, given that the UK is working in concert with many, perhaps all signatories of the European Convention on Human Rights to do just that, because most of our friends and allies in Europe consider there to be serious rule of law issues arising from the so-called pyjama injunctions, and we want to see them, like them, reformed. Would the Labour Party abandon that piece of work?
Everything that we do when, as I hope, we enter government will be based on the test. Is it affordable, is it workable, and is it legal? The legal piece has to be based on compliance with our international legal obligations. However, if you cherish something, you also have to be prepared to be open to changing it, to improving it. And it is clear that a global conversation is required about the immigration position in which we find ourselves. A European conversation is required, and absolutely, if we, in concert with our international partners and allies, can find ways of improving the system, then of course we on these benches would be looking to do that. It's unfortunately not a deal that we can negotiate from opposition. It's something that we will certainly be looking to prioritise as and when we come into government. If you don't mind, if the honourable gentleman, I'll make a little bit more progress and I'll come back to him.
Order. Just to say, it is convention that if a speaker is to be intervened on, the intervenee, if that's the word, would be there from the beginning of the speech. And I know the right honourable gentleman came in a little later than when Stephen Kinnock started his speech. Stephen Kinnock.
Thank you, Madam Chair. So it's against the backdrop of chaos, confusion and party before country that we consider the amendments that are before us today, Madam Chair. And I'd like to start by commenting on the amendments in the name of the former Immigration Minister, the Right Honourable Member for Newark. Madam Chair, this bill is riddled with shamefully anti-democratic clauses that undermine the rule of law and seek to undermine the conventions and values that we on these benches hold dear. But perhaps the most egregious example of this is the admission on the face of the bill that its provisions may not comply with the United Kingdom's obligations under international law. And indeed, Clause 3 explicitly disapplies international agreements, including the 1951 Refugee Convention and the 1984 Convention Against Torture. The leader of the more moderate Conservative caucus, the One Nation group, described this approach as authoritarian and a betrayal of who we are as a nation. And he was absolutely right on both points. Our liberal democratic nation is founded on the rule of law and on our respect for the judicial function. Our international standing is founded on our commitment to human rights and international law, and our proud history is founded on the delivery of these principles, including indeed Winston Churchill himself actually helping to establish Britain as a founder of the 1951 Convention. I made the point yesterday, I'll make it again, that it's not for politicians to interfere with court judgments, and it's not for the government to respond in a knee-jerk manner to court rulings that it dislikes. That is the behaviour of an autocracy, not of a democracy. How on earth can our country be the international standard bearer for the rule of law in the face of, for example, Putin's barbarism or an increasingly belligerent China, if we are breaking our own international obligations? Indeed, how can we even hold Rwanda to account on its commitment within this new treaty if we're not practicing what we preach? And then there is the real and present danger that this bill represents in terms of the international agreements that Britain is party to, all of which are central to our national interest.
I thank the honourable gentleman for giving way. Those who are worried about social media may also find it useful to use their phones in the chamber to double-check those international obligations, and indeed the original text of the European Court of Human Rights that says explicitly the high undertaking parties agree to abide by the decision of the court in any case to which they are parties. From the start, it was intended that there was a check and court. I listened to the gentleman opposite. I hope he will accord the same respect and courtesy to me. Does the member agree with me that from the start it was envisaged it was an important check and balance to involve the courts in decision-making?
Well, my honourable friend makes a very good point, and I think, as we've also seen in the letter that Nathalie Oiseau has sent to her about the potential risks that there are to the Trade and Cooperation Agreement and a range of other commitments, it is absolutely clear that it is in our national interest to pool our sovereignty with other nations through these conventions in order to strengthen our own national sovereignty, and I agree absolutely with her on that point. But firstly, looking at some of these agreements, the Good Friday Agreement. The European Convention on Human Rights is woven integrally into many different parts of the GFA. The political settlement in Northern Ireland should not be taken for granted. So disapplying the ECHR in British legislation would be playing with fire in that regard, Madam Chair. And of course, the Prime Minister's very own Windsor Framework, which sought to resolve the issues around trade and Northern Ireland post-Brexit, was agreed on the basis of the UK's full commitment to the GFA. I'm sure that the Prime Minister wouldn't want to accidentally set fire to his own carefully crafted negotiations. Then there is the EU-UK Trade and Cooperation Agreement, which includes clauses on important mutual security cooperation, which are reliant on Britain's commitment to the European Convention on Human Rights. Under Articles 1 and 692 of the TCA, UK withdrawal from the ECHR entitles the EU to immediately suspend or terminate the entirety of Section 3 of the TCA. So introducing notwithstanding clauses into this bill would mean that the government would also be dicing with the risk of jeopardising security cooperation with our European partners and allies. And the irony here is that this very security cooperation and data sharing is of pivotal importance when it comes to smashing the criminal gangs that are behind the small boats crossings. So this bill that is designed to stop the potential of, which is designed to potentially deal with the issue of the small boat crossings and the criminal gangs, could potentially undermine the very cooperation which is supposed to be smashing those very gangs. You literally could not make it up, Madam Chair. So I do not believe that legislative belligerence is in the interests or the traditions of the party opposite, and I certainly don't believe it's in the interests or traditions of our own proud nation. And the amendments that have been tabled by the former Immigration Minister, I'm afraid, would simply increase all the risks that I've described, and so we on these benches will be opposing them. Madam Chair, I turn now to the Labour Party's amendments. Again, I stress that we reject this bill in its entirety and that our amendments are designed to limit the damage of this unaffordable, unworkable and unlawful piece of legislation. A major concern of ours is around the way in which the government is handling the entire Rwanda saga from the point of view of transparency. From everything from the costs to the processing capacity of the Rwandan government to ministers trying to hide the fact that criminals will be sent from Rwanda back to the UK, and the fact that the UK may have to take some refugees from Rwanda. Our Amendment 36, New Clause 7 and New Clause 8, are all a part of an attempt to force the government to shed more light on the less clear aspects of the scheme and to introduce more accountability. Amendment 36 would require that the government publish a full impact assessment setting out the costs per person for the removal scheme and the confidential financial memorandum already agreed between the two countries. We believe the cost per person is far higher than the 169,000 already acknowledged by the government, and we want ministers to come clean on that point. New Clause 7 would require the Secretary of State to report to Parliament on a regular basis, as with the Monitoring Committee every 90 days on the operation of the scheme, including data on the number of people relocated to Rwanda and the costs incurred by the UK government. Similarly, New Clause 9 would require regular reporting on the number of asylum seekers declared inadmissible under the Illegal Migration Act from the point of its entry into force, whenever that may be, and the number of such asylum seekers who were subsequently removed to Rwanda. New Clause 8 would impose further reporting requirements on the government, including on the number of individuals involved in criminal activity who have been transferred from Rwanda to the UK. In the event of any such transfers, the government would be required to table a debatable motion in Parliament so that MPs could consider whether, in light of the transfers, the operation of the treaty should be suspended. It is important that the British public understand just how many foreign criminals the Conservative government would be importing back into our country as part of this Rwanda deal. Further amendments relate to the Monitoring Committee, a central part of the new treaty which both sides are required to set up in order to oversee the operation of the removal scheme and to provide a mechanism for individual asylum seekers to lodge confidential complaints directly with the committee. The Supreme Court raised initial concerns about the capacity of the committee to review complaints in its judgment. Our Amendment 59 would make the establishment of this committee a necessary precondition for the commencement of this Act, and new Clause 5 would place the committee on a statutory footing. The Monitoring Committee would be required to report to Parliament every 90 days, confirming that all the relevant obligations set out in the treaty are being fully complied with. In the event the Monitoring Committee either fails to meet the 90-day requirement or reports to Parliament that Rwanda is not in full compliance with any provision of the treaty, this Act would effectively be suspended from being in force until any issues with timing or compliance have been resolved. Linked to this, new Clause 13 stipulates that the operation of this Act should be suspended at any time when the Monitoring Committee is not in operation. Finally, new Clause 5 states that it is for a Minister of the Crown and that Minister only to decide whether or not to comply with any interim measures issued by the ECHR for the purposes of blocking a person's removal to Rwanda. Amendment 38 stipulates that in making such a decision, the Minister in question must consult with the Attorney General. Madam Chair, the Conservative psychodrama of the past 24 hours only goes to serve the old political adage. If a Prime Minister is incapable of managing his own party, he must be utterly incapable of running the country. And the resignation of not one but two deputy chairs last night, followed by a 60-strong rebellion, illustrated the level of utter incompetence at the heart of his administration. Now, you know what they say, losing one deputy chair could be down to misfortune. Losing two in one night is sheer carelessness. But at least we might get to see a bit more of the two of them on their GB News show, discussing days of yore while spoon-feeding each other with cold baked beans, which was my personal television highlight of 2023, and also explains quite a lot about the amount of hot air emanating from the benches opposite. I certainly hope to see and hear more of them in this election year. But in all seriousness, what on earth is going on? The country is looking on baffled that the Prime Minister can pay the Rwandan government £400 million for nothing, yet places such focus on strengthening our security cooperation with Europe to stop the boats in the first place, and has spent so very little time in terms of improving our broken public services or helping our struggling households during a cost of living crisis. They're perplexed that the Conservatives spend so many hours on a piece of legislation that isn't really even supposed to stop the boats. It's about the Prime Minister getting a single plane in the air with a handful of asylum seekers on it so he can say, look, I did it. I delivered the Rwanda plan and removed a few refugees. He thinks that the British people will deliver something to him on that basis. We are perplexed because this is not the behaviour and politics we can afford to expect from a British Prime Minister. These are not the serious policies that will fix our asylum system and make our country a better place. All the headline-chasing gimmicks over hard graft and getting a grip. This is not what the British public voted for. Indeed, nobody, not even the public, his own party, voted for him at all. Madam Chair, this plan is a con. This bill is a sham. I urge all members to get behind Labour's amendments in order to limit the damage, and I urge them to vote against the bill at third reading. It is unworkable, unaffordable and unlawful if we are to stop the Tory small boats chaos and end the expensive asylum use. of the hotels, which are costing £8 million a day, then this Conservative psychodrama needs to end. We need Labour's 5-point plan to end this chaos, starting with going after the criminal gangs upstream in a new security partnership with Europol. We need a government that puts country before party, and we need a general election this spring.
It may be helpful if I just clarify a few things. First of all, as well as if colleagues intend to make interventions, it's important that they have been there at the start of the speech. It's also important that they remain to the end of the speech if they have intervened. And I will, don't worry. I also intend to give priority to those who have got amendments down. I will come to others. In addition to the fact that we are discussing amendments, I should explain that because there is clause stand part, the debate can range slightly wider than would be normal, but it is not a third reading debate. There will be a third reading. There is an hour put aside for that, just in case colleagues preferred to speak at that stage. But I know Sir Jeremy Wright has an amendment. So I call
Thank you very much, Dame Rosie. And as you say, I do, in fact, two, and I want to focus my remarks on them. They're amendments 54 and 55. Dame Rosie, of course, we all understand the purpose of this bill is to allow this Parliament to designate Rwanda as a safe country so that people can be returned lawfully to it. But of course, to achieve that, you require a definition of what a safe country is. And the bill does that in clause 1, subclause 5, and particularly 1.5a, which describes a safe country as a country to which persons may be removed from the UK. So far, so good, Dame Rosie. It seems to me that's an essential part of the bill's inherent purpose. But the part of the subclause that concerns me and on which my amendment is focused is what it then goes on to say. So that in fact what 1.5a says is that a safe country is a country to which persons may be removed from the UK, and this is the bit that worries me, in compliance with all of the United Kingdom's obligations under international law that are relevant to the treatment in that country of persons who are removed there. In other words, it seems to me the bill is saying that the United Kingdom can, by means of this legislation, by saying that Rwanda is a safe country, also deem itself to be in compliance with a set of its international law responsibilities. And I don't, Dame Rosie, think that can be correct. Now, there are few in this House, I suspect, as familiar as I am with the vagaries and complexities of international law. But surely if international law means anything, it must mean that it does not lie in the hands of any individual nation state, even this one, to determine its own compliance with international law. And if it were otherwise, international law wouldn't really be international, and it certainly would serve no purpose in containing bad behaviour, as we sometimes ask it to do. I give way.
I'm very well aware, I work very closely with my honourable friend in a number of ways, as he knows. I'm very well aware that my honourable friend is a former Attorney General. And if he were right that it's not for the government or this House to determine whether measures are compliant, why on earth would they seek and get the Attorney General's advice on just that?
My right honourable friend knows that the Attorney General is consulted on a variety of different legal questions, both domestic and international. He wouldn't expect me to disclose any of the advice I have previously given, but I can tell him that the Attorney General does give advice on whether the government's actions may or may not be in compliance with international law. But the Attorney General, and I don't think the government, expects to be the ultimate arbiter of that question. The advice is given as to whether or not it is likely that this action would be in compliance with the law. And I'll come in a moment to what I think the bill and the government can properly do in relation to international law responsibilities, but it does seem to me that what it can't properly do is to set itself up as judge in its own cause on questions of international law. and this House would be wrong to pass a bill that suggested that it could. That's really where my amendments are focused. And as I say, there's a good practical reason why we should be nervous about this, because we do sometimes rely on international law in order to discharge our own policy intents and purposes. And not more than 48 hours ago, in this place, we were doing exactly that. We were saying that it's important to criticise the actions of the Houthis in the Red Sea because they contravene principles of international law. And we were saying too that we justify our own response to that because it is in accordance with the principles of international law. And quite right too. We would not have accepted the Houthis' unilateral declaration that they were in compliance with international law when they did what they did, nor should we have. And we wouldn't, of course, accept a Russian legislative act to say that the invasion of Ukraine by Russia was in compliance with Russia's international law responsibilities. Now, I make it clear, Dame Rosie, I'm not, of course, suggesting that what the government has in mind here is in any way comparable to those two examples. But it does seem to me that the point here is that to arrogate to yourself the right to declare your own compliance with international law runs the risk, first of all, of other states finding comfort in our example, and secondly, of undermining our own messages in other situations. And that, if I will in just a moment, that in my view makes this not just bad law, but also bad foreign policy. I give way.
I thank young gentleman for giving way, and I'm very pleased to hear what he has to say on the question of international law. Does he therefore share with me, and I am not as legally qualified as him, I would fully accept that, a concern that the government's own legal advice states that by stating that the bill is incompatible, it makes it compatible. Is that not worthy of the Mad March hare when it comes to consistency and standing up for the rule of law?
I suspect what the Honourable Lady is referring to is the statement of incompatibility at the beginning of the bill with the Convention on Human Rights and with the Human Rights Act. And of course, that provision is there for a reason. It's to allow the government, if it so chooses, to act in defiance of those responsibilities. That is perfectly proper, and I'm going to come on to explain why I think that is something the government can properly do. What I'm concerned about is something a little different, which is instead of saying, we don't think this is in compliance with international law, we're going to do it anyway, instead of that, saying, we think this is in compliance with international law, it's down to us to decide that, and we have so decided. That feels to me as though that is something that we could not and should not do. Now, Dame Rosie, it would be concerning enough, in my judgment, if this bill only tried to deem the UK's compliance with international law, but it also seems to say that we can deem Rwanda's compliance with international law. And that is set out, of course, in clause 1.5b, which goes on to say that for the purposes of this Act, a safe country includes, in particular, a country from which a person removed to that country will not be removed or sent to another country. Again, so far so good. That's essential, it seems to me, to do what the bill seeks to achieve. But it goes on to say, in contravention of any international law. And again, it cannot, it seems to me, lie in the hands of this Parliament to decide whether or not a country may be removed to another country in contravention of any international law. And it goes on in B2 to say that, again, a country would be a safe country in which any person who's seeking asylum or who's had an asylum determination will both have their claim determined and be treated in accordance with that country's obligations under international law. So what it seems to me the bill is seeking to do is to say, if we deem it so, not just is the UK in compliance with its international law responsibilities, but Rwanda is going to be as well. And that feels to me not valid and somewhat over-ambitious. I happily give way.
Whether my right honourable friend, who has great experience as former Attorney General, would agree with me that actually the deeming provisions under the Withdrawal Act creates another rather similar situation, because we deemed EU law to be UK law, and therefore on the analogies he's just given, he would argue, I imagine, I think he might even have been Attorney General at that time, actually did exactly the same sort of thing, although I am listening with great interest to the very more precise point he's making about this relationship with international obligations, on which I will speak later.
Very grateful to my honourable friend for his intervention. And I know, Dame Rosie, you would not want me to abuse the privilege that you've given us to range slightly more widely, to range quite that widely, so I won't. But he's right that I'm making a fairly precise point about what this language appears to me to say. And I stress, I don't think, in order to achieve the objectives the government has set in this legislation, with which I have some sympathy, though their methods make me nervous, and I make no bones about that, I do not think it is necessary to include this language. And I think, worse than unnecessary, it presents some dangers, which I don't think we need to present in order to achieve, as I say, the government's objectives. But look, I completely understand, and I suspect my right honourable and learned friend, the Minister, will tell me in a few moments or hours' time that I don't need to worry about any of this, and he may say that that is for two reasons. The first of those is he may say, well, the bill doesn't mean what I think it means. Well, you'll forgive me for saying this, Dame Rosie, but I'm getting increasingly troubled in this place that we answer points such as mine by saying, yeah, but it doesn't really mean that, and we don't really mean that by it. I think we have to be concerned as legislators with what the language we are passing into law actually says, not what we meant it to say. And I am concerned that what this language says is not, I'm sure, in accordance with what my right honourable friend wants to do or the government wants to do, but it might nonetheless have that effect or be taken by others to mean the things that I am concerned about. And so when it says what it thinks a safe country is, this bill, it seems to me it's potentially confusing two different things. One of them is deeming your own compliance with international law, which I don't think any country should be able to do. And the other is saying that Parliament resolves to do something even if it contravenes the UK's international law obligations, which, going back to the previous intervention, I do think the British Parliament can do, and we as a legislature can resolve to do if we so choose. We have to decide, of course, whether that is a wise and sensible thing to do, with all the ramifications it might bring, but as a matter of law, it seems to me that the UK Parliament can, if it wishes, pass a law to say, despite or irrespective of our international law responsibilities, this is nonetheless what we want to do. But that is not the same as deeming your own compliance with international law, which I worry this language almost certainly seems to do. And the point I make about the UK Parliament being able to do things, even when they contravene its international law responsibilities, is of course already in the bill, already reflected in the language of clause 1(4)b, which points out, and I quote, that the validity of an act is unaffected by international law. Well, quite right. So we can, if we so choose, deem a country as a safe country for the purposes of domestic decision-making, if we want to. But what I don't think we can or should do is to legislate to say we comply with our international law responsibilities when we do, and crucially, as I say, to achieve the objective of this bill, we do not need to. So the second reason, Dame Rosie, why the Minister may say I do not need to worry myself about all of this, is because he may say that domestic and international law exist on different planes, and this legislation is only targeted in any event at domestic authorities, so the bill couldn't, even if it chose to try, deem our compliance with international law in actual fact anyway. And I would agree with that. It is perfectly true that domestic law and international law operate on different planes, and it isn't likely, this bill, to determine any question of international law before any international tribunal. But if that is so, why include the language? If it doesn't have any meaningful legal effect, it doesn't serve any purpose, but what it may do, I fear, is send a damaging political signal to other states. So, Dame Rosie, it seems to me that the language I am concerned about, and which Amendments 54 and 55 would remove, is either offensive or it's OTOs. And in either respect, the bill will be better without it.
Joanna Cherry.
Dame Rosie, it's a pleasure to follow the honourable and learned gentleman, and I found myself in agreement with much of what he said, and I think he made his points very forcibly. I rise, Madam Chair, to speak to Amendments 32, 33, 34 and new Clause 4 in my name, and to Amendments 4 and 5 in the name of my honourable friend, the member for Glasgow North, and also to support those amendments in the name of my honourable friend, the member for Glasgow Central. I also want to make some comments about the clause stand part in relation to clauses 3 and 5 of the bill and the amendments that have been put forward, particularly by the Right Honourable Member for Newark, particularly in my capacity as Chair of the Joint Committee on Human Rights. But first of all, I want to turn to my amendments, which are about the impact of this bill in Scotland, and in which respect I'm speaking in a personal capacity. My amendments and those of my honourable friend for Glasgow North go to the extent of the bill, its extension to Scotland, and also to the date of its commencement in Scotland. Both of us seek to prevent this bill extending to Scotland, and in the event that we are not successful in doing that, my amendments seek to ensure that the bill will not extend to Scotland without the legislative consent of the Scottish Parliament, and that nothing in it will interfere with the supervisory jurisdiction of the Court of Session or its nobile officium, and I'll explain what that means a bit later. Madam Chair, we mustn't forget that the regime this bill seeks to impose, together with the Illegal Migration Act, is imposed on asylum seekers across the United Kingdom, not just those who arrive in small boats on the Kent coast. The UK government haven't forgotten that, and that's why they want this bill, with its far-reaching and unprecedented ouster clauses, to extend to Scotland. Accordingly, asylum seekers in Scotland looking to our courts for protection will find that the courts in Scotland have been emasculated in the same way as this bill emasculates the courts of England and Wales. Now, as well as having their jurisdiction ousted on certain matters of fact, as was debated yesterday, the Scottish courts will also find themselves unable to apply the Human Rights Act and unable to respect the United Kingdom's obligations under the European Convention of Human Rights and other international treaties. And I believe this constitutes a very serious intrusion on the jurisdiction of the Scottish courts, an unprecedented intrusion on the jurisdiction of the Scottish courts, and a very serious interference with the separation of powers between legislature, executive and judiciary. And I don't think this Parliament should be rubber stamping this bill at all, but particularly not in relation to Scotland. What this bill seeks to do in emasculating the jurisdiction of the Scottish courts in relation to asylum seekers is anathema to the Scottish constitutional tradition. People in Scotland don't want it. They didn't vote for it. In fact, actually, nobody in the UK voted for this because the policy wasn't in the government's manifesto. But you won't find it, in contrast to England and Wales, Madam Chair, you won't find any opinion polls carried out in Scotland which support this bill. Now, as the great Scottish judge, Lord President Cooper, noted in the famous case of McCormick against the Lord Advocate in 1953, and I quote, "The principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law. In Scotland, Madam Chair, it is the people who are sovereign, and that does make a difference to our view of how constitutionalism works and our views on the separation of powers. And it is of the essence of the Scottish constitutional tradition that executive power should not be unchecked. And this goes back in our history as far as the Declaration of Arbroath in 1320, when Scottish nobles asserting the sovereignty of the people of Scotland in a letter to the Pope told His Holiness that if the King of Scotland should ever seek to make Scots subject to the King of England again, they would kick him out and seek another king to defend him. So in Scotland, the sovereignty of the people is our guiding principle, not the sovereignty of the monarch, or indeed our own, or indeed this Parliament. So neither our Parliament nor this Parliament is sovereign, it is the people who are sovereign. Now, just turning to the jurisdiction of the Scottish courts, This Parliament, this Union Parliament, exists because of the Treaty of Union. Scotland has always had a separate legal system, and Article 19 of the Treaty of Union between Scotland and England protects that separate legal system, including its inherent supervisory jurisdiction, and including the nobile officium of the Court of Session, which is a power that the Court of Session in Scotland has to give remedies where otherwise there would be no remedy. And since the modern advent of devolution by virtue of the Scotland Act, the civil jurisdiction of the Scottish courts, including judicial review, has been a devolved matter and therefore one properly for Scotland's Parliament. So I believe that this bill is a grave intrusion on the civil jurisdiction of the Scottish courts, and that's the reason for my amendments. The Scottish Government is considering a legislative consent motion, and my Amendment 34 would ensure that this bill, when it becomes an act, would not come into force in Scotland without a legislative consent motion. And new Clause 4, which I'm putting forward, would ensure that notwithstanding, I like that, a nice notwithstanding clause. I hope honourable members on the other side who've been so excited about notwithstanding clauses will support my Scottish notwithstanding clause. A new Clause 4 says that notwithstanding anything in this bill, if it were to become an act, the supervisory jurisdiction and the nobile officium of the Court of Session would be preserved. And in that way, I hope to ensure that asylum seekers in Scotland will still have the protection of the courts in accordance with our constitutional tradition. Just to explain, the nobile officium of the Court of Session is a noble office or duty which Scotland's highest court has. It's a sort of extraordinary, equitable jurisdiction by virtue of which the court may, within limits, mitigate the strictness of the law and provide a legal remedy to people where otherwise none would exist. I will give way, yes.
Without prejudice to the content of what she's saying otherwise, could I just simply say in relation to the word notwithstanding, I'm extremely glad that the Scottish eagle has landed.
Certainly won't be supporting the other notwithstanding clauses in the bill, but I felt it was perhaps time we had a notwithstanding clause that benefited Scotland for a change. So my amendments, Madam Chair, they're designed to protect Scotland's courts and the Scottish constitutional tradition, and they're there to ensure that asylum seekers in Scotland might still enjoy the protection of the courts from the infringement of their fundamental rights. And that's what people in Scotland want, and that's been expressed repeatedly through the Scottish Parliament. So I am, of course, a Scottish MP and a member of the Scottish Bar, and I'm here to do what I can to protect Scotland and Scotland's legal system for the extraordinary attack which this bill constitutes on human rights and the rule of law. But, Madam Chair, I'm not a Scottish exceptionalist, and I recognise, as reflected in the House of Commons Library's excellent legal briefing on the bill, and indeed in the speech that preceded mine, that concerns about the impact of this bill on the rule of law and the Constitution are shared by many in England and indeed by many lawyers in England. And for every lawyer that has been cited by honourable members on the other side in favour of this bill and in favour of the draconian amendments to this bill, you will find two lawyers who disagree. And the library briefing, and it really is an excellent summary of the different legal views on this bill, the library briefing concludes, and I quote, "Tension between the sovereignty of Parliament to legislate and the role of the courts in enforcing the rule of law principle that executive bodies must exercise their powers within their statutory limits may be tempered by restraint on both sides. If either the courts or Parliament cease to exercise such restraint, significant constitutional uncertainty could result." Close quotes. And I believe that if we pass this bill, this Parliament will have ceased to exercise the restraint referred to there. It would be a major departure from such restraint. And I do believe, Madam Chair, that if this bill passes, I believe and I predict that we will see what might be an unprecedented constitutional challenge to an act of the British Parliament. I will give way.
The checks and balances which prevent arbitrary power. And she's right that in our constitutional settlement, that is central. But this is not the exercise of arbitrary power, because the bill and the amendments to it are quite specific about their provisions. So, for example, our separation from the international obligations that I know she holds so dear, is very specific in the amendments that are tabled by Honourable Newitt, specific to this particular measure, this legislation. This is not arbitrary, anything but.
What it does do, this bill, is it seeks to carve out a group of people coming to our country or within our country from the protections that the rest of us enjoy. And I think that history shows us that that sort of legislation can put a state on a pretty slippery slope. And that brings me to the arguments I want to make in relation to clause stand part for clause 3 and 5 of this bill. Now, the Joint Committee on Human Rights has not yet had the chance to complete legislative scrutiny of this bill, given the speed with which it has passed through the House. So we have not, as a committee, reached a concluded view on the bill. But before Christmas and before the second reading, a chair's briefing paper referring to the legal advice the committee had received was published, and it's extensively referred to in the excellent legal commentary on the bill published by the House of Commons Library. And it says this, inter alia, that the disapplication of the Human Rights Act in clause 3 of this bill is really very significant. Because, as I indicated a moment ago in my answer to the Right Honourable Gentleman, human rights are meant to offer a fundamental level of protection for every person on the basis of their humanity alone. And as our committee has noted in a previous report, if those protections are disapplied when they cause problems for a policy goal, they lose their fundamental and universal character. And that means that they lose the fundamental and universal character that characterises them. And this is arguably particularly the case when they are disapplied in respect of a particular group. And in this case, fundamental human rights are being disapplied in respect of migrants who come to the United Kingdom without prior permission. Now, bills that disapply parts of the Human Rights Act are not unprecedented under this current government, I'm sad to say. Both the Illegal Migration Act and the Victims and Prisoners Bill sought to disapply Section 3 of the Human Rights Act in respect of certain legislation. However, this bill seeks to disapply Section 6 of the Human Rights Act, and that's the obligation on public authorities to act compatibly with human rights. And that's never before been attempted, even by this government, and it represents a significant inroad into human rights protections. If we pass the bill with that clause there, it means effectively this Parliament is authorising public authorities to breach human rights. Now, that's an awful long way from what this Parliament intended when it passed the Human Rights Act and what the United Kingdom intended when it signed up to the Convention. Now, as we heard at some length yesterday, as a result of parliamentary sovereignty, breaching human rights, if we pass this bill, would be in accordance with our domestic law. But it would still violate the UK's obligations under the Convention, because we cannot unilaterally change what the Convention says. And also, as the Bingham Centre for the Rule of Law have noticed in their briefing on the bill, if we disapply the Human Rights Act in the manner proposed, we're also breaching Article 13 of the Convention, which entitles people to an effective remedy. Now, I'm afraid to say that the amendments in the name of the Right Honourable Member for Newark, who's no longer in his place, his amendments to Clause 3 would make the situation even worse. And his amendments 11 to 12 appear to extend the disapplication of the Human Rights Act to anything done under the Illegal Migration Act that relates to the removal of a person to Rwanda. And that could potentially mean that the detention of people awaiting being removed to Rwanda and their treatment prior to their removal would not be protected under the Human Rights Act. Is that what this Parliament really wants to legislate for? And additionally, as the Right Honourable Member for New York seeks to do, he wants to extend the clause to disapplying Section 4 of the Human Rights Act as well. Now, the clause as it presently stands does not disapply Section 4 of the Human Rights Act, and that means that it would, if it remains as it is, be open for a court in future to declare that this bill, when it becomes law, is not compatible with this convention. Now, with the convention, that would be by way of a declaration only. It wouldn't affect the ongoing function of the bill. It wouldn't mean that removals to Rwanda could be prevented or delayed, but it would mean that this Parliament and government would have to decide whether any changes to the law should be made. And if we amend the bill to disapply Section 4 of the Human Rights Act, again, that's something that has never been done before and something that would further oust the jurisdiction of our courts from saying to the government and the public what their view on the law's compatibility with human rights is. And finally, turning to Clause 5, stand part, I also believe that this bill shouldn't stand part of the bill. We've heard a lot today about honourable members on the other side of the House's concern about interim measures issued by the European Court of Human Rights. And the reality is this: no matter what this legislation ends up saying, it can only affect domestic law. In respect of the ECHR in particular, the UK will remain bound by the Convention as a matter of international law. And indeed, even if this government, God forbid, were to exercise the nuclear option to withdraw us from the Convention, thereby putting us into bed with Russia and Belarus, even if they were to do that, we would remain bound for a further 6 months after withdrawal takes place. And I hope they'll bear that in mind. So Clause 5 at the moment says that only a minister can decide whether to comply with interim measures, and the domestic courts should ignore them. It remains to be seen what a minister would do, but we all know that the Prime Minister has said repeatedly that he wouldn't let a foreign court, to use his words, prevent flights taking off, which indicates that interim measures may be ignored. Now, as I said in my intervention earlier on the Right Honourable Member for Newark, interim measures are made under part of the Court's Rules of Procedure 39. They don't form part of the text of the Convention ratified by the UK, but when we ratified that Convention, we signed up to the idea that the Court, the European Court of Human Rights, is the body that determines the meaning of the Convention, and it's held consistently since the case he mentioned in 2005 that failing to comply with interim measures amounts to a breach of Article 34. Madam Chair, interim measures are fundamental to any court. They are issued to protect the position of an individual while their legal rights are determined. All this fuss about people in their pyjamas in the middle of the night is just very silly. Judges in the United Kingdom, both in the English jurisdiction and the Scottish jurisdiction, are regularly got out of their beds in the middle of the night to issue injunctions in England, interim injunctions in England and interim interdicts in Scotland. It's a standard part of any legal system. And many of the concerns that the other side have expressed about these interim measures have now been addressed by the court in reforms which they are proposing. But any decision of a minister not to comply with the interim measure would therefore be inconsistent with our obligations under the ECHR. This means that Clause 5, if we let it stand part of the bill, will expressly authorise British government ministers to act in breach of international law. That is the reality. And I note that according to the Times newspaper, this is the advice reported to have been given to the government by the Attorney-General and the Minister, the Honourable Member from Mid Dorset and North Pool, when he was Solicitor General. That doesn't surprise me at all. It shouldn't surprise anyone, because any legal undergraduate would be able to tell you that. So insofar as Amendments 23 to 25 state that interim measures are not binding, that is inaccurate as a matter of law. And we must understand that we'll be putting the UK directly in conflict with our international legal obligations. So, Madam Chair, I realise I've taken up a little bit more time than I'd intended, but I hope the amendments I've spoken to and the clause stand part would go some way to ameliorating this bill, but certainly even if they were to be passed, I would be voting against it. Thank you.
Chair of the Justice Select Committee, Sir Robert Neal.
Thank you very much, Dame Rosie. It's a pleasure to follow the Honourable and Learned Lady Member for Edinburgh South West and my right Honourable and Learned friend, the Member for Kenilworth and Southam. Although I won't be supporting the Honourable and Learned Lady's amendments, I have great respect for the intellectual rigour which she brought to Scots law and its application here, and I say the same in relation to the points made by my right honourable and learned friend in relation to his amendments 54 and 55. And I do hope that the Minister will think seriously about how we deal with that issue, and I'm sure he will. But they are serious points which are raised, because in a nutshell, I too would agree with the proposition that whilst of course Parliament can legislate to do whatever it likes in domestic law, simple fact is you cannot legislate away international law obligations or treaty obligations, and it would be misleading to try and pretend otherwise. Can I then turn to the amendments moved by my right honourable friend, the member for Newark? And I'm sorry he's not in his place, because I have to say with every respect that I profoundly differ from his characterisation of pyjama injunctions by a foreign court, which I respectfully would argue is both inaccurate and rather unworthy. Because, as was observed by the Honourable and Learned Lady for Edinburgh South West, it's perfectly normal for interim injunctions to be done at difficult hours when the test for them is met. So we shouldn't say that as being unusual. There are arguments about the way the Rule 39 procedure in the Strasbourg Court works that can be legitimately made, but let's make it on the basis of an accurate construction of what it's about, rather than otherwise. Secondly, it is... let me just finish. Yes, I will actually, and then I'll get on.
Well, Terry, I have great respect for the argument he makes, and I do defer to his experience and knowledge on this. I'm interested genuinely in his view. He's eliding a judge in the UK issuing an injunction late at night in the event of what would be, in normal circumstances, an individual situation. Does he really think that it's comparable to describe, and that's in the same terms, the act of a court, which is genuinely in another country, a judge who is unknown, anonymous, who does not publish the rationale for their opinion, and in doing so calls a halt, with the support of the government, it must be said, to the policy of the British government enacting a law passed in Parliament? Surely there is a difference, both of degree and of nature, between the two cases.
I think the honourable friend needs to bear in mind, in fact, the application that was made to Strasbourg was an application about the circumstances of an individual case as well. So that's no different. There is a legitimate criticism, one that I've voiced in the past, about the procedure adopted in Strasbourg for these applications in two matters. Firstly, the anonymity of the judge, and secondly, the failure to state reasons. That wouldn't be acceptable from our point of view. But the answer is not then to throw out the whole of the judicial baby and treaty baby with the bathwater in that regard. It is, as is possible, thanks to the Brighton Declaration that was signed by my noble and learned friend, Lord Clerk of Nottingham, is possible to actually make reforms following dialogue between member states, the Council of Ministers and the judiciary of the court. And I'm pleased to say that after pressure from the United Kingdom, perfectly properly, the court has itself indicated it is going to consult on reforms to the procedure. And that can only be a good thing. So that's where I think the balanced position is as far as that's concerned. Secondly, of course, I'm not going to give way.
In fact, further than that, there are already proposed reforms that are going to come into place this year to the interim procedure that crucially will remove the anonymity provisions and also allow contracting parties like the UK to make the argument that, as I believe in this case, this is not an imminent risk of irreparable damage. We can fly people back from Rwanda, and that was the argument that we need to keep making.
My right honourable learned friend is entirely correct, and he and I probably would have very happily argued the UK's case in Strasbourg on those grounds. So let's be realistic then about what we're fighting against. It's a bit of an Aunt Sally with respect set up here, because actually things are already being steps are already being taken to deal with the objectionable matters of Rule 39s, but the principle of them is not of itself objectionable. And secondly, the characterisation of a foreign court is, with respect, not helpful in these circumstances, because it implies something alien. That's not the case in relation either to international law as a concept or to the court itself either. In fact, it happens to meet in a different place in the UK. It's inevitable because it's got to meet somewhere. But it's just bear in mind, not only was the UK one of the driving powers behind the creation of the convention in the first place, behind the court itself, and behind much of the jurisprudence of the court, the UK does actually have a shared ownership of the court, along with all the other member states. And that's demonstrated not just in the treaty, but in practical ways too. For example, the members of the Parliamentary Assembly of the Council of Europe, members of this House and the other place, have a role in the appointment of the judges of the court. My right honourable friend and member for Gainsborough and I served at one time on the subcommittee of the Assembly that dealt with that process. And I think we did so diligently. So there is an involvement in that process. A British judge always sits on the court, is a member of the court. Judge Tim Ike, the current judge, is a very distinguished international lawyer as well. We're very lucky to have him. Two of the recent registrars of the court, who run the administration of the court, have been British lawyers. British lawyers appear regularly in cases before the court. This is not an alien body. It's a court in which we have joint ownership. It's our court along with that of all the other member states of the Convention. And it's wrong to mischaracterise it as being that there's something which is therefore alien. Certainly, in all international matters, as my right honourable and learned friend said, it operates on a different plane. But the sort of the tone of a sort of alienness is, in respect, both inaccurate and somewhat offensive, and also unnecessary for the purposes of this bill anyway. Because that's the other point that I want to come to in relation to Rule 39. The amendments moved by my right honourable friend and member for Newark are OTOs. They're unnecessary, and frankly they make what is a difficult situation worse. Because as a matter of law, an interim measure under Rule 39 is an indication that is made to the government of the member state. It is not made to the courts of the member state. It's conveyed to the government of the member state concerned. And therefore it is for the members of the government of the member state, i.e. the ministers, to decide what to do about it. I personally take the view that you should be very loath indeed to ignore the findings of the court on an interim matter, and it does run the risk, as the right honourable, honourable learned lady rightly says, of placing you in breach of your international law obligation in that regard. But the truth is, it is a political decision which the ministers can take. So what the current, let me just finish this point. What the current bill, in its current formulation, states is actually no more than a statement of the law as it stands, and you probably don't need that clause in the bill. I'm not going to die in the ditch over that, because it's simply stating what is the law already. But equally, there's absolutely no need for the right honourable member for Newark's amendment, if you like, to put bells and whistles on OTOs, if I can put it that way. I'll give way to the right honourable member.
I'm loath to interrupt him as he's describing not so much the separation of powers, the desiccation of power, but on a specific point that he made about his reticence or reluctance not to abide by the advice from the court, and he said ministers could do that, but he wouldn't. Would he on that basis not have done what the noble Lord Cameron did as Prime Minister and resist the overtures from the court to give prisoners votes?
In fact, 2 points I make around that. I supported the noble Lord Cameron in that regard because it was a political decision there, and it's worth just looking in terms of the practical politics. Although we were for a period of time at variance with the court in that regard, no harm was done to the polity of the United Kingdom in that regard. No harm was done to the interests of the United Kingdom. No terrible international consequence flowed against us from it. I think the court got it wrong on that occasion, and one of the problems is that there isn't an appeal system within the Strasbourg court, so you have to wait until some future decision may go in a different way. And I think many of us take the view that in reality, the court as currently constituted in Strasbourg, perhaps less activist, if I might say, than its predecessors, might well have found differently in the prisoner voting case anyway. But the fact was, UK ministers took a decision and they did what was right in the UK. It was supported on all sides of the House, and no harm was done. So the idea that there is some terrible consequence will flow to the UK because of the existence of the ability to seek Rule 39 interim measures is just misplaced. I will.
Doesn't my friend reflect upon the fact that on this particular question of prisoner voting, which I did discuss with the noble Lord Cameron when he was Prime Minister at the time, that actually it was regarded by the Right Honourable Noble Lord, the Lord Clerk of Nottingham, I think it is, that it was, as he put it, that it was a particular political policy. I think those are the words he used. How would you describe the issue of illegal migration? Would you not regard that, if I may say, my honourable friend, as also a particular but very important political policy?
And that's why, as it happens, I will not vote against this bill, because although I have some misgivings, there is a legitimate concern that needs to be dealt with in relation to illegal boats. But the simple fact is that is not a reason for the blanket derogation, the blanket removal of ECHR protections that are proposed in the series of amendments. That's the difference in IRA 1, that sometimes there's a mixture of politics as well as law that arise in these matters. And I don't. But the point I make is that, frankly, if any government wants to take the political risk of ignoring an interim measure, it can, under our law as it stands. It happens that it actually did effectively in relation to prisoner voting, so it could now if it wanted to. I'm not going to advise on that, because I think one's got to be very wary not to come to views that aren't very often going to be fact-specific when individual decisions are made. That's why it's...
Give way.
Yeah.
I'm very grateful to our friend for giving way, and I don't want to prolong the discussion about prisoner voting, but rather like our right honourable friend for Stone, I remember having conversations about this subject inside government. I think it would be fairer, would it not, to describe the situation that the UK didn't at any point refuse to comply with the judgment.
Yeah.
It is perhaps a more Augustinian approach to compliance that we've adopted. We just haven't quite got around to it yet.
I think that's right. As I recall it, the UK government put a motion before this House, which the House rejected. So you could have had a perfectly legitimate legal argument that we had taken steps to comply, and Parliament, as it was entitled to, had done otherwise. And that's why the whole of this argument with my right honourable friends for Newark's amendments is that Aunt Sally is really a complete red herring to the real issues that we are concerned with, and why these amendments add nothing to the bill, and I urge honourable members on both sides of the House to reject them. The final thing that I just wanted to deal with, Dame Rosie, if I may, was this. I had misgivings about this bill, and I mentioned that, I spoke about that at second reading. I said that it stayed acceptable, just, and I will continue to maintain that position. My right honourable friend and member for Newark quoted the noble Lord Sandhurst, very distinguished lawyer in the other place, a personal friend of mine, I should say. I ought to say Lord Sandhurst, noble Lord Sandhurst, is chair of the research committee of the Society of Conservative Lawyers. I happen to chair the executive committee of the Society. Lord Sandhurst and Harry Gillow, a fellow member of the Society, published a very useful pamphlet around the impact of this bill, and they updated it in the light of the amendments. And their conclusion with respect was this: the bill goes as far as is reasonably possible without risking collapse of the Rwanda scheme as a whole. End quotes. They go on to say, and I quote, the bill as drafted represents the best chance of success for the Migration and Economic Development Partnership with Rwanda scheme. End quotes. So they actually are on the same side of the argument I am, that the amendments proposed by the Right Honourable Member for Newark take it over the line of being able to deliver the economic migration, the Migration and Economic Development Partnership scheme. They risk collapsing the whole scheme. It was ironic that my right honourable friend, the member for Newark, talked about blowing up the bill. The truth is, his amendments will blow up the deal with Rwanda, because Rwanda has made it abundantly clear that anything that clearly breaches international law will be unacceptable to them, and they would withdraw from the amendment. So not only are the amendments proposed legally unsound and OTOs, they're actually ridiculously bad politics with respect as well, because they would actually defeat the object of those who do want to see people being moved to Rwanda to deter the boats. So on both legal and political grounds, I urge the House to reject these amendments and leave things as they stand.
Gavin Robinson.
Rosie, thank you very much indeed for calling me in this committee stage, and it is a pleasure to follow the honourable learned gentleman, the chair of the Justice Committee, and he did say that at times you will see a collision between, or an interface with, politics and the law, and I hope what arises from my contribution is that there's a third element to that as well, and that's principle. And throughout the passage of this bill, and indeed some of the precursors to it, we have advanced a number of principled positions, one of which challenges the basis of the legal aspiration contained within the bill. Another will rightly challenge that it doesn't matter how hard you suggest this is the most robust piece of legislation. If it doesn't do what it's intended to do, it isn't going to work. And that is an unprincipled place to be with the British electorate. To suggest that all these steps are in earnest and have some virtue, knowing that they are inconsistent and will not work. I made those points during the Nationality and Borders Bill, and the ministerial bench at that time told me I was entirely wrong, and that there was no need to strengthen the provisions, and that the bill would do what they said it would do. And now I hear through stages of this bill, at this committee stage, the very same people who occupied the front bench adopting the same arguments that we deployed to the Nationality and Borders Bill. I still find it thoroughly inconsistent that our government have reached a position that they have an agreement with Rwanda that involves our country accepting refugees from Rwanda, a country capable of producing refugees, and yet we are considering that in the context of the Safety of Rwanda Bill. It is incongruous to me how a country deemed safe by this Parliament is capable of producing refugees from that very same country. And I haven't heard a robust argument to the contrary as to how that is not an inconsistent position. Of course,
I'm very grateful to the honourable gentleman for giving me a chance to put him right, because the example is, for example, the transit mechanism that is in place, where Rwanda is already hosting refugees from Libya, for example. Rwanda, in its generosity and safety, hosting hundreds of thousands of refugees. That's how.
Rosie, and if the Minister is prepared to say that the only refugees that can come to the United Kingdom from Rwanda are those that have been produced as refugees from other countries, that is an absolutely fair point to make. But I don't think that's the point he's making. I don't think it is, and I'm very happy to let him intervene again, but I just genuinely don't think that is the point he's making. And the point I am making, that is entirely inconsistent, on one hand to say we're to accept refugees from a country, and on the other deem that country as safe, but I accept our right to do it. And I don't quibble with the government's aspiration that Rwanda is a safe country. I don't quibble with it. I just say there's a complete juxtaposition between, on one hand, saying it's safe, and on the other, accepting refugees from that very same country. And I make the point, Dame Rosie, and I recognise the nature of this committee stage, but I do make the point again to the Shadow Minister. It's not about his valiant opposition at committee stage or at third reading or what passed at second reading. It's about the Labour Party's opposition, which will fold, I have no doubt, fold on this bill in the other place. The political choice will be the Labour Party's. There is no second session or additional session of this Parliament. There will be no Parliament Act available to pass the Rwanda bill, and it's going to be tortured in the other place. The bill will be tortured in the other place. And the only reason, or the only way it will emerge, emanate from this Parliament, is if a political calculation is made by the Labour Party that there's too much political cost in opposition to the bill, and they draw stumps and allow it to pass. And I reiterate that point. I'm saying it very clearly now, and I suspect in a number of months' time, this point that is being ignored today will become quite acute within our political discourse.
I thank the honourable gentleman for giving way, and I apologise then. I perhaps hadn't fully understood his point in his question to me when I was making my remarks. It was specifically about the other place. What I would say to him is that Labour members of the other place will give this bill the scrutiny that it deserves, will hold the government to account. And if you take, for example, the illegal migration bill, which ended up going through, got royal assent, in spite of very severe and serious reservations, but we, of course, in the other place, recognise that we have the duty to scrutinise, but also also we are responsible for ensuring the proper functioning of Parliament across the board. So I would say to him that I don't think this bill will be treated in any way differently to any other piece of legislation that would go to the other place, at least from the point of view of my colleagues there.
Tim Rose, I'm very grateful to accept that intervention, and the Shadow Minister has made his point and I have made my point, but I suspect at that point you will find as much safety in the point that has just been made as those that stand bullishly and say this is the strongest, most robust piece of legislation ever, irrespective of whether it works. I just make that and put it on the record. Madam Deputy Speaker, as you will be aware from second reading considerations, we do have concerns about the operability of this bill in light of the UK's withdrawal from the European Union and the legislative framework that surrounds that relationship. And that's why you'll see in new clause 3, to speak directly to our amendment, you will see a notwithstanding clause, and I know they've had some humour around notwithstanding clauses from the Honourable Lady from Edinburgh South, or Edinburgh South West. But that notwithstanding clause is there because we are concerned, in contradiction of the government's position, that the claims that have been made in this House and the position that the government have deployed is not sustainable legally. And this amendment proposed by us, the notwithstanding Section 7A of the withdrawal agreement, the European Union withdrawal agreement 2018 amended 2020, is important from a principle perspective as a unionist, from a practical perspective, as a member of this Parliament who believes that our immigration policy applies equally across the United Kingdom. It always has applied equally across the United Kingdom. And the concern is that government is blindly ignoring our concerns and allowing a situation to develop that will cause a fracture in the immigration policy which up until this point has applied equally across the United Kingdom. Now, I have engaged with the Minister on this, and I'm very grateful not only for him making the time available, but the courtesy with which he always approaches these issues. Colleagues will recall that we raised this issue in second reading, and the Minister gave a commitment, and fundamentally the commitment that the Minister gave comes in two parts. One, that government has never accepted that the rights chapter of the Belfast Agreement engages immigration policy. And furthermore, the government have in the past robustly defended the position that the rights chapter of the Belfast Agreement does not engage immigration policy, and have won. They have advanced that argument in court and have won. And that argument that the government is putting forward is predicated on Article 2 of the Withdrawal Agreement, that there be no diminution of rights for the people of Northern Ireland whenever the United Kingdom leaves the European Union. And as a consequence, given the rights chapter, they say does not apply to immigration, there is no diminution of rights, so this is not captured by Article 2. Now, we engage with the government, and I'm not going to take an intervention at this stage because there's a few elements to this that I want to get out clearly and cleanly, and then I'm happy to take an intervention once I have done so. But the Minister put forward his point. We exchanged positions at second reading about the potential of an updated legal note, and I have to say that in all candour the Minister has been forthcoming, government have been forthcoming with addressing this point to us more formally. On Article 2 of the European Union Withdrawal Act alone, not Article 7 of the European Union Withdrawal Act. And Dame Rosie, let's just be clear about this. We as a national parliament are considering on a national basis our national immigration policy. And our amendment is intended to elicit the government, eyes wide open, choose to ignore us at this point, choose to dismiss the concerns that have been raised, and ultimately leave it to the courts to decide and for the judiciary to determine if there's a cause for concern or not, or take the very simple step on immigration grounds alone to disapply Article 7A, Section 7A of the withdrawal agreement. That's the choice. I shared with the Minister yesterday, and I share with the House today, that there was a High Court case in Belfast. There was a judicial review in the matter of an application for Amam and Jasson. And it's interesting reading, and I share it with the House at committee stage this afternoon. Paragraph 94 of that judgment says very clearly the combined effect of Section 7A of the EU Withdrawal Act 2018 and Article 2 of the Protocol limits the effects of Section 5, 4 and 5 of the European Union Withdrawal Act, Schedule 1 and Paragraph 3 of the same Act, which restrict the use to which the Charter of Fundamental Rights and the EU general principles may be relied upon after the EU's exit. This means that the Charter of the Fundamental Rights remains enforceable in Northern Ireland and falls within the ambit of Article 2.1 of the Protocol. And contained within the Charter of Fundamental Rights is Article 18, the right to asylum. So everything we've seen from government has engaged the discussion around the rights chapter of the Belfast Agreement. It has not engaged the consideration that was resolved and shared in paragraph 94 of this Belfast High Court judgment, which has a completely separate legal construction as to how the government's ambition around this Rwanda Bill will not apply to Northern Ireland. Now, the Minister said clearly on the floor of the House the bill will apply in full in Northern Ireland in the same way as it does in the rest of the United Kingdom. New Clause 3 is our attempt on the first stage for the government to accept it and rule out the concerns that have been raised, and if they should not do so, then articulate at least their intention, their position, what they believe to be the case, why they believe this interpretation and the judgment from Belfast is wrong. And I raise these issues on a number of levels, Madam Deputy Speaker. As a parliamentary spokesperson on Home Affairs and somebody who's engaged on these immigration issues for a while, as somebody who's voted against previous attempts because I don't believe that they are the right approach, somebody who has voted against this bill at second reading because I still don't believe it is the right approach, but a representative for Belfast, which, believe it or not, and I say this with no alarm or no theatrics, but as a matter of record, that the House of Commons library figures in September pointed that Belfast has the second highest number of asylum seekers housed within our city across the entire United Kingdom. 78 per every 10,000 within the city's population. And so I'm not being alarmist about that. I'm not going to over-egg it. I'm just making the point that these are important issues, that the unity of our immigration system is an important issue. The protection of our borders is an important issue on immigration terms, and heavens knows we've had enough difficulty around the creation of a trade border in the Irish Sea that we are having to deal with, that we cannot casually or mistakenly or through misplaced hope walk ourselves into the creation of an immigration sea border in the Irish Sea because government fails to accept the strength of feeling on this issue, the cause for concern surrounding it, the legal and judicial opinion that has been given that leans into it. This is our opportunity to put it right, and I think it is an opportunity that we should take. Now, Dame Rosie, I'm about to sit down, but I did, in fairness, indicate to the Honourable Lady that I would allow her, and I mean no discourtesy, so I shall.
I thank you, gentleman. And I appreciate the case that he's making. My concern is that my reading of the Angerson judgment, and I went and looked it up after he and I had talked about it, is it says that both the applicant and the respondent agree that the rights, safeguards and equality of opportunity enshrined in Strand 3 of the Good Friday Agreement do not exclude asylum seekers. So the Home Office that brought the case accepts that the Good Friday Agreement extends to refugees in Northern Ireland, and yet with this piece of legislation they are seeking to exempt them from those rights and therefore undermine the Good Friday Agreement. I just wanted to clarify my reading of the ruling that he mentioned.
Look, she's entirely right in the quote that she has shared, Dame Rosie. It is fair to say that the government won that case. Therefore, we didn't see, nor indeed did the government really have any rationale for taking forward an appeal to defend some of the points that they may well have chosen to defend. But she highlights a frailty in that position. if the Home Office were accepting of a position that they have defended in other cases, that the Rights Chapter is not engaged. That is a frailty of the government's position, and that is why, in fairness, the Honourable Lady has her own amendment down, which isn't as fatal as ours in the notwithstanding provisions, but at least is asking government not to proceed with this bill until they are in a firm position to publish a position, and this House has agreed that that is the basis upon which we proceed. I've been in this place now for 8.5, almost 9 years. There are many occasions when this House has agreed to proceed in the face of what I believe to be well-grounded, politically supported and principled decisions. So it's not an amendment that I take comfort from, but I look very much forward to hearing what the Minister has to say, given the day that this is and the potential for third reading this evening. Dame Rosie, thank you.
Sir Robert Buckland.
Thank you, Madam Deputy Speaker. I spoke yesterday to the amendments that stood in my name that are potentially subject to division later, so I won't trouble the House on that. The amendment today that stands in my name relates to an amendment to Clause 9, which preserves a small element of Clause 1, namely the definition of safe country. I listened very carefully to the reasoned arguments of my right honourable and learned friend, the member for Kenilworth and Southam, who I think is in a similar position to me, except he is taking exception to parts of Clause 1 that I want to retain. I'd rather get rid of the rest of Clause 1 because I think it's bad lawmaking, but I'll come back to that in a moment. And I think I might have an answer for his sensible questioning of why it is that in the definition of safe country we see in subclause 5b2 a reference to that country's obligation under international law, otherwise the other country's obligation. I think it's simple. It has to flow because unlike the understanding of many people about this scheme, this is not the offshoring of UK processing. This is the wholesale handing to another country of the determination of applications. And that's why I think it's in there. Yeah. And that's the answer, I think, that hopefully gives him some satisfaction, which is why, on consideration of my amendment, I decided to retain the entirety of Clause 5 in my amendment, which would put it into the interpretive clauses towards the back end of the bill. Now, that was the only part of Clause 1 that I could see had any function whatsoever. Dame Rose, I'll give way.
Extremely grateful to him for giving way, and I understand the argument he's making, and I'm not going to be dogmatic about the approach that I set out earlier, but isn't there a danger if we retain the language he's referring to? We open up another channel of legal challenge, which is exactly what the government's seeking to avoid, because if the question becomes, is Rwanda in compliance with its international law responsibilities? That's something else that someone may choose to argue if they wish to resist their transfer to Rwanda.
My right honourable friend is absolutely right. I think I've said outside this chamber that the principle less is more when it comes to the passage of statute is not something that is fundamentally conservative, but it's also fundamental to good lawmaking. And although this bill doesn't weigh in at a very heavy number of clauses, I think it's a mere 10, I do think that as parliamentarians we have a continuing duty, Dame Rosie, to demonstrate economy. And I think any clause, in this case Clause 1, that is subtitled Introduction, should give us all pause for thought, if not breaking out into a cold sweat. Because it seems to me that the language in all those clauses up to Clause 5 and then Clause 6 is really the place, it's better it belongs in a white paper or in an accompanying policy document. We know what the purpose of the bill is. We've read the treaty. We've read the policy document. Most of us will have read the policy document that accompanied the publication of this bill. That's where this language belongs, Dame Rosie, not on the face of a bill. Not just because I have a tidy and ordered mind, well, I try to have a tidy and ordered mind, but the very point that my right honourable learned friend makes. The more words you put into legislation, the more opportunity you give for their litigation and their justiciability and the arguments that will then go before the court about fundamental issues at a high level that really should not be, in my view, the province of litigation. You know, it's for the contracting parties of a treaty to sign the document, to agree its terms, and then for the treaty to take place, to come into force either directly, as in the case of Rwanda, or in our dualist system via the Constitutional Reform and Governments Act, the CRAG procedure that is ongoing, which will bring the treaty into force. So I've got to say to my right honourable and learned friend, who I have great esteem for, why is our journey really necessary, to use one of my favourite wartime adages? In my view, Clause 1, I think, needs to go, save for the retention of Clause 5, which is why, although it will be a stand-part vote anyway, I tabled a particular amendment just to emphasise my extreme distaste for Clause 1. And also a distaste based upon the fear that this somehow becomes the norm, that we start to see legislation of this nature proliferate. Start with Clause 2. That's what the bill's all about, the safety of the Republic of Rwanda. That's where it should begin. Dame Rosie, it's very clear what Clause 2 says, and I spoke to it yesterday. Now, Clause 3. Now, that throws up a series of interesting questions. I'm not a particular fan, may I say, Dame Rosie, of Section 3 of the Human Rights Act. Never liked the read-down provisions. I think it draws the justices and the Supreme Court and the Court of Appeal, the Supreme Court in particular, into a province where they are almost acting as a constitutional court. We've seen it happen. The read-down provisions where judges, in effect, pass and reinterpret the will of Parliament is a very sticky and dangerous place for the court to go down. I don't like it. And had I had the opportunity, had we done what we said we were going to do in the manifesto, which I helped write, we would have updated the Human Rights Act by now, and who knows, we could have got rid of Section 3, and we wouldn't need to be referring to it in this ad hoc way in this bill. It was a horrible echo of that Bill of Rights, Dame Rosie, which happily never saw the light. We didn't have a second reading of that, thank goodness. And perhaps some of what I'm saying now in the context of these amendments and the stand-part debates are an echo of my deep distaste for aspects of that failed legislation. So why have we got Clause 3 in the bill? Well, I can see what the government wants to do. They want to avoid arguments relating to the Human Rights Act. I'm afraid they can't get out of jail. Because what will happen is that as people have an individual right to petition to Strasbourg anyway, we're in effect sending the arguments to that so-called foreign court. I entirely agree with my honourable friend, the member for Bromley and Chislehurst, court which we helped set up and have a direct ownership of. We send the arguments directly to there. And of course the danger of allowing petitions to go to Strasbourg without any airing of these arguments in domestic courts is that we're really not giving that evidence, that margin of appreciation evidence that is so crucial for the Strasbourg court. Because, you know, again, Dame Rosie, I do get frustrated by inelegant and inaccurate comparisons between the Luxembourg Court, the Court of Justice of the European Union, and the Strasbourg Court. The Strasbourg Court is a very different place. We have a much wider margin of appreciation, a much bigger discretion, a much more room in which to make arguments of interpretation and context, and indeed political context as well, about the way in which we do things in this country. And perhaps it's no coincidence that the number of times the United Kingdom is found in breach of the Convention is vanishingly small. And we've heard about prisoner rights. More cases, anybody? Abu Qatada. You might remember that. This is Abu Qatada case is the one that's on all fours with what we're dealing with here. We solved the problem by making sure that Jordan actually had a fair trial system. And I think, if I'm right, I think Abu Qatada was tried. He was acquitted in Jordan. But, you know, the point was made, and I think this is the point on all fours with this bill, that if you're going to rely on the processes of another country, then getting them right in order to be compliant seems to be the best way forward, which is why the government treaty approach, I think, is to be commended. So, look, Clause 3 No, I don't see the need for it. Get rid of it. You're going to end up with these arguments whether you like it or not. Now, clause 5. Well, again, another clause that, in the words of my honourable friends, is just unnecessary. I do not see how interim measures, first of all, equate in any way to the binding nature of final judgments, which Article 46 of the Convention, of course, draws us to, and indeed anything different from the approach that we take to domestic injunctions, interim injunctions in domestic cases that High Court judges, County Court judges, judges of all shapes and sizes will be enjoined to create or refuse on ex parte or inter partes applications. And it is important, I think, in this context about the debate of interim measures, to pray and aid the work that has been done in the plenary sessions of the Court of the European Court of Human Rights last year, where already the rules will be changed, and these rules are going to come into effect in 2024. May I ask my right honourable learned friend to work with colleagues in the Law Officers Department, his former department, and indeed the Lord Chancellor, to make sure that the Council of Europe, and indeed rather the plenary sessions of the court, actually get on with implementing these changes, because it seems to me that the changes to interim measures are really important. First of all, the limiting of the granting of interim measures to exceptional circumstances. Those are not the words at the moment that exist in the definition of Rule 39. That, at a stroke, changes the ballgame, in my view. And secondly, the end to anonymity for judges, which is a proposal that will be enacted. And finally, importantly, the opportunity for parties to the proceedings to request the court to reconsider its decision. So we will, the United Kingdom, will have an opportunity to say, no, there's no imminent risk of irreparable damage here. We can fly people back from Rwanda if there's a problem. And in any event, because of the measures we're taking in this Act, we're not going to be sending people who are vulnerable or at risk because they might be terminally ill or pregnant or whatever it might be, or some serious condition, to Rwanda in the first place. We've got the arguments, Dame Rosie, to deal with Rule 39, in my view, and we should have the confidence, the self-confidence and the ability to make our case. And these reforms to Rule 39, I think, will be significant. I'm delighted to have followed the Honourable Gentleman Member for East Belfast, who I think made a very thoughtful contribution. He and I have had some differences of opinion about things in recent days, but he always couches his arguments in a respectful way, and for that I thank him. And today, I'll give way before I develop the yes, I will give way.
It's grateful to my right honourable friend. Two things. First of all, just quickly, does he understand that there are those who argue that these Rule 39 indications are actually, or the way in which they're being used by the Strasbourg court, are not binding? Has he heard that argument, and does he agree with it or not? And then the second thing is with regard to the question of how people react to the manner in which it's being done. Does he think that the way in which it is being done, given the reforms that are being proposed, does he speak with authority? Not that he hasn't got his own authority, but can he quote to us any specific document or demonstration which shows that actually the whole thing is now more or less sewn up?
Well, I'm very grateful to my honourable friend. I do have sources which I was looking at in terms of research for the speech today. I will send him the links that I have to the web pages in the European Court, which deal with several meetings that were held, I think, in the summer and in November of last year, where these proposals were agreed, and that now the question is implementation in 2024. I think they have not been specific as to precisely when these reforms are going to be brought in. I think, therefore, now now is our opportunity, not just as a parliament but as a government, together with other member states, to say, look, this is welcome, can you please bring them in, and hopefully bring them in a way that dovetails with the eventual coming into force of these provisions. Yep. So that's an important point that I think he makes well, and I will certainly send that information to him. With regard to the question of binding nature, I think that it's tempting. First of all, I made the point that these are not final judgments, so they're not binding in the sense that Article 46 bites, and therefore we have a prisoner voting scenario. Yeah. However, procedurally, I do think they have to be abided by, bearing in mind the fact that, as a matter of procedure in our own domestic courts, if an injunction is passed, then it would be potentially a contempt of that court for any party to those proceedings to do something that would in effect defeat the injunction. And he'll know exactly, for example, an injunction perhaps freezing an asset, or the injunction preventing the removal of a particular asset from the jurisdiction. Clearly, doing that would frustrate the whole purpose of litigation and would be contempt of court. So I think he gets the point. And that's why I think that it is not necessary to add Clause 5. I think we all know the arguments. And if we do add Clause 5, we start getting ourselves into the unfortunate consequences of then having to consider the Ministerial Code, the Civil Service Code. I agree with my honourable friend from Stone, by the way. I took the view at the time of the United Kingdom Internal Markets Act that the drafting of legislation, Part 3, which never, of course, became law, was not a breach of the Ministerial Code, it wasn't a breach of the Civil Service Code. It was entirely in order, and we were able to do that. And that's where I parted company with my good friend Sir Jonathan Jones, the former Treasury Secretary. I didn't agree with him about that. Having said that, and I know he would approve of that, but having said that, I would say this about Part 3 of UKIM, and there are other parts of Part 3 that we need to bring forward, by the way, in terms of legislation to help colleagues like my honourable friend for Belfast East, who nods sagely from a sedentary position. We need to do that. We brought forward that legislation, and indeed the Protocol Act, as a way of leveraging the negotiations, and we were successful. We managed to sort out through the joint committee between, it was then Michael Gove, who, my honourable friend, right on from the member for Surrey Heath, and indeed Maris Sefcovic, who came to a conclusion in the joint committee before on the protocol, and then of course on the Protocol Act itself we have the Windsor Framework. Now, people with different views about that, but the point is that legislation was not necessary. And that's why I say, in all candour, to my right honourable and friend, now we are using this legislation not as a way to leverage negotiation, but as a direct enactment of policy. And that's why we have to be very careful about this. And to come to the points made by the honourable gentleman for Belfast East, and then in the intervention by the honourable lady for Walthamstow, we can't ignore the Northern Ireland dimension on this. We just can't. And I think we've seen, two very good and nuanced arguments. First of all, about the interaction between the Charter of Fundamental Rights of the EU and the law of Northern Ireland, and then the position of the European Convention itself, and the centrality of that convention to the Good Friday Belfast Agreement, which I think we all agree is a fact. However, we whatever our views might be about that. To come back to the point about the EU dimension, the Supreme Court was very clear in its judgment about the Rwandan applications relating to cases before it, that there was no role for retained EU law. That was very clear. That's what the court said. The Act was very clear that retained EU law no longer applied to the Procedures Directive, which was the particular directive that we were talking about. However, I think the honourable gentleman is right to sound the alarm bells to make sure that inadvertently we do not end up in a position where our immigration law is divided or complicated by the fact the EU law factor, which undeniably is an issue with regard to the law of Northern Ireland. I'll give way to it.
For the contribution that he's making, Dame Rosie. But he would accept, of course, that the arguments around the particularities of Northern Ireland, or should an application come from Northern Ireland, they weren't considered by the Supreme Court in detail, and that is precisely why I'm not saying I'm right, but for as long as we have an undetermined position, and we have a juxtaposed position between the government on one hand and some advocates in Northern Ireland on the other, we need to get it settled, and we need to be sure about the position. That's my point.
And I think he makes a very powerful point. I hope in the other place that is taken up as well. And I would certainly, in my role as chair of the committee, want to discuss that further with him and indeed with ministers either in the Home Office or indeed via the Northern Ireland, or probably directly to the Home Office, I think, would be the best way forward. And actually that opens up the point made by the Honourable and Learned Lady Member for Edinburgh South West about the interaction of Scots law with all of this. Now, she's not wrong when she says and reminds us of the fact that Scots law does look at parliamentary sovereignty in a different way from the law of England and Wales. That, I'm afraid, is something we cannot get around. However, I would qualify her remarks in this way by saying that I think that is overcome by the fact that we have a United Kingdom Supreme Court, which, of course, within its body will have, and does at the moment, in the form of the President and Vice President, two very, very distinguished Scots lawyers who understand these principles deeply, and at any time in the composition of that court will have senior Scots lawyers present. And it is the very existence of that court, indeed a senior judge from Northern Ireland as well, Lord Stevens. That is the whole function of the Supreme Court, where it can bring together the slightly differing concepts of constitutional law that undoubtedly exist in our jurisdictions and strike the right balance, a balance that is based upon restraint. We come back to that word again. I'm not going to labour the point that I made yesterday, Dame Rosie, but my honourable friend knows that he is walking a tightrope here when it comes to getting this legislation right, and that anything that smacks of a lack of restraint, and I'm afraid the amendments, tabled by my honourable friends, and I've said, I think, obliging things yesterday, and I will repeat them today, do not follow that sense of restraint, do not follow that sense of balance. And it's not just the risk of an imbalance between the courts of England and Wales and this Parliament, but an imbalance between the differing jurisdictions of the United Kingdom. And that should cause us all pause for thought, particularly those of us who are deeply committed to our union and who believe in this United Kingdom. And I'm not saying my honourable friends are trying to do something to deliberately undermine that, of course I'm not, but I'm just sounding a word of warning here, that in treading too heavily down this path of exceptionalism, in going too far in normalising what were the exceptional circumstances of withdrawal from the EU. And I should know that because I sat on that front bench making the case for many of the provisions within the EU Withdrawal Act that are cited by my honourable friend, the member for Stone and others. Those are exceptional times. This, I know, is an exceptional global challenge. But before I conclude my remarks, I'll simply say this. We need to tread carefully. If we don't, then what we do is, in trying to deal with an external problem, we create internal constitutional and legal problems of our own that I don't think any self-respecting Conservative government would want to do, and any self-respecting Parliament would want to follow. And for those reasons, I would urge honourable and right honourable members to reject many of the amendments that I think complicate this bill, and to follow the maxim that less is more.
Stella Creasy.
Thank you, Madam Chair. It's a pleasure to follow the Honourable Gentleman from Swindon, and indeed many of the colleagues that have sat next to him, who have brought an immense level of legal expertise to their concerns about this legislation. Let me try to offer something different than as somebody who is not legally qualified, a lay person's view or perspective about what this legislation is doing, and in particular why I have tabled and speak to Amendment 9, but obviously I support the amendments in the name of my front bench colleagues. This is actually not, for me, about the R of refugees or even the R of Rwanda. It's about the R of rights, and the rights that we enjoy that protect those freedoms and liberties to which so many of us fight for, are passionate about, and believe are intrinsic to a good life. This piece of legislation that the government has stated itself is a clear statement of the Parliament's view that Rwanda is safe, notwithstanding all specified domestic legislation and the common law and any alternative interpretation of international law, including customary international law. Now, for those of us who are not qualified, the word notwithstanding there is doing an awful lot of work to justify the diminution of rights for people in our country, and the concept that somehow international law does not protect us. And so much of the anger that we have heard, the concept, the idea of a foreign court, has come from it being about the European Court of Human Rights, that it is an affront to our democracy that this organisation is part of protecting those rights, those liberties, those freedoms on which we depend. How dare Winston Churchill sign us up to such a thing? How dare he believe that working with other countries was the way in which we protected those rights? As he said, in the centre of our movement stands the idea of a Charter of Human Rights, guarded by freedom and sustained by law. The scoundrel. What sort of rights was he trying to protect? What sort of abuses by the state did he dare to think we might need a court to uphold for us? The right to family life? A travesty, surely. The right to privacy? I mean, goodness me, what a terrible thing to be concerned about. The right to freedom from torture, or the right to liberty, or even the right to freedom of thought? Well, no wonder we need to look at all of this again. How terrible those things must sound to those of us who are not legally qualified, who cannot see the rub there. Let me try and think through a real-world example, perhaps, Madam Chair, of why those rights might be upheld by a third party. One could think of somebody, say a member of this House, who didn't have the respect and courtesy for other people speaking in this debate to even stay and listen to them shortly after he had spoken. Somebody who thought the rules did not apply to him, that the treatment of other people was not something that mattered, who perhaps was far too busy worrying about his social media account. Rightly so, Madam Chair would want to hold him to account. Goodness, many of us would think he might need legal representation for what could happen next. He would want his day in court. Oh, he might not want to be in the chamber when we were talking about those very issues. He might certainly be concerned about the idea of a judge and jury existing in the same person. The very principles that led to setting up the European Court of Human Rights are ones that we all feel every single day, because the Court of Human Rights does not just defend those basic things like a right to family life or the right to privacy. It also defends a process by which those rights are upheld. But even if Madam Chair wanted to take somebody to task, they might at least be entitled, for not following the rules in this place, they might at least be entitled to a fair hearing, a fair trial for what they had done. Yet what this legislation does is remove that concept of a fair hearing from those people in our country who are often some of the most vulnerable, people fleeing torture and persecution. They want to uphold in government ministers, judge and jury, which doesn't even apply with their own data on how many people they were actually granting asylum to when their cases were heard. But nevertheless, the point about the ECHR is a point that Churchill understood, and I believe many of us in this chamber understood, is that we withdraw the opportunity for that freedom to be heard and that freedom for a fair trial and for somebody else to hear your case against an overbearing state at our peril. Article 13 of the European Court of Human Rights Convention sets out the right to an effective remedy, and it dares to impose on state parties, on countries that are signed up to this court, that everyone whose rights and freedoms are set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding that word again, that the violation has been committed by persons acting in an official capacity. In lay person's term, when you think the government has done you wrong, who do you turn to protect you? Now, rightly, you might want to turn to our courts, but if the government is setting the laws, it makes sense to many of us who value freedom and liberty that there is a third party that you can adhere to. And frankly, it's a sign I'm getting old that I look at the Conservative Party now and I wonder where those libertarians are, those people who recognise rightly the concern that a government might be overbearing and repressive. Freedom-loving indeed, but not enough for their own freedoms, it seems, from the way in which this piece of legislation starts that inevitable process of removing that right to a remedy. Because we all know right-wing governments might start with refugees, but they never end with their rights when it comes to removing them. Now, removing the right to an Article 13 remedy, which is what this legislation does, doesn't just have consequences for refugees, and many of us have debated that issue, that concept that each person should be able to have their day in court, a concept that laypersons across the world understand, for it is not just written into the European Court of Human Rights, into our Human Rights Act, it's written into the United States Convention. I don't think it really is some terrible communist, socialist, Marxist idea that people might have a remedy. That idea of due process, it's part of being a state that plays by the rules, that treats people fairly. And if we start to unpick that in this legislation, it does not just have a consequence for our immigration system, it has a consequences far beyond the remit I think that anybody has really thought about, because for so long it has been a byword for British liberty and freedom that we've been prepared to stand up for the rule of law and play by the rules, and yes, be part of making them through being part of the Council of Europe. And I declare an interest as somebody who did take part in one of those elections to vote for one of those terrible pyjama-wearing judges who then has to uphold the legislation that we have helped create. Where does it have an impact? Well, the member on my side, whose constituency I've just forgotten because I am getting old, I'm sorry, I do apologise, talks about the Good Friday Agreement, and the member from Swindon recognised that too. Let us sound the alarm here, if the government will not deal with it now, that it must be dealt with in the other place, because peace is precious. And the peace in Northern Ireland was built on the bedrock of the Good Friday Agreement, and the Good Friday Agreement is built on the bedrock of the European Court of Human Rights. It's baked into the Northern Ireland peace process. The Good Friday Agreement placed a direct duty on the UK government and all of us in this place to incorporate the European Court of Human Rights and its work into Northern Irish law so that people in Northern Ireland could challenge an injustice in the courts if their rights were breached. That's not my interpretation. The Good Friday Agreement explicitly says full incorporation into Northern Ireland law of the ECHR and states explicitly that the parties, i.e. us and the Irish government, affirm their commitment to the mutual respect, the civil rights and the religious liberties of everyone in the community. When we start removing those rights, which what this bill does by denying the right of a refugee to go to court under Article 13, then we start undermining the Good Friday Agreement because it does affect people in Northern Ireland. It's a principle established in law through Section 7A of the Withdrawal Agreement. Now, the government actually acknowledged this when we debated this on the 12th of December. The Home Secretary himself acknowledged that the bill makes differential treatment in different parts of the United Kingdom and that somehow the bill would address these practical implications. But we've not seen any practical addressing of the implications and the consequences that that might mean for our commitment to upholding the Good Friday Agreement. An agreement that I think we would all concur 25 years on still matters and therefore is worth fighting for. And it matters because refugees are people too. I don't know why we have to state that in this place, but it does increasingly feel like we must do. And the member is right when he talks about the Anderson ruling, but the Anderson ruling shows that the government recognised that just a few months ago because the government in the court said that it applied to refugees. Section 108 explained explicitly that the applicant and the respondent both agreed that the rights and safeguards and equality underpinned by the Good Friday Agreement are not excluded from asylum seekers, and that the concept of who everyone in that community was, that is written into the Good Friday Agreement included those outside the background of communal conflict. So we could be in a position where it's a frying pan and a fire, because if the government proceeds with this piece of legislation, we undermine the Good Friday Agreement. But yes, if they exempt Northern Ireland from this so that those rights are upheld, they create the loophole that I'm sure members on the other side of the benches, I'm not sure which part of the mafia contingent that refers to these days, will recognise creates a loophole in this legislation and just reflects the further chaos and confusion that the government's Rwanda legislation causes. I have tabled Amendment 9, therefore, to address this issue head-on. It asks the government to do a very simple thing, which is set out how we are upholding the Good Friday Agreement through this legislation. Surely that is not a controversial question to ask, but it seems very controversial to get an answer. It's not just the Good Friday Agreement that messing around with Article 13 unpicks. It's also part of our trade and cooperation agreement, because again, when we're doing international treaties, evidence that we play by the rules and therefore we're good to do business with is part of why other countries want to work with us. And that matters post-Brexit, because our reputation is everything. And time again, this government has sought to undermine it by suggesting that somehow the rules shouldn't apply to us, and that therefore people shouldn't expect the United Kingdom to stand up for those values and abide by upholding them altogether. Article 524 of the Trade and Cooperation Agreement says the cooperation provided for in this part is based on the parties and member states' long-standing respect for democracy, the rule of law and the protection of fundamental rights and freedoms of individuals, including as set out in the Universal Declaration of Human Rights and in the European Convention on Human Rights, and on the importance of giving effect to those rights and freedoms in that convention domestically. Giving effect is the crucial thing here. Again, as a layperson, it makes simple sense to me. There's no point in having rights if you can't actually use them. If there is no court, if there is no possibility of being able to seek a remedy. And yet that's exactly what this piece of legislation starts to unpick. It's not a surprise to me, therefore, that the chair of the committee in the European Parliament, Natalie Ozzo, who is charged with overseeing the Trade and Cooperation Agreement, recognises this legislation unamended for what it is, which is a direct threat to that. And the worry that many of us have is not about Brussels telling the UK what to do. It's the fact that we are heading into the months and years before the Trade and Cooperation Agreement is going to be renegotiated. And next time somebody in your constituency comes to you with all the paperwork that Tory hard Brexit has created and that TCA underpins and asks you what you're going to do to deal with it, when they come to you about the border tax that's going to come in at the end of January and all the paperwork they're going to have to pay for at the end of April, that opportunity to reduce that and remove that and bring back that trade we desperately need will depend on those negotiations. Walking into them showing that you can't trust a word that we say as a country, because we might say we're going to follow the ECHR, but actually if we think it doesn't suit us, we won't, and what are you going to do about it, is not the way to get a good deal for British business. So there are consequences to the way in which this legislation has been drafted that we haven't even begun to unpick in this House, but today is our last day to do anything about it. We must not look like a country that you don't want to do business with or is hypocritical. And yet that is frankly exactly what we are. And for those of us who have fought for and defended the rights of people we disagree with, that hypocrisy stinks loudly from this Home Office. Because the same Home Office that wants to use the European Court of Human Rights to deny the implementation of the buffer zones that this Parliament voted for on the basis that there would be an Article 9 contention under the ECHR, is the same Home Office that is seeking to rip up the rights of refugees to use the ECHR when it feels like it. Sauce for the goose, sauce for the gander. In layman's terms, everybody can see what is going on here. Picking and choosing to suit your own ends, and the consequences for people be damned. This bill is contrary to the rule of law because it amounts to a legislative usurpation of the judicial function. It's an assault on our constitution. It is not standing up for liberty and freedom. It's denying it by removing those basic rights. And the government is doing that in its own legal assessment. Now, I earlier raised this with the member opposite. I mean, again, I'm not legally qualified, so I read this, and I think it reads like something out of Alice in Wonderland. It says that Article 13 in the ECHR is engaged but will not be infringed. I mean, that feels a bit like present but not involved as a way of thinking about legislation. It seems to be saying that because we can say that Rwanda is safe and will always be safe, there can never be any concerns raised about safety. It's a tautology. It doesn't make any sense, not least with the evidence that we have that Rwanda does have concerns about safety, or indeed the possibility that things might change in future even if you don't accept the evidence of extrajudicial killings, deaths in custodies, enforced disappearance and torture, and the persecution of those from the LGBTQ+ community. It's not just that it says that. It then goes on to what I believe is a bit more like the Mad March Hare. It's from the government's own legal position. It says that the government considers a declaration of incompatibility is sufficient to provide an Article 13 effective remedy for challenges to decisions under the presumption of safety in Clause 2 to treat Rwanda as safe. For those of us who are not legally qualified, saying something is incompatible to make it compatible, because basically what you are saying is that means somebody can bring a court case, well, that just means that this piece of legislation is a lawyer's charter. Now, the government keeps telling us they don't like lawyers, but they seem to want to encourage them to make a lot of money out of badly drawn pieces of legislation that will encourage court cases. But that's exactly what the government's own legal ruling does. This House can and should do better. This amendment before us is about resolving these challenges, showing that we have thought about them. If nothing else, it would give succour to the court that we had, as we did with prisoners voting, considered the matter, which is often what the court is asking us to do, to not leave people's rights locked away, unable to be accessible, but actually to look at how they are being used. Churchill said that they would welcome any country where the people own the governments and not the government the people to the courts. I think a very noble provision. I'm sorry that members opposite are increasingly advocating removal from the European Court of Human Rights because they can't live up to those terrible ideals of a protection of a right to family life or a protection of privacy or, goodness knows, a protection of freedom of thought. Oh, go on then.
By constantly and sarcastically evoking Winston Churchill. And obviously he did sign up to the ECHR and he sent lawyers to the drafting process of that. But does she acknowledge that, firstly, he didn't initially think that the United Kingdom would join it in the first place? Secondly, when he did sign us up to it, there was no right of individual claim to the European Court. It was properly on the plane of international law, which is between states, which is the appropriate place for this sort of law, and nor would he accept, surely, not at any of us, what the ECHR has become under the jurisdiction of the Strasbourg Court and, I'm afraid to say, our own lawyers. And all the articles she mentions, including the right to family life, have been so expanded by the courts ever since that it's become absolutely inappropriate for us to belong to the court in this way. I really do not think that Winston Churchill would have supported what Strasbourg has become. She doesn't either, surely.
I'm sorry that the Honourable Gentleman wasn't here earlier to be part of the conversation again. I'm sure he would want his own right of remedy to explain why he couldn't be bothered to be here at the start. He would have heard the debate that we had about what the original intention of the court was. Let me quote back to him the original document that says, high undertaking parties agreed to abide by the decisions of the court in any case to which they are parties. From the start, and Churchill himself advocated from the start for the court as a backstop against overbearing governments that felt that it could speak for its people and prosecute people in ways that were being talked about post the Second World War without any challenge. I don't quote Churchill sarcastically. I recognise what he saw at the time, the danger of authoritarianism, and the member opposite would do well to go back and reflect and perhaps reread some of those challenges, as well as the rules about taking part in a parliamentary debate. When Churchill talked about welcoming any country where people own the governments, it was about democracy. And our courts are an integral part of our democracy because they do keep governments honest, even if they're straining with this current administration. Just 2 countries have left the European Court of Human Rights. I was there when we expelled Russia because of its aggression, and we tried to prevent them coming back. And Greece left in 1967 under a military regime and then rejoined once democracy was restored. We should be proud and confident of our capacity to speak up for human rights and to recognise that a right to an effective remedy is an integral part of that, that it's no point having a right if you can't then exercise it, and that means having a separate body to be able to oversee them, to be fair to all parties. More pragmatically, we should be worried about messing up our trade deals and undermining peace in Northern Ireland, as this piece of legislation does. Let me say honestly to the member opposite, it's not woke to be libertarian, to not trust governments and think that we need to protect us. It's whack to think that because your government is in charge, it's okay because it won't abuse that power. All governments try to do that at some point, and it's right that all governments face a process of challenge. This legislation won't stop the votes. What you really want to do is stop the vote, and you can't do that as a government. There will be an election, but not before we have done potentially irreparable damage. Now, the Irish government has yet to say what it thinks about this legislation, but the UK government in that ruling in October was clear that it felt that refugees were covered by the Good Friday Agreement. So in tabling this piece of legislation, this government is undermining its own logic about its obligations under the Good Friday Agreement. So even if members opposite do not care about the Trade and Cooperation Agreement, let us at least care about the peace process. Let us ensure that these issues about compatibility are not something out of Alice in Wonderland, but speak to the best of this place and those obligations, because I promise we shall all regret it if we do not speak up for freedom and liberty in this way.
Suella Braverman.
Madam Chairman, I rise to speak in support of Amendment 11 tabled by my right honourable friend, Member for Newark, commanding the support of over 50, 60 of my colleagues. And I note the comments made by the Honourable Member for Walthamstow, and I would like to respond to some of them that she's made in the course of my comments. Now, we are here to fix the problem that we're all seized by, that is stopping the boats. And this is our third attempt to fix this problem. We passed the Nationality and Borders Act in 2021. We then passed the Illegal Migration Act in 2023. And we are here again, third time round, with the Safety of Rwanda Bill 2024. And the British people are fed up. They have run out of patience, they have run out of time, and this is our last chance to get it right. Now, the amendment on the table here seeks to remedy a fatal flaw in the bill. That being that this bill, as currently drafted, will lead us directly to a rerun of the scenario that we all saw on the 14th of June 2022, when the then Home Office and administration had identified a cohort of illegal migrants, filled a plane ready to take off to Rwanda, but at the 11th hour, pursuant to an opaque process, a decision was made by an still unidentified judge in a foreign court that had the effect of blocking the flight. Sorry, do you have something to say? Why don't you?
I'm not sure why we have to be frightened of foreign courts. What exactly is wrong with a foreign court?
Well, I'll tell you what we have, where we have a problem with a foreign court. When actually in that scenario, English courts had actually refused injunctions by the migrants to get off the flight. The foreign court overrode English judges, overrode the will of the government, overrode the will of the British people to control our borders and stop the boats. That's a problem with the foreign court. And that's the problem that we are trying to fix. And so when that flight was grounded in June 2022, it was because of these Rule 39 interim injunctions. Now, these orders are not contained in the European Convention on Human Rights. They are not a product or content of the original documents of the Convention itself. They are a creation of the Strasbourg Court and the Strasbourg judges. They have evolved over time, pursuant to the living instrument doctrine that is espoused by the Strasbourg Court and that has inflated and expanded its remit over decades, beyond anything conceived by the original drafters, beyond any intention set out in the original versions of the European Convention. Now, no one here, I believe, disagrees with the aspirations and the content of the European Convention on Human Rights. I don't disagree with anything set out in that document. It contains noble and vital rights, fundamental rights, human rights, that we are all proud to defend fervently and fiercely against oppressive regimes, against authoritarianism, against genocide, against mass killings, against some of the worst atrocities that history has seen. That's what was the creation, that's what the context was for the genesis of the European Convention. The problem that we're dealing with here, and this is where I want to respond to the Honourable Lady's comments about the issue, is the court. It's the court that has become politicised. It's the court that has become interventionist. It's the court which doesn't follow the traditional rules of precedence that our common law system here in the English courts subscribes to. It's the court and the judges in the Strasbourg court, in the European Court of Human Rights, that has distorted the original European Convention on Human Rights into something that bears no reflection, as I said, to what it was originally intended. And it's been exacerbated by Labour's Human Rights Act. And over previous recent decades, we have seen the rights culture, the litigiousness around immigration and asylum, and many, many other areas of public sector decision-making become stymied and thwarted and undermined by a heavily resourced and activist legal industry, undermining government decision-making, stymieing policy-making, undermining law enforcement and public safety. To take but a few examples, take the case of a Nigerian national, cases 00, sentenced in 2016 to 4 years in prison for offences including possessing crack cocaine and heroin with the intention to supply, pleaded guilty in 2017 to battery and assault, serious offences. In 2020, the first-tier tribunal allowed his appeal against deportation on grounds that he had very significant obstacles to integration in Nigeria, and they outweighed the public interest in his deportation. Despite the serious nature of his offending, despite the risk that he posed to the public, no, his Article 8 rights, interpreted in a vastly elastic way, a distorted, illogical way, operated to stop that man being deported. Or the case of D versus the UK, where Article 3 we can all agree with. It prohibits torture and inhumane treatment, degrading treatment. But in this case, in D versus the UK, a case of a non-national who was convicted for dealing drugs, the Strasbourg court held that the effect of discontinuing his medical treatment available in the UK, but not available in his destination country, amounted to inhumane or degrading treatment under Article 3. Why should a convicted drug dealer be entitled to public services here and not be deported?
I'm grateful to my friend. And surely on that basis, almost any deportation could be blocked, for there are few countries in the world that can match the standard of our NHS. And once that precedent's been set, every person will claim they require treatment for the most minor of ailment.
I'm afraid my right honourable friend is absolutely right to highlight that point. And it's Article 3, its stretched interpretation originating in the jurisprudence from the Strasbourg court by politicised judges who have a political agenda that they are pursuing, which has led to a perception that here in the UK we have an international health service, not a national health service. Or lastly, AM Zimbabwe, a case from 2022, where it has now become law, thanks to that case, that states who want to remove someone have to prove that medical facilities available to the deportee in their home country would remove any real risk that their lifespan would be shortened by the removal from NHS facilities. Exactly the point that my right honourable friend has made. It is now a duty on the UK government to establish that foreign health services are sufficient before we deport people who may well pose a risk to public safety and national security in some cases in this country. So those are the overall problems with the court, not the convention, but with the court. And Rule 39 is another symptom of the problem that we have with the court and with the judges. And that's why this amendment is absolutely vital, because this amendment that has been tabled will make it clear that Rule 39 orders are not binding, and that it will be for the UK government to make the decision on deportation, not for a foreign court, an identified judge somewhere far away who does not have the same ambition or aspiration as this UK government to stop the boats. And that's why I will support this amendment enthusiastically today. Just to conclude my comments, Madam Chairman, this is our last chance to fix this problem. We have stretched the patience of the British people. But this comes down to a very simple but profound question, ultimately, of who governs Britain. Is it us, the democratically elected representatives who have been directly sent here on behalf of the British people on a clear mandate and a clear instruction on what to do, and whose laws are passed by a clear and transparent majority to which we can all be held to account at the ballot box? Or is it an opaque forum many miles away in a different country, distant, outsourced, foreign, which does not share our values, which does not, no, I won't, because which does not share our values, which has made decisions time and time again which are at odds with what the British people have indicated that they want, and which has operated to undermine our public safety, our national security, and our good governance. The operation of the Strasbourg court, call it Strasbourg court, call it foreign court, you can argue about semantics. It's the European Court of Human Rights that we are concerned with here. And it is that court that is currently controlling this country's ability to stop the boats. It is that court and its jurisprudence that is stopping this government from delivering for the British people. We made a vow to the British people that we would stop the boats. That was a solemn vow that I took incredibly seriously. It is what people voted for in 2016 in the Brexit referendum by a majority. I know most people on that side of the chamber don't want to believe the majority, still live in denial and don't want to accept the facts. It's what people voted for by a huge majority in 2019 to control our borders and to stop the boats. We made a promise.
Lady for giving way, and I know she feels this passionately. I just wonder if she could clarify, because she's got a concern there about a foreign court. What does she think NATO is?
doesn't do effective. NATO is not a court. I'm slightly embarrassed that I have to make that clear to the Honourable Lady. That's really elementary politics. We are being governed by a foreign court and judges who do not have our interests at heart. The decisions coming from that court are stopping us from controlling our borders. The amendment tabled here will prevent that foreign court from stopping us. And that's why we need to support this amendment. It will fix this bill. This bill needs to work. It is our last chance. If we get it wrong, the British people will not forgive us, and they would be right to do so.
Order, order. I have now to announce the results of today's deferred divisions. On the Draft Immigration Act 2014, Residential Accommodation Maximum Penalty Order 2023, the ayes were 331, the noes were 51, so the ayes have it. On the Draft Immigration Employment of Adults Subject to Immigration Control Maximum Penalty Amendment Order 2023, the ayes were 331, the noes were 51, so the ayes have it. Patrick Grady.
Madam Deputy Speaker, what a privilege to follow the former Home Secretary, and it's really lit up. You know, there was comparisons earlier on that this was the next episode in a box set. I think we've actually just seen the first act of the next round of the next Conservative leadership contest, and no doubt the sketch writers and everybody else paying attention have suddenly woken up. I mean, she made some incredibly interesting comments. She spoke about vows that were made to British people after referendums and elections. I remember a vow being made in 2014 about how the Scottish Parliament was going to become the greatest, most powerful, devolved Parliament in the entire world, and look how that one turned out. She's right, the government will be held to account, and Parliament will exercise its opportunity to have a say on these issues, and that's why the amendments from her and her honourable friends were voted down last night, and that's why they'll be voted down again this evening. I'm incredibly confident. And then come the election, a majority of members of Parliament, and that includes a majority of members of Scottish National Party MPs in Scotland, will be returned to this House who will vote to repeal this bill, assuming that the bill ever makes it on to the statute book in the first place, Madam Deputy Speaker, because in reality, this was supposed to be, what is playing out is not a debate specifically about this legislation, but about the future of the Conservative Party. And not just the future of the Conservative Party, in fact, some of the past of the Conservative Party as well. It's been a real privilege in some ways to debate against the Maastricht rebels of old, and having the opportunity during my time in this House to debate against people who were on the television when I was studying for my Modern Studies standard grade 30 years ago, and they still can't get that determination to rebel against the government out of their system. It doesn't really matter what the government's proposing. You know that the member for Stone and the member for Gainsborough and the member for Woking and all the rest of it are just going to be against it because they love that sweet taste of rebellion. But the rest of us have better things to do with our time. We need to get on and demonstrate what our constituents actually think about this bill. We heard at great length from the member for Stone yesterday about the wonderful concept of parliamentary sovereignty, even though the clause that explicitly recognises parliamentary sovereignty is actually in today's grouping of debate, and that's the clause that my Amendment 31 would remove. And the reason for that is because the assertion of parliamentary sovereignty in a bill like this is actually a bit of an innovation, and I'd be quite interested if the Minister was able to respond to this point a little bit later on. This idea of including in a bill the language that Parliament is sovereign is, in fact, as I say, a little bit of an innovation. With the help of the House and Commons Library, the only other instance that I've been able to find is in the EU Withdrawal Act 2020. Now, there are other examples of legislation which imply parliamentary sovereignty, imply the ability of this House ultimately to override courts and make its own decisions. Some of that is in some of the founding legislation that took us into the European Union in the first place. Some of it's in the acts that established the devolution settlement. But this line asserting that Parliament is sovereign is something of a legislative innovation. And given how lyrical the member for Stone waxed yesterday about the wonder of an unwritten constitution, it slightly strikes me that this is a form of codifying the concept of parliamentary sovereignty. It strikes me as this is perhaps actually writing down aspects of the UK constitution. And this seems to me a random piece of migration legislation, which, as we say, may or may not ever actually make it onto the statute book. It seems a very interesting way to go about codifying the UK constitution. The other reason for my amendment, though, is the one quoted both by the member for Kirkcaldy and Cowdenbeath yesterday during his 10-minute rule bill, and my honourable learned friend for Edinburgh South West earlier on, when she quoted the constitutional expression, when she quoted the constitutional tradition expressed by Lord Cooper in the case of McCormick versus the Lord Advocate in 1953, that the principle of unlimited sovereignty of Parliament is a distinctly English principle which has no counterpart in Scottish constitutional law. And my honourable and learned friend spoke with far greater experience than I can about what the significance of that ruling means, and indeed the wider significance of Scotland's historically independent legal system to this debate and to this legislation. And that perhaps explains my amendments 4 and 5, which remove Scotland from the extent clause of the bill, because despite what the member for Fareham seems to think about the opinions of the British public and the British voters, voters in Glasgow North want no part of this. And I know that because I speak to them on a very regular basis. And a significant number of them, frankly, are asylum seekers who come to my surgery on a regular basis, and I hear the horror stories, not just of what they've experienced in their countries of origin, but of their experience of trying to deal with the Home Office. And frankly, perhaps if more asylum seekers knew that that was what they were on the receiving end of, maybe it would have the kind of deterrent effect that the Home Office is so desperate to try to achieve. But in reality, Scotland always has been a country that welcomes refugees, asylum seekers, those who want to make their home and contribute something to our society, just as so many countries did around the world who welcomed Scots when they were cleared off their land to make way for sheep, or when their crops fell victim to blight, or in the modern world who want to study around the world or practice their professions overseas. And that's why I also support the amendments from our honourable friend, the member for South West, Edinburgh South West, that the Scottish Parliament should be asked to give its consent to this bill before it took before it takes effect north of the border. Because in reality, the Scottish Parliament will not give its consent to this motion, because it is not what the people in Scotland want to see, or how we think a humane system of asylum should take part. The bill talks about the safety of Rwanda. I asked the Prime Minister about this earlier today. I asked him if Rwanda is a safe country, if it's a comfortable place. And I asked the Minister this yesterday as well. If Rwanda is a safe country, if Rwanda is a comfortable place in which people can live out their lives having been granted asylum, why would the principle of being, why would the potential of being deported there be a deterrent? It doesn't seem to make an awful lot of sense. And the Minister's answer and the Prime Minister's answer was the same. It's, well, because Rwanda isn't the UK. So the fact that Rwanda, that not being the UK is itself in a deterrent. So by the same logic, if the government came to an agreement with Disneyland and threatened to deport asylum seekers to Disneyland if they arrived here by irregular means, that too would be a deterrent, because it is not the United Kingdom. Sadly, there is not yet a Disneyland in the United Kingdom, though I suspect sometimes people look at this place and wonder exactly where the fantasy in all of this is. So by the government's own logic, the bill fails under the weight of its contradictions, and that's the point of the definition of the safety of Rwanda, which is in Clause 1, Madam Chair. So the bill fails under the weight of its own contradictions, and you could see that in the contradictory amendments that have been proposed by the 2 or 5 or however many opposing factions there are on the Conservative benches. So the former Home Secretary was right. The public will have their say on this bill. And after the next election, the government that is returned, I'm confident, and that will include members from the Scottish National Party who will be prepared to support any legislation that comes forward to repeal this bill, assuming, as I say, it makes it onto the statute book in the first place.
Order, order. I will now announce the results of the ballot held today for the election of the Chair of the Defence Committee. 476 votes were cast, 4 of which were invalid. Jeremy Quinn was elected Chair with 371 votes. He will take up his post immediately, and I congratulate him on his election. The results of the counts under the alternative vote system will be made available as soon as possible in the Vote Office and published on the internet. Order. Tim Lawton.
Thank you very much, Dame Rosie. Can I be slightly unfashionable and talk to the amendment rather than regurgitate some second reading speeches that we've had? And I do so with some trepidation because we've had a trio of former Lord Chancellors, Attorney Generals and Chairmen of the Justice Committee sitting to my right, who speak with much greater legal gravitas and much more expensively, is the only upside perhaps of that. So my advice and my talking to this amendment comes for free. But in contributing to this debate, I am largely speaking to this side of the House. Because in all the speeches we had yesterday, when the opposition could not fill the full allotted time for this debate, having complained about the lack of scrutiny, and I'm guessing they may not be able to fill the full time given to it today, we heard speech after speech emulating their front bench that told us what they don't like, what they're not supporting, what they're not voting for. And at absolutely no point did they come up with a practical solution for the very real everyday problems we are aiming to deal with here. So whilst we have disagreements on our side as to the methods, what we want to achieve is in common. And that goal is something that needs to be tackled, and we are having an honest debate about it on this side. And at last, the official opposition is playing absolutely no part in that debate. My honourable friend, the member for Newark, who I think has left his place, started the debate talking to Amendment 23 in particular, and he described the problem as like pulling the pin out of a grenade but then not throwing it. I don't think that was helpful language, and he then quitted the chamber having thrown the grenade behind his own lines. Because what we need here is cool, calm consensus to come up with practical, workable, acceptable and legal solutions. So the Rwanda scheme is not perfect. I think all of us will agree with that. But frankly, it is the only real show in town at the moment to answer this essential question, which I raised last week in the opposition debate, which again the opposition struggled to fill with their own speakers. How do you deal with people who have come to this country mostly by small boats having paid criminal gangs with no credible prospect of being able to lodge an acceptable asylum claim, and who come from countries to which it is virtually, if not completely, impossible to return them, so they know that once they have made it across the midway of the Channel and they are in British territorial waters, they are effectively in the United Kingdom for the foreseeable future. That is absolutely the question that is at the heart of this whole bill and this debate today and yesterday. I'll give way to the Honourable Lady.
And I've heard him make this point before about people who come and then can't be sent back to whatever country because of the situation there. And it's a case that has occurred within my own casework. So at the moment, what the Home Office appears to do is grant people temporary leave for perhaps a year at a time, which gives absolutely no certainty to the person who's affected by this, but it does give the Home Office, I suppose, that discretion to reconsider it rather than giving them permanent status. So this already happens. It's not something that he should really be so concerned about, I would say, given it's something that happens already.
I know it happens already, which is what I've been saying, and she's at least credited with being consistent. But we have three problems with the immigration system at the moment in this country. One, how we can prevent people from leaving those mostly French beaches in the first place to make that most inappropriate and most dangerous journey. And we can have a different argument about the safe and legal routes, which he knows I support, as to whether that would reduce the numbers trying to do it, or whether we can come to some accord with the French that they would actually intercept those boats and return the passengers back to French shores. That is the first question. The second question is we absolutely need to speed up the whole processing. The government has, to give it its credit, of those people who are in limbo, and those who came before the Illegal Immigration Act, who are able to have their asylum applications still heard in this in the country. We need to get through that backlog as swiftly as possible. We then have a problem with those in limbo post the Illegal Migration Act who have effectively committed a crime under the terms of that Act. But then the third point to solve the migration crisis is then removing those people who have not been able to make a credible claim to stay in the United Kingdom. And that is why the alternative of them facing a lottery as to whether they will end up in a hotel in Kent or on a plane to Rwanda and have their claim instead assessed there is an important part of the deterrent factor. It is just one part, it's not an overriding part as some people have tried to caricature it, but it's an important part to deal specifically with that group of people who it is really, really difficult to remove. In time, we need to have more returns agreements. We've successfully done that with a number of countries. Albania has been cited many, many times. But there are countries with whom a returns agreement, of which Iran will be one, is frankly impossible, and we shouldn't delude ourselves otherwise. So to suggest we can solve this problem just by having a further agreement with the French, paying them more money. We've paid the French gendarmerie and police force £480 million already, and yet the proportion of successful intercepts has actually fallen in the last 12 months. We already have joint operations with them. We already have a unit within the NCA dealing with this. So the opposition's claims that this can be solved by getting better at cracking down on the people smugglers cooperating with the French, all of that is already happening. We need to speed up the applications, as I've just said, but that still does not deal with the problem of what you do with people that you can't then return. So that's why I absolutely agree with the spirit of what the Honourable Member for Newark and other honourable friends are trying to do with Amendment 23, but I don't agree with the method, which is why I will oppose this amendment. Let's just remind ourselves, the reason this bill has become necessary is in response to that Supreme Court judgment which found the Rwanda scheme to have various specific shortcomings. The refoulement threat, the fact that it was a one-way street, which has now been resolved. And so that's why a number of measures have been brought in with the Rwanda Treaty and within this bill as well. This bill is about allaying fears about not fulfilling the obligations under international law and the implications that may have for the Northern Ireland Agreement, as that has already been mentioned, and for negotiating trade treaties and other international agreements in the future. But the Rwanda Agreement, as it currently stands, before the reforms to it, fell foul of our own courts. Not just the ECHR or the Refugee Convention or whatever, it was our own courts that ruled against the government. And it needs to be seen to be lawful, not just by Rwanda, but potentially also by other countries who have signified an interest in operating a Rwanda-type scheme themselves, both as hosts and other European countries who actually are interested in getting part of the action if we are able to get the Rwanda scheme into operation. And ultimately, my aim would be able to see a cooperation of European and other nations have a joint Rwanda-type scheme, and it's not just limited to Rwanda. That could act as a very effective deterrent so that we can make sure that far fewer people come across the channel and we can really clamp down on those who still use that route, because absolutely they have very little credible claim to have asylum in this country, and for that we need to have the safe and legal routes operating properly as well, as I've said many times before. So there is a problem specifically with Article 39 pyjama injunctions or indications. Now, I'm not a lawyer, but on the basis of the thresholds for which other things can come to court, this is a very, very opaque process. We've heard about the anonymous judges. They don't issue a full judgment, that the government cannot make a case at all. Where else is there a legal system whereby the person who is effectively being prosecuted cannot make their own case in front of a judge? And there is no appeal facility in this whole operation as well. But Mr Gale, Sir Roger, these Article 39 indications were never part of the European Convention. It was never included in the Constitution. There were attempts to include it in the Constitution which were never supported. And these powers, as other honourable friends have said, just seem to have been absorbed into the Strasbourg Court at its own fiat. To whom is this court accountable? Why is the European Council not doing more in terms of governance of how these powers have been surreptitiously extended? Now, last year, the Strasbourg Court itself admitted that it needs to change its ways. It admitted that the operation of Article 39 indications is not satisfactory, and they said that in future they would only be used in extremis. We don't know how they define that they will be operated by named judges, and that the government in this case would have an opportunity to present its evidence and be listened to, and there will be more transparent judgments. So the court itself knows that there is a problem with these Article 39 indications, and we are not the only country concerned about the way they have been operating. Too often it seems we are pilloried as if the United Kingdom government are serial offenders against ECHR judgments and European Convention diktats. Well, other countries seem routinely to get around Article 39 indications, and we have one of the best records in complying with ECHR judgments. If one looks over the last 10 years or so, there have been no fewer than, I think, 400 ECHR rulings which have not been enforced or complied with. In the case of Spain, 61% of rulings against them have not been complied with. Italy, 58%, Germany, 37%. In the case of the United Kingdom, we are one of the best compliers with ECHR judgments, and the sorts of things we've not complied with are votes for prisoners, which we've heard about, where we had a vote in this House, largely to indulge the Liberal Democrats as part of the coalition government, I seem to recall. This House very forcefully, robustly voted against it, and we decided not to go forward with it. I think that was absolutely the right judgment, and it stays in limbo. So we do need to reform the ECHR. In the last year, I think there have only been 4 judgments against the UK on ECHR Convention matters. So, Sir Roger, yet again, the UK has fallen foul of abiding by the rules that too many others ignore. So I support the case for not being bound by Article 39 rulings. And as I say, we need urgently to seek to work with our partners through the Council of Europe and others to reform them. It's a very opaque governance system. But I do not believe, Sir Roger, that not being bound by these confected Article 39 directions undermines our overall compliance with international law or our international responsibilities and undertakings. But the bill already says that in a reasonable and balanced way, the Minister has discretion to make the decision not to comply with those Article 39 indications. So we have given the Minister and the Government the power to say, actually, we don't think that is right, and therefore, for good reason, we are not going to allow that Article 39 indication to apply to that case. That, I think, is a sensible way of proceeding. It's not a mainstream, routine, blanket disregard, which could fall foul of our own courts and have international implications for the integrity of British legislation and governance. So I support the spirit of what honourable members are trying to put forward with this Amendment 23, but I don't support the method. We all know that this is a very difficult, complex and sensitive issue to get this Rwanda legislation through. We have to strike a very fine balance between not trampling on international law, but at the same time enabling our government to get on with the measures which it was elected to do. I think the government have got the balance right in this bill, and it was not an easy task to do that. And that's why I want this bill to go through unamended. I think we all have something to gain from that happening. I will certainly be voting for the full bill at third reading if that happens this evening. But my honourable friends just need to stop and consider before they pull the pin out of another grenade. If this bill does not go through, there is no plan B for dealing with those people for whom we cannot transport them back to the country from which they came. There will be no Rwanda Bill, no Rwanda scheme, no deterrent policy, and no obvious end to the small boats. So I hope the Honourable Member for Newark, having made a very strong case, but I think with the wrong ultimate conclusion of the method, will consider the implications of pursuing this and pursuing it all the way to voting in the wrong lobby when it comes to the third reading as well, to withdraw his amendment and let the government get on with the job with seeing whether we can get the Rwanda scheme to work, get the planes off the ground, offer a real deterrent and get this problem sorted out once and for all.
Tim Farron.
Roger, pleasure to serve under your guidance this afternoon, and indeed to take part in a debate which has been, broadly thoughtful, despite very clear differences of opinion. A pleasure to have sat through and enjoyed the speech of the Right Honourable Member for Fareham, who is the very definition of an activist lawyer. And so we're grateful to have her with us. And I speak in solidarity with the other minority of people here today who are not legally trained, who are not lawyers, and it's right that our voices are heard too. I would say this. I rise to speak in particular on and in favour of amendments in the name of my right honourable friend, the member for Orkney and Shetland, who is indeed a lawyer, Amendment 6 and 7. But I want to say something I think which ought to be not even remotely controversial, and that is the evil trade of shipping people across the English Channel in rickety boats. It is evil. It needs to be stopped. And those people who are carried across the Channel via those means are taking huge risks. And we've seen massive loss of life, or significant loss of life, over the years, including in recent times. But I think this bill and the two amendments that I'm speaking to seek to challenge the fundamentals of the bill. I believe this bill will not do what it says. It will not stop the boats. It will not tackle the issues of deterrence and so on. And even if it did,
what the Rwanda provisions would achieve is to tackle roughly 1% of the number of people who seek asylum in this country. And at the heart of this bill are a series of errors, really, as well as leading to poor policy, because it is a bill based on a series of false premises. There are three basic false premises. And number one is the belief that whilst this is a global problem and a European problem, that the UK's position is especially awful. That we are, and I've heard incendiary language in this place and outside of it, relating to us being overrun, swamped, people swarming across the channel and all that kind of thing. The reality is that 85% of those who declare themselves to be refugees remain in the region from which they have fled, normally in the next door country. So a very small minority end up in this continent. That Germany takes 4 times more asylum seekers than the UK. France 2.5 times more asylum seekers than the UK. Spain 2 times more asylum seekers than the United Kingdom. And indeed, if we were to just perish the thought, place Britain back into the European Union just for a second, for a league table snapshot, then we would see that the UK is 20th in the league table of countries amongst the other 27 that in terms of numbers of asylum seekers we take per capita. So the idea that the UK is overwhelmed with this particular problem is not true, and it isn't taking account of the realities across the continent and across the world. It's also worth bearing in mind that given the issue the government is really dealing with, or it thinks it's dealing with in terms of its voter base, is the issue of excessive immigration in general, and yet only 7% of the migrants to this country are asylum seekers. The real issue, and where there is an issue of us being overwhelmed, is that the last time I checked, 165,411 asylum seekers are waiting in a backlog. 75% of those people will be, on past experience, counted as refugees and given approval by this government. So we know that the people are broadly who are coming here are genuine refugees. And then a maybe different 75%, not an entirely coterminous 75% of them, are waiting more than 6 months. So when people get letters in their postbag, emails, and people are outraged about this issue, more often than not, it's not about the boats crossing the channel so much as the fact that a local hotel is full of asylum seekers and not being used for its primary purpose. There is a reason for that. Those asylum seekers do not want to be in that hotel, Sir Roger. They want instead to have their cases treated quickly. I was in Barrow, in the constituency of my honourable neighbour, the member for Barrow, just a few months ago, talking to asylum seekers there who would actually rather be told to leave the country and be given a decision that was negative to them than to be waiting the year or more that they had so far. One guy who told me that was a person who was an Afghan interpreter for the British Army in Afghanistan, but we'd left him behind, and the only way he could find to get to this country was to come via that irregular route. These are the people we're talking about, and the reason that we're in the situation that we're in is because of the government's failure to tackle the backlog. So the first false premise this bill is based upon is that the UK's problem is somehow different and greater than any of our neighbours, or indeed somehow separate from the problem that affects indeed the whole of planet Earth. The second false premise is that the only way to control migration, brackets 7% of it, because asylum makes only 7% of UK migration, the only way to control migration is to duck international law and become a pariah. The Right Honourable Member for Kenilworth and Southworth said more eloquently and in more detail than I'm going to, he pointed out the issue of the United Kingdom being credible internationally. You know, we listened to the Prime Minister earlier this week. We're aware of what the UK is doing, government is doing, the UK military is doing alongside the US in the Red Sea. And the justification for that, which I hear and understand and accept, is that this is about upholding the rule of law. And if we want to work around the world stage and to be a leader, to be people with influence, then we need not to be those who habitually break the rule of law and think these things do not apply to it. I am content to give way, yes.
I just perhaps would like to mention to the Right Honourable Gentleman that actually this question of global leadership is a matter which I did mention in my speech yesterday for a very good reason. It's to do with reputation, but it's also to do with change. And all over the whole of the European Union, faced with compulsory quotas and compulsory fines, they're in a real mess. They've also got the Charter of Fundamental Rights. They can't do it without changes in constitutional law and their constitutions, and they may well have to have referenda. In this country, we're in a different position, and we can do it because we, in the dualist system, are entitled to require our courts to obey the decisions of Parliament about its sovereignty where it is clear and unambiguous wording that is used. There is the difference. That's why we can lead the world. And in the case of the negotiations, which are bound to be happening, because my friends on this side of the chamber have been indicating that they believe that there are going to be changes in the European Convention, and indeed, for that matter, also in the Refugee Convention.
For his intervention, and I would simply say, of course, it's a given that the law changes, and laws change via a variety of different means, including how this place votes. Nevertheless, the United Kingdom would be seen to, in order to tackle a problem in an ineffective way, by the way, to be choosing to disapply the Human Rights Act and to choose, at least to an extent, not to comply with international law. Now, I heard all the kind of disparaging remarks about, lefty lawyers, activists, judges, foreign judges, and so on. And I think all of that, it just kind of demeans this place, and it's not the kind of thing that people who are supposed to uphold the Constitution really ought to be saying, particularly given the majority of lawyers that I've heard speak in this debate are on that side of the House. And if members opposite want to describe themselves as lefty lawyers, that is their business. But I don't think it is helpful. But when you've got the Law Society saying, and I quote, that this legislation may be incompatible with our international obligation and sets a dangerous legal and constitutional precedent by legislating to overturn an evidence-based finding of fact by the court, that is something we should take seriously. There's no doubt whatsoever that for us to decide that to pass a law to say that Rwanda is a safe country, it's not only an overreach of Parliament, because if we have got evidence to say that Rwanda is safe, present it to the court. Do it in the proper way. It is dangerously authoritarian for us to decide that we can decide on a matter of fact of law rather than presenting it before the courts. It's not only an overreach, though, Sir Roger, it's also ridiculous. I mean, if we're going to declare Rwanda safe just because we want it to be, I declare Blackburn Rovers back in the Premier League and Alan Shearer to be 30 years younger and back in a number 9 shirt playing up front for us. There we are, make it so. But that's clearly not the case, sadly. So if there is evidence, you present it to the court. It is ridiculous for this place to say that somehow it can declare a place safe just because it is convenient for it to do so. You don't control migration by this kind of sophistry, but deterrence is still appropriate. And people have asked about, well, what deterrence are you going to have? Well, the deterrence is if we had a functioning asylum system where you actually returned people who failed in that system. I can see him with his hand up. Off you go. Yes, I'm happy to give way.
I'm very grateful. On his point about declaring a country safe, it is the case that France, Germany and other EU countries have decided they will not entertain any asylum applications from Albania because it is a safe country that abides by the same conventions. So they've done it, why can't we?
I mean, I think on balance we'd say yes, Albania probably is, until the bulk of returns that we have had have indeed been to Albania. But I think for us to get out of a hole on this individual case, when there is evidence that Rwanda is not a safe place, then the issue is we present evidence to the court in order to achieve that. I mean, if you want to have another go, yes.
On the safeness of Albania, having said that nobody can determine whether a country should be deemed safe or not. There are many dangerous things going on in Albania, which is why some people are leaving them, involving drugs and trafficking, various other things as well. All I'm saying is European countries will not entertain asylum applications from Albania because they've deemed it not to be suitable and applicable. So why can't we apply the same criteria to Rwanda?
I've never been an apologist for the European countries. They make their own decisions, but the clear issue is this House has been asked to decide on a matter of law when that is a matter for the court. So if there is evidence that Rwanda is safe, you present that evidence to the court. That's the proper way to go about it. And he knows that. And my opinion is neither here nor there whether a place is safe or not. The issue is about have the courts considered the evidence in front of them. The evidence in front of the courts was that Rwanda is not safe. We don't deal with that by just declaring it to be safe, which is unconstitutional and also ridiculous. We present the evidence. If the government has evidence, present it to the court. But I want to go back to what I was just leading into, which was the issue of deterrence. The fact is, if you want to deter people to come to the United Kingdom who do not have a legitimate claim, then be some use at removing those people who do not have a legitimate claim. The fact is that only a quarter of those people who are denied asylum once they've gone through the process are actually removed. And that is the problem. So we have a government that is incompetent at doing the basics, inefficient at doing so, and is weak at tackling those people who eventually do get assessed and are shown not to be refugees. So the problem is not activist judges, it is weak and incompetent government. It's also worth saying that I'm not accusing everybody on the other side of the House of being populists, but one of the hallmarks of a populist is that they look at a huge and difficult problem and they come up with a simplistic solution. And the reality is, we need to be honest that this is a very difficult problem and it isn't easy to solve. That it is a global problem and that what we have to do is work with other countries in order to try to address it. So, for example, some of the issues around Yemen will no doubt have been exacerbated by this country choosing to reduce its aid to Yemen. So if we want to influence and stop the flow of people away from troubled parts of the world, then we get alongside those places and we seek to try to deal with these things at source. But I would not even make any pretense that that will solve the problem. But let's not pretend that by trying to attack one part of the symptom is an answer. It is dishonest to claim that this is an overall answer to the problem. The third false premise is that the provisions of this bill will even remotely work. At best, on the government's own figures, a maximum of 1% of the asylum seekers coming to this country will end up being removed to Rwanda, at the cost, by the way, of £240 million and counting. I mean, we could just say, why not put that money into a better border force? Why not put that money into clearing the backlog? Why not put that money into doing things that actually would deter people from coming? It won't work, though, and it won't deter people. And let's just think through why it will not deter people. Let's think of one of the places from which many refugees who end up in this country and indeed come over the channel come from in the first place. Eritrea. Eritrea, many people would refer to it as being the North Korea of Africa. Isaias Afwerki, an awful, appalling dictator. Amongst the things that he does, and that is a cause of people seeking refuge from that country, is that he conscripts all young men at 18, and then many of them, particularly from Christian communities, are then sent to murder their own people. And so, understandably, people ask, why are so many people coming young men? That's one of the reasons why so many people are coming are young men. And so they seek asylum. Where do they go next? Well, many of them will stay in the region. But just in this issue of deterrence, it's so important to understand it. So that young men, maybe a couple of brothers who've escaped, it's been hard to escape in the first place from Afwerki and his evil henchmen. So he leaves the country. They leave the country. They end up at some point going through the lawless horror that is Libya today. Utterly appalling, a country barely without rules. If you think the experience of what happened post-Gaddafi is a reminder, there is nothing so awful in this world that you cannot make it worse. And Libya is even worse than it was in that time. So you pass through that with its human trafficking, with the massive murder rate, with the appalling experiences of human rights in that country, and you make it eventually to the Med. And you cross the Mediterranean. You've crossed the Mediterranean to mainland Europe. And then, at some point, you're asked to make a decision about about whether you will or will not cross the 20 or 30 miles of the English Channel. I'm sorry, Sir Roger, it's a piece of cake compared to the horrors that they've endured so far. On the 1% chance they might get sent to Rwanda, do we genuinely think that this is a deterrent at all? It's a reminder, isn't it, that this is a huge distraction from the issue that we are actually facing. So this is a bill that assumes a state of affairs that isn't true. It assumes that the only way to deal with this situation is to act unconstitutionally, in a very anti-conservative and unconservative way, I might add, and it assumes it will work when it blindingly, obviously, won't. And Amendments 6 and 7, in the name of my right honourable friend, the member for Orkney and Shetland, are there in order to... They challenge the assumption that in order to control migration, we don't need to exempt vulnerable people, or we believe we don't need to exempt vulnerable people from domestic laws which protect their human rights. We don't need to try and duck out of our obligations under the ECHR by ignoring interim injunctions. So these provisions, they are morally wrong, they are constitutional vandalism, and it constitutes a failure. It is an issue which is all about seeking to distract the electorate from the reality of their daily lives. It is a government failing to govern and tackle the cost of living, tackle the NHS crisis. 1 in 9 people in my constituency, Sir Roger, is currently on an NHS waiting list. And this government is wasting its time on something which is morally outrageous, unconstitutional, and won't even do the thing it is set up to do.
Order. Just before I call Sir John Hayes, could I remind the House that this is not a second reading debate. It is a debate about all of the clauses stand part, certainly, and all of the amendments, but it's not a second reading. There is a distinction. Sir John Hayes.
I'm extremely grateful, Mr Chairman. This debate is not on this side of the chamber, as my honourable friend from Worthing and Shoreham and other places said, a difference in ends. In aims, it's a difference about means to those ends. We want, on this side of the chamber, to travel to the same destination. What we're debating is the journey to get there. So let's not exaggerate the differences between us. They are those differences. And I know the Minister shares that view, and we've engaged with him, and we hope to continue to do so, even at this late stage, to improve the bill, to make the delivery of those intentions, the journey to that end, one that we can realise. We have to do so because mass migration is perhaps the biggest existential crisis facing this country. I say that not blithely, because unfortunately in this chamber people say things as though they're definitive and use all kinds of superlatives. Indeed, the Honourable Lady from Walthamstow made a brand out of it, and as we heard earlier. So I don't say that blithely, but it would be a view shared by a large number of my constituents, and as the Honourable Gentleman also said in his contribution, is now widely shared in other countries. So the issue of dealing with this bill and these amendments to it affects our constituents directly and personally, contrary to the contribution of the Honourable Member for Westmoreland and Lonsdale. He claims that this is a distraction. Far from it, because you cannot absorb the number of people we are as a consequence of both legal and illegal migration into this country in a short period of time without a devastating effect on public services, a displacement effect on the investment in the skills of our own people, a displacement effect on the need to reform welfare, and above and beyond all of that, the ability to integrate those incoming people into cohesive societies in which we all share a common sense of belonging. So, in dealing with these amendments, we need to be realistic about the scale of the problem and the nature of the British public's view of that problem. They know that the vast majority of people arriving here on small boats are men under 40, about 75% of them. 9 out of 10 of them are male, by the way, far from the picture painted by some of the critics of the government and our policy. So they know too that large numbers of them are not genuine asylum seekers, but they're economic migrants. I will in a moment. I just want to continue to make my point and then I'll happily give way. And that truth is so evident to the electors of this country, they look with bemusement at this place that it's not widely recognised here. And yet we hear speech after speech from the benches opposite in particular, I have to say, that seem to be either ignorant of those facts or unwilling to face them. I don't know if the Honourable Lady is the first or the second, but I happily give way to her.
I would just ask him if he perhaps would like to correct the record that most people that come in small boats are in fact refugees because the Home Office grants them status. They are not economic migrants. They do not get economic migrant status, they get refugee status.
What we certainly know about them all is they travel through safe countries, in many cases more than one, before they got here and failed to claim asylum. So we know that about them. She's right that we are probably in this country too lax in the way we process claims. Certainly, we offer asylum to more applicants than they do in Germany, for example, in France, for example, and indeed across the European average. We grant a higher proportion of applicants for asylum a successful claim than most other European countries. Now, we know, too, do we not, Mr. Chairman, that the failure to remove these people is costing the British taxpayer an immense amount of money. When I looked at the figures, I was staggered by them. The cost of asylum is now £3.97 billion. It is extraordinary that a single matter should be costing so much, and the need for this bill is justified alone on the basis that we can no longer afford to deal with the level of illegal migration at the scale we are. We simply can't afford for this to continue. We know too that the British sense of fair play is being tested to its limits. The public see this and they are increasingly disillusioned about the apparent inability of the political elite in this country, and we are the political elite, like it or not, and their unwillingness, as I described it earlier, to accept the fact. Now, progress has been made in clearing the backlog, and that was largely the result of the efforts of my right honourable friend for Newark and my right honourable friend for Farrell. During their stewardship of the Home Office, they focused resources on processing claims more quickly and had considerable success in doing so. But the problem is that as fast as we process people, more and more arrive. And so until you deal with the root of the problem, you can never really tackle either the cost that I described, nor the disillusion felt by our constituents. And that's why the Prime Minister pledged, he pledged it, after all, to stop the boats. Now, in order to do so, we need an act that is as effective as possible. And the amendments in my name of my right honourable friend, which I strongly support, would do just that. The amendments 11 to 18 deal in particular with the Human Rights Act. Taken together, they would fully disapply the Human Rights Act 1998 for this bill and the Legal Migration Act 2023, in particular relation to removals to Rwanda. A lot of nonsense has been spoken earlier about rights, and there is a lot of nonsense prevailing in this House about rights. Rights are fundamentally important. We believe, do we not, Sir Roger, in those essential rights which characterise our country. The right to a fair trial, the right to go about one's business freely, unimpaired, the right not to be arrested without cause, the right to vote in free and fair elections. These are important parts of what it is to be British, but they're not, they don't spring from the ether, they're not given. It is a liberal myth that rights are natural. Rights are the product of decent governments in decent places doing the right thing. They are special because we've chosen them, not because they were given to us by some source, some ethereal source. The Honourable Gentleman, who I like and respect, by the way, will know, because he knows Scripture even better than I do, that rights do not get a mention in the Ten Commandments. They don't get a mention in the Sermon on the Mount. Perhaps he can find a place in either of those to contradict me.
I did not mean, but he tempted me. I don't think there is any, and this is not a Liberal thing, I think many Conservatives ought to support this. I don't think there is any case for human rights having any standing whatsoever without some form of metaphysical. He's quite right to say the Bible doesn't talk about rights, it talks about individual duties. If I've got duties to you, you therefore have rights. So I do not believe rights are made up by human beings. I think they're literally God-given.
My opinion of the Right Honourable Gentleman has soared to an even greater heights. I knew he was the best of Liberals, and that's not a great thing to be, by the way, but it's better than nothing. It's better than nothing. And he's confirmed that in that pithy intervention. So the important thing about the amendments 11 to 18 is, crucially, they rule out using sections 4 and 7 of the Human Rights Act. And we know from experience that the good intentions of government, backed up by legislation passed in this place, has been routinely frustrated by what my right honourable friend from Fairham rightly described as activist lawyers. And I would say dodgy lawyers in this country and deluded pressure groups. So it's not just malevolent foreigners, it's malevolent people here too. And the truth of the matter is that the only way that we will affect this policy, and I say this to the Minister, is if we do not allow that kind of gaming of our system, both by those who come here, although I entirely accept that there are amongst them people, of course, who we should welcome. Of course there are people fearing persecution. Of course we should be proud of the fact that we provide a safe haven for people in desperate need. We always have and we always will. But those people who are legitimate applicants for asylum are being effectively compromised by a system that doesn't adequately distinguish them from the very people that I've described as gaming our far too lax system. So this bill is an opportunity to put that right, but only if it's fit for purpose. And the amendments are not designed to frustrate the Minister's intentions. They're not designed to allow the Prime Minister's pledge to fail. On the contrary, they are designed to make his pledge real, to allow it to be effective. For if these amendments are not accepted by government, I fear it will do just that. Fail and disappoint. Fail and disappoint the very people that we pledged we would stop the boats. Now, Section 4 deals with the declarations of incompatibility, and Section 10, as I described it, deals with remedial measures. As it stands, these are not excluded by the bill. That means, unamended, the bill would allow a court to issue a declaration of incompatibility with the ECHR, which would effectively kill the Rwanda scheme. The Minister must know that that is a possibility, at least, we would argue, a probability. But even if it's a possibility, I do have to say to him, why wouldn't he want to exclude that possibility? I happily could work.
I'm grateful to him giving way, and perhaps I could just elaborate on the point that he's making in form of intervention. What is most likely to happen were this amendment not to be accepted by this House is that on royal assent of the bill, someone will bring a case seeking a declaration of incompatibility for the bill. Yeah. That will then go through the courts, and if the Supreme Court were then to rule, ultimately, that the bill was incompatible with the Human Rights Act, it would of course then be up to this House and Parliament to determine what to do. But if the Prime Minister is correct that the government of Rwanda would not wish to be a party to any scheme that was in breach of international law, the scheme would be dead.
Well, my right honourable friend explains exactly the point that I was making. The intentions of the bill are put at risk by the failure to close this loophole. Yeah. And it is just that. It is an opportunity for people to exploit, in exactly the way my right honourable friend, the absence of provisions that would strengthen, or in the Prime Minister's word, tighten the bill sufficiently to avoid such an eventuality.
Will my right honourable friend give way?
I happily give way.
Yeah. All the British people expect is to have real fairness, hearings with real judges. Is not that right? We've been speaking about the European Court of Human Rights. Is it not the case that many appointed to that court, that Strasbourg court, have never even been lawyers?
Oh,
they're not qualified, let alone be judges. Often they're academics, they're civil servants, even politicians, and more recently, as time has developed on, they're human rights activists. These non-lawyers are often guided by NGOs who even help draft their judgments. Yeah. They are what Lord Sumption has described as ideologically committed staff lawyers. Why should we here in this place, we in this wonderful country, be subservient to that quality of some notion of international justice? Make laws here. That's what our people want.
Well, the Honourable Lady in that pithy intervention has described so much of the fundamental problem with allowing what my right honourable friend described as a foreign court with foreign judges from determining outcomes which directly affect the interests of this country.
On that point,
I want to just complete, because the Honourable Lady makes, there's so many compelling arguments in their intervention, I want to deal with all of them and then give way to my honourable friend. Because, of course, there are three things about this, Sir Roger. The first is that our judicial system is not common. It is particular and special, rooted in English common law, but also with a system largely due to the separation of powers, which means our courts are independent from the legislature and the executive. So we have a strong tradition of both judicial quality and independence. Frankly, that's not true in many of the countries of Europe, and I'm happy to give way to my friend who will elaborate.
Talk about the Court of Human Rights in Strasbourg as if it's rather like our own Supreme Court or that of the United States. Yeah. Now, as I said earlier in this debate, I'm on the Council of Europe, so I know exactly how these people are appointed. We in the Parliamentary Assembly, it's the one power that we have, we appoint these judges, and we're given free names, and frankly, we have very little information on who they are, but what is undoubtedly true, and there's evidence of this, is that more and more of them are not, as in our case, really distinguished lawyers and judges. They are human rights lawyers, academics, and what is worse about the process, unlike our judges, they're not appointed by an independent process. The political grouping in the Parliamentary Assembly, dominated by the Socialists and the Federalist Christian Democrats, grouped together to appoint the most federalist pro-European judge.
Well, it is that to which I was alluding. The separation that exists in this country between the judiciary and the legislature, between the political process and the process of justice, simply doesn't apply in a lot of the other countries in Europe, and certainly not further afield. So there is a problem of the politicisation of the court, and there is also a problem, as I also said, of quality, both of which my two right honourable friend referred to. But furthermore, there is an issue of accountability, because the point about law in this country is it's made in this place. And the reason that that is so significant is this place derives its legitimacy from elections, democratic, free and fair elections. We are empowered to make laws in this Parliament because we are accountable, answerable to the people. And as soon as we subsume that accountability into some pan-national arrangement, particularly of the kind outlined in the interventions, my honourable friend, we weaken this House. And by weakening this House, we weaken the people who send us to this House. And it's partly why their view of the world is so at odds with what I described earlier as the political elite. But what I really mean is the bourgeois liberal elite that dominate far too much of the establishment in all its elements.
This is a bourgeois
and
liberal
I
elite.
exclude the right honourable member from Westmoreland because he is liberal, but I don't think he's bourgeois. At least not as far as I'm aware. He's definitely not bourgeois. So the amendments that disapply the Human Rights Act are fundamentally important to the success of the bill. By the way, just as an aside to Roger, entirely relevant to the bill, of course, the Human Rights Act should have been, we should in government from 2010 onwards got rid of the Human Rights Act anyway, because it's a Blair construction through which all legislation, it seems to be now, is seen. It's a very damaging statute which has stymied much of the work of subsequent governments. Now, amendments 23 to 25, taken together, would, as my right honourable friend made clear, prevent the notorious Rule 39 injunctions, the so-called last-minute pyjama injunctions, which emanate from Strasbourg. These amendments will ensure the default position is that Rule 39 indications are not binding and explicitly a matter for ministers. The government's own legal advice made clear that without this amendment, flights may be grounded yet again. Ministers will indeed have the opportunity for exceptions, will not be bound to do so. This bill must be amended so that ministers can disregard Rule 39 orders. We really cannot allow Strasbourg judges to overrule this Parliament and halt flights. Decisions will be taken by those elected in Westminster, not by courts in Europe. It's what the people expect of us. It's what the people demand of us. The bill may block claims about the general state of Rwanda, but will still permit individual claims which will block removal. Unless such individual claims are explicitly excluded, we know that spurious cases will use to frustrate removal, and thus legislation will have no teeth. And the Minister knows that these things go on for days and weeks and months. These cases are never resolved quickly, and the time is short. And so consequently, at very least, surely the government would acknowledge that the flights that they regard and we regard as a necessary part of dealing with the scourge of illegal immigration will be delayed. The amendment in the name of my honourable friend will block individual claims, suspensive claims, limiting such claims to exceptional circumstances. Now, there are circumstances where perhaps a seriously ill person who can't travel should be accepted. And I think most of us would, well, all of us, I hope, would agree with that. But those will be rare cases. The Home Office has already correctly excluded families, children and pregnant women. Such exceptional circumstances are incredibly unlikely, given what I've said about the profile of those people arriving in small boats being overwhelmingly fit men under the age of 40. Sir Roger, this is the third migration bill in recent times. It's our third and final chance, as other speakers in this debate have said, to deliver on our promise to the British people to stop the boats and control our borders. If we fail to strengthen the bill in the way the amendments I've outlined do, it will simply not work. If we fail to make this bill work, if we fail the British people, we will have broken our promise to them. Thousands more people will make risky journeys in perilous conditions. Our hotels will remain full with those awaiting judgments of enormous cost. The British people will regard this as a failure which is rooted here, in this House and in this government. Now, the Minister is a good man, a diligent Minister, who I'm sure understands the thrust of the arguments that have been made in this House today. Because he will know that in the end, this is about a fundamental crisis of democratic efficacy, the ability of a nation state to deliver for its people. The greatest Conservative Prime Minister of all time, Benjamin Disraeli, said justice is truth in action. And this issue is a matter of justice, legal justice and social justice. And it is for that reason that the British people want to see the boat stopped. They simply regard it as unjust that our borders are being breached with impunity. For if the elected government of the United Kingdom cannot remove people who arrive here without permission to be here, then a more troubling and profound question must be asked: who governs our country? My constituents want the government they elect and the parliament they voted for to determine who governs Britain. Only by improving this bill and by delivering the Prime Minister's mission of stopping the boats can we assure that we answer that question.
Well done.
Johnson. Thank you, Sir Roger. This has been a very interesting committee stage of this bill. We've ranged from the metaphysical to MPs feeding each other baked beans to a constitutional tour of the history of Scotland to the case of John Hurst, who lived in Hull, who put an axe through his landlady's head, went to prison, and then fought a campaign to get rights for prisoners to be able to vote. And we've had that discussion about that particular way that we've dealt with the prisoners and their right to vote issue in the past. We've also had a lot of criticism of lawyers. And I have to say, some of the best speeches we've had this afternoon have been from lawyers in this chamber, actually. And I don't know whether they'd be counted as lefty lawyers, but they were certainly sitting on those benches over there in the majority of cases. I'm very conscious, Sir Roger, this is this isn't a second reading speech, but I do just want to refer the House back to the report that the Home Affairs Select Committee produced 18 months ago when we were looking at small boat crossings. And what we said in that was, there is no magical single solution to dealing with irregular migration. Detailed, evidence-driven, fully costed and fully tested policy initiatives are by far most likely to achieve sustainable incremental change that deters journeys such as dangerous channel crossings. We also said to the government that their number one issue they needed to address was the backlog, and I am pleased that there has been some progress in dealing with the backlog. I think they've now got a backlog of about 90,000 still to deal with, but that's an improvement of where we were last year. However, I want to now deal with the amendments that are before us this afternoon. I want to speak to amendments 11 to 18 and 23 to 25 tabled by the Right Honourable Member for Newark. And I am concerned about these amendments because I think if they were to be accepted, they would put the United Kingdom on a collision course with international law. I also want to speak to amendments 36 and new clause 7 in relation to the issue of the costs of the Rwanda policy. So turning first of all to clause 3 of the bill, which disapplies the Human Rights Act, amendments 11 to 18 would extend this disapplication of the Human Rights Act, thereby extending the permission of this bill, that this bill grants, to public authorities to act in ways that are incompatible with human rights. And Amendment 11 and 12 specifically appear to extend the disapplication of the Human Rights Act to anything done under the Illegal Migration Act that relates to the removal of a person to Rwanda. And this could potentially include that person's detention and the treatment prior to their removal, meaning that not only would no legal challenge be possible under Amendment 22, which we discussed yesterday, of course, but also there would be no specific legal obligation on public authorities to act in compatibility with human rights. And extending the disapplication of sections 2 and 3 of the Human Rights Act to all immigration legislation as it relates to a person's removal to Rwanda under the bill or the Illegal Migration Act does raise serious concerns over unforeseen consequences and unintended human rights violations. And it should also be noted that amending the bill to disapply Section 4 of the Human Rights Act, something that has never been done before, doesn't actually have any clear legal purpose. It would simply prevent the courts telling the government and the public their view on the law. Now, because the Secretary of State has already said on the face of the bill that he is unable to say that the bill is compatible with convention rights, so no one could reasonably presume that a statement of the same from the courts, were it to be made, would have any impact at all. So that's why I'm querying those amendments. Now, I do want to turn to Amendments 23 and 25, which the former Immigration Minister opened the debate with at the start and talked about, I think, taking the pin out of the grenade at that part of the debate. So Clause 5 of the bill concerns interim measures excuse me, from the European Court of Human Rights. And it states that it's going to be for a minister, and only a minister, to decide whether the UK will comply with these interim measures. So can I, at this point, again, just pay tribute to the Chair of the Justice Committee and the Chair of the Joint Committee on Human Rights for their very clear explanation of the current situation around these interim injunctions, and setting out very clearly how the United Kingdom has what our involvement with that court is, and our long-standing commitment to that court, and also for setting out that there is a review at the moment around those interim injunctions, which I think is very helpful. But just turning now to the amendments 23 to 25, they would actually stipulate that interim measures from the European Court of Human Rights, the so-called pyjama injunctions, which halted the removal of the asylum seekers to Rwanda in 2022, are not binding on the UK and have no effect on a person's removal to Rwanda. Now, although the amendments allow that a minister may choose not to remove someone where interim measures have been indicated, Amendment 25 makes amendments to existing provisions on the treatment of interim measures in the Illegal Migration Act, designed to make clear that the Secretary of State, immigration officers and the courts must not have regard to interim measures in relation to removals to Rwanda. So these interim measures are made, as we've been discussing this afternoon, under Rule 39 of the European Court of Human Rights, their rules of procedure, and therefore do not form part of the text of the convention ratified by the UK. However, the court, which is the body that determines the meaning of the convention, has held consistently that failing to comply with interim measures amounts to a breach of Article 34 of the convention itself, the obligation not to hinder in any way the right to bring claims before the court. Therefore, any decision of a minister not to comply with interim measures would be inconsistent with the UK's obligations under the European Convention on Human Rights. And the legal advice that the Home Affairs Select Committee has received is that the amendments before us this afternoon would therefore put the UK directly in conflict with the European Court of Human Rights. And worryingly, there are also reports today in the media that the government is considering amending the Civil Service Code to require civil servants to ignore interim measures from the European Court of Human Rights, something that the General Secretary of the First Division Association has described as madness. But it is also quite interesting to observe that there may be some synergy here with the Minister now in the Home Office and his approach, because I understand that when he was in a different position, I think Solicitor General, he backed the Attorney General in the Attorney's advice stating that ignoring a Rule 39 order would breach international law and that the government should not even indicate that it would refuse to comply. If I can now just turn to Amendments 36, New Clause 5, New Clause 7, these groups are around costs, and I want to look at the aspect that's missing from the bill, and I think deserving of some scrutiny, that is actually how much this policy will cost. I also want to speak to particularly the amendments because of what's happened recently in terms of the Home Affairs Select Committee and the Public Accounts Committee and our attempt to find out about the cost of the Rwanda policy. There's far too much that we don't know about how much this policy will cost and how much taxpayers' money is going to be spent, which is why I believe that New Clause 7, which requires the Secretary of State to promptly notify Parliament of any payments made under the Rwanda Treaty, does have some merit, and I hope the Minister will look carefully at that amendment. It's for this reason that Amendment 36, requiring the publication of a full impact assessment on the costs involved in removals to Rwanda and the publication of the financial memorandum signed with Rwanda, also, I think, carries great merit. So as I was just saying, the Home Affairs Committee and the Public Accounts Committee have found it very difficult to get basic financial information from the government on the Rwanda scheme. And that's why I also believe that New Clause 5 is worthy of the Minister's careful consideration as well. Now, New Clause 5 would place the Monitoring Committee for the Rwanda Treaty on a statutory footing, and that would enable greater oversight of the implementation of the treaty and, crucially, ensuring that Parliament can do its fundamental job of scrutinising government policy. As the Home Affairs Select Committee spelt out 18 months ago in our report, which I quoted from earlier, dangerous channel crossings are only going to stop when we've got that evidence-driven and that fully tested policy initiatives that I talked about, and that there is proper costing for that. And it seems to me that's plainly not the case at the moment. And it is crucial for us not only to deliver that policy, but in working to stop small boats, but more widely to ensure the responsible and effective use of public money. And it is really important to remember that the Permanent Secretary at the Home Office, when the Rwanda scheme was announced, required a ministerial direction from the Minister, the Home Secretary, to actually implement that policy, as the Permanent Secretary judged, and he still does actually today, he still holds this view, that there was no evidence that the scheme would constitute value for money. There was just not the evidence available. So on that basis, you might consequently expect that the government would be very keen to demonstrate exactly how much it's spending of public money to allay fears that the money isn't being well spent. But I am just very concerned about the position that the government have got itself in. We still don't know how much will be paid to Rwanda in the final 2 years of the Migration and Economic Development Partnership, or what the cost of the per-person cost of relocating an individual to Rwanda is. And the most substantive update we've received recently on the cost of the scheme came about by accident, because someone apparently mucked up and published details in the International Monetary Fund's board papers. So indeed, we found out about that unwitting disclosure in a similarly haphazard way, with a late-night letter from the Permanent Secretary to myself and the Right Honourable Member for Hackney South and Shoreditch, the Chair of the Public Accounts Committee, which he then posted on the Home Office website. So it appears that in Rwanda, they are able to find out exactly how much money the British government is paying for this scheme, but British MPs are not allowed to have the same information made available to us unless it's disclosed in documents seemingly by mistake. So what we do know, of course, is that following the £140 million paid to Rwanda in the financial year 2022 to 23, there was an additional payment of £100 million in April 23, and a further £50 million will be paid in the 24-25 financial year. But as I've said, the deal with Rwanda is 5 years, and the government is still not willing to tell us exactly how much is pledged in those final 2 years. As for the money paid to Rwanda already, we now do have some information, and I'm grateful from the Minister on the Treasury bench that he was able to provide us with some information in a letter which the Home Affairs Select Committee has published today. So it sets out the 120 million. It says 39% was spent on education, 21% on infrastructure, 19% on job creation, 13% on health, 5% is for agriculture, and 3% is for ICT. So we know that the government have also pledged to pay Rwanda a certain amount of money in relation to each asylum seeker removed there, but yet again we don't actually know how much that will be. And we've all been able to, all we've been able to glean from the Home Office is from their economic impact assessment to the illegal migration bill when it was going through Parliament. I think it came out right at the tail end actually, in which they estimate the cost of relocating a single individual seeking asylum to a third country, that is Rwanda, would be £169,000 per person, which we are told represents an additional costs incurred relative to processing an individual through the current migration system. And I understand from previous immigration ministers that the cost of processing an individual in the United Kingdom is around £12,000. So there's quite a differential there between £12,000 and £169,000. But it's not just those core costs that we are not clear about. There are multiple layers of other possible, probable and prescribed payments involved in the delivery of this policy that we've not been given any detail on. For instance, the treaty with Rwanda establishes this new appeals body for individuals applying for asylum, which will be staffed by judges from, we are told, a mix of nationalities. The question then is, will the United Kingdom be paying for this new international appeals body and paying for its staffing? And if so, how much will that be? And the treaty also specifies that any person sent to Rwanda will be entitled to a permanent residence permit. This deals with the issue that the Supreme Court were concerned about in terms of refoulement. So this means a person will stay in Rwanda even if their asylum claim is unsuccessful. But what we don't know is what the financial implications of that are for the British taxpayer, what payments will be paid, if any, to the Rwandan government in connection with those unsuccessful asylum applications. The treaty also specifies that initial asylum decisions will be made by individuals who are appropriately trained, and for the first 6 months no claim will be rejected unless advice has been taken from a seconded independent expert. So will the UK be providing any additional money to Rwanda to train these decision makers and employ these independent experts? The treaty also guarantees free legal advice to claimants during the asylum process. So will the UK be making any payments to Rwanda to back up that guarantee? Again, we've not had anything from ministers to tell us this basic information to enable us to effectively scrutinise the policy. And that's also before the announcement in the written ministerial statement yesterday, where the Lord Chancellor set out that there would be 150 lower-level judges appointed to the upper tribunal in the United Kingdom to hear appeals quickly to enable, I think, concessions being given to people, members on the opposite benches who were obviously very concerned about the number of appeals that might flow from this bill. So again, I did hear the Minister on the news this morning being asked about the cost of the 150 judges, and he wasn't able to say what that cost was. So again, that's another factor that we need to look at when we're looking at the value for money of this policy. So given the failures that I've talked about to have that transparency, and I have to say the resistance that the Home Affairs Select Committee has come across, and also the Public Accounts Committee, to getting more details on the cost of the Rwanda scheme, I think Amendments 36 and New Clause 7 are very helpful to Parliament in getting that information. I think those are the main points that I wanted to raise today, but I do want again to reiterate that a huge amount of political capital and time and parliamentary time is being spent on this bill, and what we do know and what the Home Affairs Select Committee said 18 months ago is that we still do not have the evidence that this bill will actually do what the government think it will do, which is to deter people from getting in small boats and crossing the channel. So there is a huge amount of resource going into this, and as I started off by saying, there has to be a range of initiatives to deal with illegal migration. There is no one magic policy that the government can use to stop the problem we have with the small boats. And I hope that ministers will take that into account in their closing comments.
David Simmons.
Thank you, Sir Roger. May I start by drawing the House's attention to my entry in the Register of Interests. The Ruislip, Northwood and Pinner constituency is a part of North West London which has been shaped by generations of refugees, starting particularly in the period around the Second World War with large numbers of European Jews fleeing persecution and successive waves of people coming from across the world, finding refuge and becoming part of our community, and understandably had a lot of views to share about not just this Safety of Rwanda Bill, but also previous legislation that we've had about the issues of migration. And whilst, Sir Roger, I'm going to focus my contribution on the amendments which are particularly around the role of the European Convention and the European Court of Human Rights, it does seem to me that in a debate which has at times become quite philosophical, there is a wide recognition that shared sovereignty is often, in practice, for our constituents, greater sovereignty. That I'm a big fan of those fine British philosophers, Hobbes and Locke, who talked about the social contract. But it's very clear that it is when we work very closely with our neighbours that we achieve the most effective measures against widespread illegal and irregular migration flows. We've already seen effective work with the French authorities to tackle the activities of some of the gangs in northern France that has contributed to bringing down the numbers coming across the Channel. So, Roger, I'm going to attempt in my contribution to add some further evidence to our deliberations in a way that I hope will help to encourage ministers and to emphasise my support for taking forward this bill in its unamended form, as I know the government seeks to achieve. And when we look at the role of shared sovereignty, there are many, many examples, well beyond that of the European Court and the European Convention of Human Rights, that have a significant bearing on this issue. We look, for example, at the United Nations Convention on the Laws of the Sea, which sets out the responsibilities that the United Kingdom and others have in the English Channel in respect of refugee boats that have frustrated the views of past Home Secretaries about how we might specifically tackle that issue. But we've yet to see a great deal of debate in this chamber about why we should repudiate the United Nations Convention on the Laws of the Sea, despite the fact that the International Maritime Organisation is based just across the river. The International Tribunal that deals with it is based in Hamburg. It could similarly be described as a foreign court. And indeed, our own Judicial Committee of the Privy Council acts as the Supreme Court of Appeal for a number of countries and jurisdictions around the world that are not part of the United Kingdom and that are not subject to UK law. And indeed, despite the fact that both the European Convention and our own law prohibits the death penalty, that committee of our own Privy Council, drawn from parliamentarians in the United Kingdom, has heard appeals such as the Chandler case of 2011 regarding the death penalty in Trinidad and Tobago. So it's very clear that there is a long and established history of nations coming together to establish international conventions, processes and tribunals to administer the law in the interests of both our harmonious relationships with each other, but also the longer term and greater benefit of our citizens. And in respect of this particular problem, it's very clear that the work that was done by the late James Brokenshire when he was the minister dealing with illegal migration to secure, in particular, the ports and the railheads in northern France has contributed to the problem that we face today, in that the people smugglers have nowhere else to go other than the small boats, which this bill aims to stop. Now, a good deal, Sir Roger, has been said about the best way in which we can deal with the role of the European Convention of Human Rights in the operation of this bill and other matters arising from it. Now, we know, Sir Roger, that the ECHR is a very, very broad organisation. It came into being after the Second World War, as we've heard. And my argument for why we should reject the amendments to its role, and in particular those around interim measures, is that we already have a very extensive series of levers which we can exercise in order to shape it. And indeed, the reason why those interim measures exist is not merely because judges in the court have decided that they would like to have them, but because parliamentarians from the UK and other member states and other politicians and ministers and governments have argued for that court to take on a greater role over the years in response to the challenges, and some of those that we've seen, for example, have affected British citizens. They've been caught up in the conflict in Ukraine, where those interim measures have potentially influenced the safe return of those people to the United Kingdom. We have the Council of Ministers, the directly appointed members of our government who sit together and determine what the priorities of that convention and that court should be. We have the Parliamentary Assembly, and it's worth remembering at this point, a good deal has been said about the role of the judges. The judges of our Supreme Court here in the United Kingdom, and indeed our entire judicial process, is completely free of political interference. The judges of the European Court of Human Rights are directly elected by parliamentarians from their member states, and indeed the legal committee of the European Convention of Human Rights of the Parliamentary Assembly is chaired by the member of Christchurch, who I'd hardly describe as a bourgeois liberal. So I think, like the member for Bromley and Chislehurst, the characterisation of it as a foreign court is no more accurate than it is to say that the International Tribunal of the Law of the Sea is a foreign court, or indeed that our Judicial Committee of the Privy Council is a foreign court, when it is dealing with matters at the request of other jurisdictions, which it does on a very regular basis. And having served on the Congress of the Council of Europe, which is the local government element, which looks at how those laws are handed down and implemented in practice, it's very clear that we have a significant number of diplomatic and other levers which we can exercise if we feel that the court needs to move its practice in a different direction. And it is also clear that the court has already begun that process in the light of comments from the United Kingdom and others. So my argument, Sir Roger, is that it is in our interests, because it benefits our citizens and our country, to maintain our membership of the European Convention of Human Rights. It underpins so much of our positive influence in the world, and it gives us the moral authority to ask others to do things, that we maintain our active support and membership for that organisation, but that we seek to address these issues using our elected members of this House who sit in those assemblies, our elected politicians who sit in other assemblies like the Congress, our academics and appointees who sit in bodies like the Venice Commission, which advises on the gold standards for the conduct of elections, that we use all of these levers that are at our disposal to convey our views to the court and to the convention organisations about how we should proceed. And in respect of the judges themselves, it was very positive to hear from other members who've been part of that process, because we know, and I'd say contrary to sometimes what has been said, that there is a two-stage process, that for someone to be a candidate to be a judge, they have to meet the requirements for international judicial appointment in terms of both legal qualifications and relevant experience. They are then put forward for election by the politicians who place them on the court. And their decisions, certainly in respect of the so-called pyjama injunctions, seem to be very little different from those which magistrates like myself and others across this country will be asked to take on matters of judicial warrants. That you are asked to make a decision to enable an intervention to happen at a moment of urgency, and then in due course there is a longer period of opportunity for that to be considered by the courts and all the other authorities that may have a stake in it, of course.
I'm very grateful to the honourable gentleman. I'm so pleased that we are having this very clear explanation about the court and the judges. After what's been said this afternoon, it's just very refreshing to have this. And can I just thank the honourable gentleman, who I also think is a lawyer. And I don't know if he's a lefty lawyer, but he's a lawyer, I think.
Well, I'm grateful to the member of Kingston upon Hull North. I'm not a lawyer. I served as a magistrate in this country, but it's always my pleasure to say I belong to that even more despised race of human beings than Tory MPs, and that I was formerly a banker. But so just turning, Sir Roger, to a conclusion. I do think that in respect of what is said in the bill and in the amendments around the Human Rights Act, we are right to have some degree of concern about that. And this House needs to strike the correct balance. It is a fundamental principle of British justice, which dates back at least as far as the Saxons, that people may not be subject to a penalty unless they've had the opportunity to be brought before a court, a properly composed judicial authority. And therefore we should be concerned at the idea that in the United Kingdom we would exempt a group of people from access to our law on the basis of the method of their arrival in the United Kingdom. However, we do need to balance that against the fact that people are dying in the English Channel. They are drowning in cold water. Gangs are profiting from that hugely, which is fueling all kinds of other types of crime. And to an extent, we are a victim of that previous success in that the improved security in northern France has created and massively exacerbated the problem that we face today. And that, for me, is the thing that balances up the risk to a loss of human rights. That we need to ensure that we have that really effective deterrent in place to address the problem that has arisen out of that earlier success. Sir Roger, it is and remains my view, and I've expressed it in the debates about the previous migration bill, that the point at which we will establish full control of our borders is the point at which we add an asylum visa to all the other types of visas that we have. So that there is a single safe and legal route controlled by the British government under rules set by this House. And if you arrive on our shores to claim asylum without having gained that permission first, then you are automatically ineligible regardless of your method of arrival. And that would mirror the process that we already have in place for people who want to come and work, to come and study, to come and marry, to come and invest here in the United Kingdom. And it seems to me that we still have not yet put in place that effective process and system that would enable us to do that. But it is clearly crucial, as the weather will begin to improve soon, the smugglers will be looking to invest in their stock of boats, and more people's lives will soon be put at risk, that whilst we keep our eyes on the objective, that is to return to something more like the Syrian Vulnerable Persons Relocation Scheme that's required or described by the UNHCR as the gold standard for international refugee resettlement, that's the model on which we've based our Afghan resettlement scheme, whatever logistical problems that experienced, that this House has recognised as the way in which the United Kingdom wishes to play a part in refugee resettlement around the world. But we need to ensure that we deal with the specific problem that arises of small boats in the Channel. And it seems to me, for all the debates that we've had, for all the well-intentioned arguments, that the bill in its unamended form strikes the best balance that we have available to us to address that particular problem and ensure that no one else dies on a route to seeking asylum here in the United Kingdom. And for that reason, I will be supporting it unamended tonight.
Alison Foulis.
Thank you very much, and it's actually a pleasure to follow the honourable member from Ruislip, and it's refreshing to hear somebody from the Conservative benches talking up the merits of an asylum visa, because it is something that would break the model of people smuggling gangs, because it gives people a safe and legal route. It gives them that safety and certainty. Nobody need pay over everything that they own and be exploited to get on a leaky dinghy in the Channel if they were able to travel like any of us were able to travel to come here for safety and for sanctuary. And I understand from other people in this House that the Conservative benches are quite keen to wind this up early tonight, because apparently they are going to a burn supper. I'm not sure if this is true or not, but it's certainly a rumour that I heard earlier. So I would give me some thought, certainly, and I am a big fan of our National Bard, of some of the things that Robert Burns might have to say to the Conservative Party and the way in which they conduct their business. And I think I might start with man's inhumanity to man makes countless thousands mourn. I move the amendments standing in my name of those and those of my honourable colleagues, and commend to the House those standing in the name of my colleagues from Glasgow North and Edinburgh South West. And I wish to start with clause 3 on the disapplication of the Human Rights Act. Now, the Human Rights Act 1998 was landmark legislation. It is woven into the fabric of our devolved institutions. It underpins the Good Friday Agreement, and it should concern us all when a government without any kind of mandate starts to pick away at the stitching. The Law Society has said that the exclusion of the Human Rights Act to this extent is unprecedented. And thinking of Robert Burns and defending the rights of people to migrate, he had a verse, he has a verse on just about everything, but he has a verse on the rights of Highlanders against their lairds who were not allowing them to then migrate to Canada. He said, "They and be damned, what right had they to meet or sleep or light or day, but far less to riches, power or freedom, but what your lordships please to gie them." And we should give asylum seekers far more than this government thinks they have a right to give them. Disapplying Section 6 removes the obligation for courts and immigration officials to take into account human rights when assessing the safety of Rwanda. Disapplying Section 3 limits the protections courts can provide. Disapplying Section 2 forces courts to ignore any rulings from the European Court of Human Rights that Rwanda is unsafe. These are important protections. They ensure people's safety, not just from government, but they are a check quite specifically on the Home Office, a Home Office which we know has long and consistent form in making serious mistakes which have long-lasting and life-changing consequences. One only needs to reflect on the legacy of Windrush, TOEIC and the highly skilled migrant scandal to know the scale of Home Office incompetence. And we need the courts to offer protection against the Home Office's instinct to deport first and ask questions later. Amendments 11 to 18 in the name of the member from Newark make an already unjustifiable situation much, much worse. Liberty have stated that these effectively remove the possibility of securing any, much less an effective, remedy for breach or threatened breaches of rights arising from removals to Rwanda on the basis that it is an unsafe country. And when Robert Burns, in his Slave's Lament, said, "Torn from that lovely shore and must never see it more, and alas, I am weary, weary, oh," I think we all feel that weariness at the government and the circularity of these ridiculous arguments. It is unsafe for refugees who get to come here from Rwanda, but somehow it is safe enough for us to send people to Rwanda where they will be in safety. It makes absolutely no sense. And this moving of Rwanda to people, for people against their will by this government, I would say, is nothing but state-sponsored people trafficking. This government is now, in effect, a criminal gang moving people across the world. People moved against their will, with no regard to their safety, no recourse to appeal to a country they do not know, involving money and profit. Well, that sounds like people smuggling to me. Those in the benches opposite either can't see this, or they frankly just don't care. Because to them, these aren't really people that we're talking about here. They never have to see them, they never have to engage with them, they never have them crying across the desk in front of them at a community hall on a Friday. It is utterly despicable. Moving to Clause 5 on interim measures of the European Court of Human Rights. Now, interim measures are important and, according to the Court's well-established practice, apply only where there is an imminent risk of irreparable harm. Clause 5 expands on the previous provisions of the Illegal Migration Act to ignore interim measures. Now, these things that we've passed under the Illegal Migration Act are not even yet in force. It's an act that I mentioned yesterday. It's only 181 days since it got royal assent, but here we are this afternoon legislating yet again. And interim measures exist not just in international law, but also in our own domestic law. And often, as the Honourable Member for Edinburgh South West said, often they happen late at night. That is the nature of these things. They are last-minute protections for people who have no other recourse and no other remedy. They are not unusual, but refusing to comply with them, as this legislation sets out, and as the member for Newark's amendments demand, would be a clear and serious breach of international law. No mere technicality here, a serious breach of international law. So where does this leave us with the government of Rwanda, whose minister has been quite clear on the need for this agreement to be compliant with international law? And indeed today, the President Paul Kagame said to The Guardian there are limits on how long this can drag on, and he would be happy for this to be scrapped entirely. The government is on very, very shaky ground here, and is the Minister and the member for Newark really going to have us believe that we can cross our fingers behind our back and nobody will know that the UK government broke international law? They are having us on. And what is particularly daft about this measure in the legislation is that the European Court of Human Rights has already responded to the concerns that the UK ministers have made. In November last year, the European Court of Human Rights provisionally adopted amendments to Rule 39 of its Rules of Court and the procedure for interim measures, tightening up in the circumstances and the procedures. They're also changing the procedure that member after member howled about earlier on, so that judges are no longer anonymous. I don't know whether in the amendments that they're making they're going to be able to be forced to disclose their preferred nightwear, but I think that's perhaps a matter of discretion. The grievance that the member for Newark and the UK government and the backbenchers howl about is being addressed. So that makes this bill even more of a waste of everybody's time, money and energy. And what damage does it do to when the UK government continues to behave like a petulant child rather than engage constructively with the international organisation of which it is a part? It sends a judge to this court. It is part of this process. It's not somebody else's court, it's our court. We are part of it. Furthermore, placing all decisions on compliance with an interim measure in the hands of a minister is a deeply worrying suggestion, far less appropriate than a court. And maybe the minister will also be in their pyjamas as they sign off a batch of human cargo in the dead of night, but as presumably it's a British minister in Union Jack pyjamas rather than a European judge in a blue onesie with yellow stars, members opposite will probably think this is perfectly acceptable. They care more about flags than about rights, and they have the cheek to call us nationalists. Deliberately breaching international law is no longer a situation we need to assume that a minister of this particular government would in any way hesitate to do. The Law Society of Scotland have added to the criticism of this power, saying it contradicts the doctrine of separation of powers between the executive and the judiciary. And as the honourable member from Kenilworth and Southam pointed out earlier, there are foreign policy and serious implications of this move. I support the amendment in the name of the member for Orkney and Shetland, and while I appreciate the intention, it's hard not to feel that the amendment in the name of the official opposition is merely an attempt to water this down by having a minister consult with their Attorney General. And given that the member for Fareham was the Attorney General before being Home Secretary and signing the amendments today that undermine human rights, I'm not sure that's the protection that perhaps they think it might be. And I note the various amendments and the efforts of the member from South Swindon and his colleagues to amend this bill, but I think we all know that they are in a hiding to nothing with this. Moving to Clause 8 and the extent clause, the SNP have been very clear indeed, that we do not believe that in this cruel and unnecessary bill, we do not support it. So our attempt to decisively declare that this is not in Scotland's name comes in the form of amendments 4, 5, 32, 33, 34 in the name of my colleagues from Edinburgh South West and Glasgow North, which attempt to remove Scotland from the territorial extent of the bill and require the legislative consent of the Scottish Parliament. As my colleague from Edinburgh South West pointed out earlier on, this has a significant impact on the ability of Scottish courts and the ability of our legal system to work effectively. And we have asked for legislative consent for the Scottish Parliament before this legislation comes into force. It's sky chilly in Scotland today, but I can say to the Minister that hell would freeze over before he would obtain our legislative consent on this bill.
Absolutely.
Moving to Clause 9 on commencement, Amendment 41 seeks to separate the treaty from this bill and ensure that the treaty itself receives the scrutiny it deserves, given the significance of the provisions made within that treaty. And I don't know how many colleagues will have examined the treaty, but I think it is quite right and quite appropriate that this House does so, as the Home Affairs Select Committee has asked in terms of a debate. Moving, because this is the way that this strange process is laid out, I move last to Clause 1. It comes last because, of course, it does in this topsy-turvy world of Westminster. The principle of the bill remains abhorrent to us. International law is not something that states should disregard when it inconveniences them. And again, Burns has an important principle on this. In his letter to Mrs Frances Anna Dunlop, he says, "Whatever mitigates the woes or increases the happiness of others, this is my criterion for goodness. And whatever injures society at large or any individual in it, this is my measure of iniquity." This bill is riddled with iniquity and harm. We rightly call out states who abuse human rights, who ignore their courts, who treat people in a dehumanising manner. There is absolutely no justification for the UK in doing so. It is a bogeyman to distract the public from the chaos that the Conservatives have presided over all these years. Our amendments 39, 40, 42, 43 and 44 seek to assert the importance of complying with our international organisations to abide by the Human Rights Act. It is astonishing that we require to do so But as the bill preface sets out, this bill is very much incompatible with convention rights, and this Tory government wishes to have us carry on regardless. The Right Reverend Sally Foster-Fulton, moderator of the General Assembly of the Church of Scotland, has been among many voices calling out this appalling legislation. She says, this bill threatens to destroy the UK's reputation, reducing our ability to speak with any credibility on injustices and human rights abuses across the world. It also sets a worrying precedent that fundamental human rights can be eroded and denied to some. Now, far be it from me to rush to the defence of the UK's international reputation, but I urge members to consider the wider implications of this cruel policy. It is not domestic, it is international. It has wide-reaching implications. Scotland wants no part of this failed, expensive and cruel Rwanda plan. We look forward instead to the day that we are no longer beholden to this insular and damaging UK immigration policy, to this Parliament that does not speak in our name. We want Scotland to take her place in the world with all the responsibilities that entails in an international community. And to finish again on Burns, for all that and all that, it's coming yet for all that man to man, the world o'er, should brothers be for all that.
Nick Fletcher.
Thank you, Mr Roger. It's been a very, very long debate, and I've listened with intent to everybody who has spoken. I admit to learning quite a lot today. Unfortunately, not everybody who's spoken is still here to listen to me, although I have listened to them, but that tends to be the place tends to happen in this house quite a lot. People speak very, very long at the beginning, and then, unfortunately, they never get to listen to the other people. Now, the lawyers, it tends to be mainly lawyers that have spoken. And I often thought, before I became a Member of Parliament, that maybe this place would be best full of lawyers. That's what it should be about. We're making law. Maybe that's the right thing to do. But I was corrected by the Honourable Member from Somerset. I didn't know I was going to speak of him today, but he told me, no, it's wonderful that people like yourself, Nick, are here. And after listening to what I've heard today, and having listened to what I've heard with regards to the recent post office case, lawyers just seem to be able to talk at this level continually, back and forth and back and forth. In fact, I said with the post office case, there was £60 million apparently given to looking after these postmasters, and 40 million of it was spent on lawyers. What I'm trying to get at is that for all the talking that's happened, the people who put us here are still struggling like mad to understand why, when we put people on a plane, somebody from Strasbourg can say, no, they don't have to go. And we all watch with aghast that this is happening. The struggle to see why it was mentioned in the Telegraph last week that somebody who'd been caught of producing £500,000 worth of cannabis and convicted for it couldn't be deported because he couldn't speak his mother tongue anymore. They can't understand why an immigrant who's taken £8 million from organised crime and tried to smuggle it out of this country, and we can't deport him because of his human rights. Now, human rights obviously are extremely important, and anyone who mentions coming out of the ECHR, it automatically gets lambasted by many people on that side. But unfortunately, the people that put us here can't understand why these things are happening. And we just got to, whatever happens, these judges that we're talking about, that we've supposedly elected, they need to come to Doncaster and they need to come and see what's happening there, like I said in my speech before Christmas. And we should be able to have a conversation like this without being heckled, without, being called like that we have been called out on Twitter and every time we say this, but it's because of the nastiness that definitely comes from the left that stops these conversations happening and stops us being able to have some decent conversations and decent debates that we're having. Now, I've listened to my honourable friends all sat on that back row, and they speak an awful lot of sense. They really do, and I take it on board. But I've got friends on this with me who want to use these amendments to tighten up this bill. And when I hear about what we're trying to do, I have to agree with them, it needs tightening up. Because we can't keep on putting people in a plane and then taking them back off again. We can't keep on letting people come to this country, abuse this system, using taxpayers' money to defend them while we're giving them board and lodgings in hotels next door to schools. We've got to stop this. We have to stop it from happening. So I support these amendments that we're putting through today because I want to help the government. I want to help the government with its promise of stopping the boats. Because if we stop the boats, we stop the tragedies that happen out at sea, where 5 people died. 5 people died last week, and we need to make sure that that doesn't happen again. We need to stop the boats because we are put here by the taxpayers of this country, by my constituents, and we need to make sure that they're getting value for money with every pound that they get taken in their tax. And when we speak about human rights, we have to remember the rights of the British people who put us here. So I will support these amendments because I've got to do whatever I can to make sure that the people that put me here are treated fairly and their rights are considered above anybody else's. Thank you.
Nick Fletcher. I beg your pardon. Sorry, Tom.
Thank you. It's a pleasure to contribute towards this incredibly important debate, and it's a pleasure to speak under your chairmanship as usual. I was very happy to sign the amendments tabled by my right honourable friend, the member for Newark, amendments 11 to 18 and also 23 to 25. I was also happy to support his amendments and also the amendments of my honourable friend, member for Stone, yesterday. I do have concerns about the bill as it currently stands. Of course, I want exactly the same thing as the Minister wants, which is the boats to be stopped, and the boats will only stop if we have a deterrent. I haven't seen an example across the world of this situation being properly dealt with without a deterrent. And it's critically important that we have one. But it does concern me, though, that the exceptionally narrow grounds for individual appeal won't be as narrow, perhaps, as the government hopes, which is potentially why we heard talk about the 150 judges yesterday, which did cause me some alarm. I guess in some respects, why are some of us so cynical on this side of the House? Why do some of us have so many concerns that this may not work in the way that we hope it will? It's experience. It's the fact that we have voted for 2 bills before, the Nationality and Borders Act and the Illegal Migration Act, that we hoped would work comprehensively, but haven't. It is right that the government highlight the reduction in small boat crossings by 1/3. It is right that we do that, but it's nowhere near enough. And we will not be thanked by the people of this country for not smashing it in a comprehensive way. So I will be supporting Amendment 11 in relation to the I won't be giving away in relation to the Human Rights Act. And I will also be supporting my right honourable friend, member of the Newark's amendment on the ECHR as well. I remember vividly the situation in June 2022, where, and I also remember the referendum we had in 2016, where the majority of people in this country voted to leave the European Union. They did so because they wanted the Parliament of this country to be fully sovereign. They did not want it to be frustrated by a foreign organisation, whether that's the EU or the ECHR. So the way in which that happened on the June 22nd, a policy that has majority support for most of the people in this country, I thought was devastating. So more generally, I think it is important that we respect the discussions that happened at second reading, where the Prime Minister said that he wanted sound international legal arguments for amendments. That bar has been matched, and my right honourable friend, the member for Newark, has explained how that's been the case. But fundamentally, I have regretfully come to the conclusion that, as a member of Parliament, I think we should leave the ECHR. And I think in time, my prediction is that we will. That is my prediction. I think many of the debates associated with the ECHR are very familiar with the debates we had around Brexit. Those who originally wanted to leave the EU were branded as extremists and a minority. And I think, and the same arguments are made, let's reform it from the inside. We will try that again with the ECHR, and I think we'll be unsuccessful in doing so. There's a supranational nature to the ECHR that I'm deeply uncomfortable with. We've already seen how it operates. And it's interesting, and some members have said, they've made the point that it's not a foreign court because we've got ownership of it. Well, people made the same arguments about the European Union, about the MEPs going to Brussels. Ultimately, when it came to that decisive referendum, most people who voted on that question disagreed with that view, and we rightly, in my view, left the European Union. But it is not right, and it does open up a serious democratic deficit when we leave the European Union and the principles for why we did are live in this debate today, and we must listen. But I say, on the issue of illegal migration, like on the issue of net legal migration, we're playing with fire here. The level of frustration felt by millions of people in the country is extreme. And the warnings are there across the world about what happens if mainstream parties do not deal with people's legitimate concerns about mass migration. So if a Conservative Party does not, in a responsible way, robustly deal with this and finally stop the boats, the warning signs are there for what might happen. And that is something that I'm very happy to give way.
And just to make that point even firmer, with which I completely agree, does my honourable friend think that the fact that we are, which often isn't mentioned, that we're quite a small island with a huge population and an entire infrastructure which was created in the 19th century, so that for all these reasons we have that much more pressure on our social services, our infrastructure, our planning and so forth?
I think one of the giving way, he's absolutely right. There are intolerable pressures being placed on this country through mass legal migration and also illegal migration. And I think it is right that more and more of my constituents are seeing the link between that issue, pressure on public services, strains on social cohesion, and other things as well. I think immigration at sustainable levels with integration is a force for good. Immigration at unsustainable levels without integration prevents intolerable troubles for the people of this country. And that is something that I want to guard against. I'm happy to give way to it.
Well, I'm very grateful to Ryan for giving way. And that is a view not just held by him or many in this House or many in this country, but across many countries in Europe. Mass migration is now seen as an issue of salience by countries right across Europe and the wider world. So he is far from being alone. He is speaking for the people.
I thank my honourable friend for giving way. We've had lots of arguments about the ECHR today and Winston Churchill forming it. I do not for a moment think that if Winston Churchill was alive today, he would be comfortable with the way in which today's ECHR is operating and the supranational nature to it. I do not think he'd be comfortable with that. That's an argument that has been defeated time and time again, but continues to be wheeled out by members opposite, that I don't agree with. But ultimately, I applaud the Prime Minister's desire to stop the boats. Of course I do. But it's not enough just to try. And it's not enough just to be 80 or 90% of the way there. We need to be 100% of the way there. And we've seen previously, any chinks in the armour of any bill designed to tackle this issue will be ruthlessly exploited. We share the desire of the Prime Minister. We want to work with him to get a bill that we can all unite behind that stops the boat. Immigration isn't just an important issue. I honestly believe it's become existential, an existential issue. And ultimately, it is important that we unite behind the bill, but the bill needs to work. And the question is, do we think the bill works, or do we think it doesn't work, and do we think it can be strengthened? For all of those reasons, though, I conclude my speech today, but I will be supporting the amendments laid by my right honourable friend, a member for Newark, and I will be voting for them with a certain degree of pride, because I believe in the sovereignty of this country, I believe in listening to the people of this country, and I believe in narrowing the unhealthy disconnect there is between the views of the majority of the people in immigration and where we are at the moment. Thank you very much, Mr Chair.
Mark Alongi. Bob Seeley.
Thank you very much. I'm sorry to be a bit late to this august report stage. I want to talk in general about some of these amendments, because I'm very sympathetic to a lot of them, I listen always to what the our right honourable friend from Newark is saying, and I think he is incredibly eloquent on this and also probably very right in some of the things that he says. But I'm also going to explain why I'm not going to support, always eloquent, always right. But I'm going to explain why, despite my concerns about the ECHR, I'm not going to support his amendments and those other amendments, because we are dealing with the art of the possible as well as the art of what is right and wrong. And I listened to the honourable member, my honourable friend from Ipswich, to talk about this in very apocalyptic terms. And I think he is right to say there is a great deal of angst and concern about this. In my patch, like in his, over 50% of people, according to that recent poll, wanted people sent back without a right of appeal. So I'm sympathetic towards that argument. I'm sympathetic to what the honourable member from Newark says about his concerns about the way the system will not work. But we are dealing with the art of the possible. And for me, when the honourable member for Ipswich says we need a 100% system, or we need 100% certainty, not an 80 or 90% certainty, I get a bit concerned about that statement. Happy to give way.
Would my honourable friend give way? I'm grateful to my honourable friend for giving way. Does he recognise that we should be focusing on the practicalities of what are achievable, recognising the tensions on a very broad debate of what we can legislate for and what in reality will work within the limitations and the context, be that from the courts, be that from our colleagues in this place, but what will also work for Rwanda themselves?
Absolutely, and if the Rwandans turn around and say we've changed our minds, we are in a world of pain on this issue. And again, it's a question about, I trust the government, but I think the government has been naive in the past on this. But to work on the basis that we on this side of the House are not going to trust our own government on this and give them zero credit, I think is going way too far the other direction. Now, when it... Yeah.
Sir Roger, my old friend's making a series of very important points. Does he agree with me that one of the reasons why our constituents are concerned to see this bill pass has been the enormous impact that very high levels of migration have had on local government finance? And representing a local authority which is an island, one of the 31 in the southeast of England that volunteered to be asylum dispersal areas, does he agree that other parts of the country might do well to step up to the plate too?
I think he makes a very good point, and I think other countries should do well to step up to the plate. Thank you for that comment. Back to what my honourable friend from Ipswich was saying about an 80 or 90 versus 100% solution. As far as I see, there are 4 options, there are 4 outcomes for today, and I want to discuss them, if I may, in brief detail. Firstly, that this bill works in a wonderful way and everything is perfect. Do I think that's likely? Well, I hope it is. I live in hope. I share... I'm so sorry, thank you. I share his concern that maybe it won't. The option two is that some of the legal appeals work, some of the legal appeals don't work, but we begin to get the planes moving sort of this summer. It's a reasonable success. We are heading in the right direction with other measures. Option 3, it doesn't work. I will give way in 1 second. Option 3 is that it doesn't work. We get some brownie points for trying, but it's a bad outcome. Option 4, we vote down the bill today. There are no flights at all. The left are in clover. The Liberal elite will be smiling all the way to the next election. There will be 100 colleagues on this side of the House return, and there will be nobody to challenge woke. There will be nobody to challenge large-scale illegal immigration whatsoever. I give way to the honourable friend.
I thank my honourable friend for giving way. I mean, I think that what would make the Liberal elite the happiest would be to see this bill strangled in the courts because of its weaknesses. That would make them the happiest. And also, does my honourable friend, does he vote? What does he think about the amendments put forward by my honourable friend, the member for Newark, who perhaps knows his issue better than anybody else?
Makes 2 points. Firstly, about the happiness of the Liberal elites. I think my answer to that is he is giving a subjective opinion about what he thinks they would love. Actually, what they would love most of all is this bill to die tonight. We have to get this bill through to give us any form of chance. Now, 4 options, as I say, that it works perfectly. It may not. Option 2, that it is likely to work in part. We can live with that. Option 3, it fails. That's bad. We are trying. Option 4, we kill the bill tonight. We could all go and look for new jobs.
Exactly.
Right? So that is what we are. That is what we are facing. I want to see the honourable gentleman and many other people returned. But what we need to be doing is to make sure that we give the people the best chance of delivering on this. And the best chance of us delivering on this is to try to push the government in a conservative direction. I give the honourable gentleman that. But once we think the government's gone as far as it can, and I'm on the same side of the argument on this, but I'm different. My differentiation is that I will give them the benefit of the doubt to get this through third reading. We have to get this bill through, even if he doesn't vote against, but he's willing to abstain. At least it will be an improvement. I'd love to give it. Thank you.
I'm very grateful to my honourable friend for giving way. Is it also important that we all note that if this bill is killed off at third reading, there is no other opportunity to bring another bill back to address this issue within this Parliament? So we will be stuck in the current situation going into the elections.
I thank my right honourable friend for that very important point. I would just note that on the WhatsApp group where we were chatting about this earlier, one of our colleagues from the North East posted the idea that we could have a new bill, that a new bill would be written. I'm finding that to be truly living in la-la land, because the idea that everybody on this house, on this side of the house, would agree to a new bill once we've killed this bill is for the birds. It's this bill or no bill. It's this bill or no chance. So I think we have to face the reality. I would also, because my honourable member, my honourable friend from Ipswich, spoke very eloquently about the ECHR, I just want to touch on the ECHR as well, because it's important. I'm not a fan of the ECHR. Our freedoms, our liberties, they're not because of the ECHR. They're not because a Bulgarian judge gets out of bed at 2 a.m. in the morning to strike down democratically elected law. There is nobody in this House who is as willing for me to rewrite our relationship with the ECHR. Now, this bill is not the time to do it. This is an argument for our manifesto. But if he was to suggest to me that what we need to do is to make the ECHR advisory, so we fundamentally change our relationship, that a vote in Parliament can overrule the ECHR, he will find no bigger champion of that than myself. And in the same way that if we were looking to review the Human Rights Act, I'm as bored as him of hearing ministers saying, and they don't really do it in private, we can't do this because of the Human Rights Act. I pull my hair out. We're in government. We should be changing the Human Rights Act if we don't like it. We shouldn't be using it as an excuse for inaction. Yeah.
Thank the honourable member for giving way and listening with interest to his points. As one of the people who actually would be seen as the architects of the Rwanda scheme, along with the member for Corby and the right honourable member for Witham, I would have preferred to see this bill with the member from the member for Stone. And I hear many of the points made by my honourable friend from Newark. But whilst I would prefer to see it go further, it was a bill that could still work.
I agree. Thank you, sir. If there was, I thank my honourable friend for his comments. If there was a chance for moving further, yes. But I don't think there is. And I think the issue is it's this bill or no bill, and it's this bill or no chance. So to come back to what my honourable friend from Ipswich was saying about the ECHR, yes, I accept what he's saying, and I agree with it. So let's reorientate our relationship with the ECHR. Let's reorientate our relationship with these European laws. Let's look again. I don't like judicial activism any more than anyone else on this side of the House. Judicial activism is the enemy of democratic accountability if you have foreign judges who are willing to get up in the middle of the night and overrule law passed in this House by this democratic body, answerable and sovereign to the British people. So let's talk about changing the ECHR, but we should not be doing it now.
Will you give way? On precisely that point, isn't there a further addition to his argument, which is a practical one? which is that overriding the ECHR in this instance, as opposed to following a broader debate, may lead to the Rwandan side being less enthusiastic and pulling out from the deal, and therefore practically sending us back to square one.
I thank my honourable friends, right honourable friend for that intervention. It's good to see him. So thank you very much indeed. Personally, when it comes to, I think they're called Amendment 39, if I understand correctly, the pyjama amendment, where judges get out of bed in the middle of the night to strike down democratically. I don't even know why our government is still agreeing to abide by these amendments, because as far as I can see, it should be a matter of principle that Amendment 39 amendments are advisory until such time as we wish to adopt them. So I don't even know why the government, maybe the government has some movement or something that it wishes to tell us about on Amendment 39. It would be wonderful if they did. But as part of this conversation, and I think we are in a period of flux as our electorates rightly become more concerned about issues related to crime, about issues related to sovereignty, about issues related to legal and illegal immigration, we start to talk about our relationship with the European Human Rights Conventions. I'm up for that, but now is not necessarily the time to do that. One final point, if I may, sir.
I'm grateful to my honourable friend. He's making an extremely important point. And before he moves on to the last part of his speech, I want to press him a little bit further on the ECHR and the elements that he's commented, as well as the comments made by my honourable friend from Ipswich. Does he recognise that some of the fundamental changes that have been asked for in some of the amendments this evening are so great that they in themselves warrant a separate piece of legislation, even if they were to come forward, so that this House could consider them in full and in detail, rather than being attached onto an extremely important bill in itself, and where they could undermine the objectives as well as detract from the wider debate that they're trying to make in terms of the ECHR?
I thank my right honourable, thank you, sir. I thank my right honourable friend very much for that point. I quite agree. I think we're in danger, sir, of reverse engineering a whole load of opinions on the ECHR into a single bill, which is influenced by the ECHR, but is fundamentally about something else. I would like to see greater debate about the ECHR. I would like to see greater debate about the relationship between our laws and what we do about international conventions, being mindful and being respectful of them, whilst at the same time understanding that our freedoms, our privileges, our rights as Britons, for me, do not come from post-war European documents. We should remember where the ECHR came from. It was effectively written in part by ourselves to help Europe recover from the appalling destruction caused by fascism, but also the threat of totalitarian socialism and totalitarian communism. Since then, we've seen what was a good document. In part, it was a good document, sir, because it was written by ourselves to help Europe recover, to help get its legal and political dignity back. What we've seen is that it's been a target of politicised judicial activism. And I believe something which is the target of politicised judicial activism should not necessarily be overruling our own traditions. And there, I do find a tendency.
Sir Roger, the honourable member for the Isle of Wight is once again making some very powerful points. Does he recognise that the number of interim measures that are handed down in respect of the UK is extremely small? In fact, in some years there are no interim measures that are granted in respect of the UK. But that nonetheless, we do need to review the way in which measures which are not specifically described in the original documents that underpin the ECHR have evolved. And therefore it is right that, although it remains absolutely something which is non-binding and a decision for a government minister how to respond to those, that we need to ensure that our courts and our system understands the role that Parliament expects them to play.
Thank you, Sir Roger, and I again thank my right honourable friend. I think he makes a very valuable point, and one that I was just about to come on to. Why is it that some people in this country, some political groups, generally on the left, idealise international courts as if they are great fonts of wisdom, when for me, a lot of their judgments are highly political, highly tendentious. They seem to be studied disrespect. They are a sort of an exercise in studied disrespect of the English common law, which for me is one of the great wonders of human civilization and human achievement, Sir Roger, along with monotheism and one or two other things. That these things are extraordinary achievements, and we seem to allow these international courts to overrule them as if these international courts are great fonts of sort of Olympian wisdom, when all these sort of great judges from on high, who frankly do not come from traditional judicial systems and judicial traditions anything like as strong or as noble of ourselves.
Would I give way? I've been agreeing with the basic thrust that it's this bill or nothing. But can I just say to him gently in relation to the European Court of Human Rights, for example, that if he looks carefully at the case law of the European Court in Strasbourg, British common law traditions have in fact had a significant impact on the jurisprudence of that court. It does not follow the pure civil law system of the continent. Those who've served on the Parliamentary Assembly of the Council of Europe will know that. And actually, it's moved to a hybrid system, largely because of the influence of British jurists.
I thank my honourable friend, and he makes an excellent point, and considering he's an eminent lawyer, and I frankly am not. Time left. There's time left. I am, Sir Roger, tempted to say I will stop digging, but I would just say one point in my answer to my honourable friend, Sir Roger. Yes, I accept that point, and I think he's absolutely right that we have had an influence. But it is also, for me, that I have, from what I've seen and read, there has been an influence also of a far more rationalist system on our own common law. And I do not find the impact on EU law and EU casework on our system to have been entirely beneficial and entirely helpful.
I'm glad he's making this point because, and I don't blame him because it's easy to align the two. EU law and the operation of the Luxembourg court is a very different discipline from Strasbourg. That court is enjoined to interpret EU law, and what it says is gospel, and we have to follow it. That's not the case with Strasbourg. When he talks about the case law, you know, I'm not going to put him on the spot too much, but name the cases that actually are the problem. Where are they? I can help him. The Hurst case, the prisoner voting case, was a pretty poor judgment. And it was bad. It was a bad judgment.
You're not allowed to use that one.
So there's one. there was another one about whole life sentences. There was another one about whole life sentences, which we sorted out in the Court of Appeal. Problem solved. The Abu Qatada case, that was a long saga. We sorted that out. Those are really the three problems we've had in the 10 years. That doesn't amount to a hill of beans.
I'm delighted my right honourable friend has intervened, because those are exactly the 3 points that I was about to mention to completely make my case. And I thank him for letting me do it for me. But I accept the point he makes. But I also accept for the fact that we are a sovereign parliament and our relationship, Sir Roger, has changed for many of these institutions, and I don't think necessarily our relationship reflects that change. So I will leave it at that, but I am accepting not only the points that he said, but also the wisdom in which he says it. And I think at that point, Sir Roger, unless I've got any more interventions, I'm going to be winding up. So thank you so much.
Order. Just before we proceed, and I call Jerome Mayhew, can I gently say it has not escaped the notice of the chair that a significant number of members have wandered in after many hours of debate during which they have not been here and then sought to participate. Technically, the chair has no power to control that, but understand we deprecate it. I take a very dim view of it as bad manners. And I hope that's very clearly understood. The honourable gentleman, the member for Ipswich, who's popped out for a few minutes, sat in his place for 5 hours waiting to speak. I believe that any other member that wishes to speak in a debate should afford the House the same courtesy. Jerome Mayhew.
Thank you very much, Sir Roger. And I should start my speech with my personal apology for not having been here for the full course of this debate. The reason in my case, well, I very much wanted to be actually, but I had duties in Westminster Hall for 2 debates during the course of the afternoon, which prevented me from taking a full role in this debate. But I'm very grateful, Sir Roger, for you nevertheless agreeing to call me in what is obviously a very important debate. I have heard sufficient, however, Sir Roger, of the debate, the back and forth, that there has been criticism from the benches opposite that this bill goes too far. And there are even some words of advice and criticism on these benches that it perhaps doesn't go far enough. So I think before we get down into the nitty-gritty of the amendments, it is worth going back to base principles, look at the fundamentals as to why this bill is necessary in the first place. Because it is, without doubt, it must be the case for every single member of this House, irrespective of their party loyalties, they must agree that the current position in relation to small boats crossing the Channel is deeply wrong and has to be addressed. It's just not fair what is happening at the moment, because the small boats programme that we see in our television screens and have done for the last 2 or 3 or 4 years, ever since we plugged the last gap in our external borders by making it harder for illegal immigrants to get onto lorries or to get on the Eurostar. That's going back almost a decade, in fact. The business model is such that where you restrict one point of illegal access, the model will seek out the next weakest point in the border of our country. And right now, that is small boats crossing the Channel. But these are not individuals buying up dinghies and setting off across the Channel. We all know that this is a massive commercial opportunity for organised criminal gangs making masses and masses of money, millions of pounds, tens of millions of pounds, from the misery of others. This is money going into organised crime, which then finds a vent in other crime, both in Europe and in our own country. And it is criminal gangs who are imposing violence on the very vulnerable people that are then exploited by them in the crossing of the Channel. So it must be right that any responsible government would take steps to challenge a set of circumstances where very vulnerable people are being exposed to risk and violence, not just the risk of death crossing the Channel. And the honourable member from Doncaster, if I heard him correctly, said there were 5 deaths just last week from this very dangerous process. But there's also the violence of the criminal gangs imposing their will on these migrants. Yes, I'll happily give way.
Thank you very much for the intervention, accepting my intervention. Does the honourable member not agree that the massive amount of money wasted on the Rwanda plan would be better spent on creating safe legal routes and clearing the backlog so that those fleeing persecution can build a better life in a country proud of its humanitarian actions, as so many have in my constituency of Ealing Southall?
I'm very grateful to the honourable member for Ealing South for his contribution. And he allows me to highlight the success that the government has made in reducing the backlog, as made clear by the Prime Minister in Prime Minister's questions early on today. But he's also right, and I don't shy away from the point that the Rwanda scheme is expensive. And if it was to be calculated as cost spent per person flown to Rwanda, it would be a very high cost indeed per individual. When the scheme gets up and running. I will come to the honourable member, the honourable friend in a moment. But that is not the point of Rwanda. It's not that every single person who comes across borders illegally will then be shipped to Rwanda. The idea of the Rwanda scheme is to act as an effective deterrent. So you send a few people to Rwanda. The scheme, the criminal gangs, and more importantly, the people who are paying large sums of money to the criminal gangs, get the message that this course of action, paying money to the criminal gangs, being ferried across the Channel, is no longer an effective way of getting here. And they will go, I will in a moment, but I will give way there and then to you after that. That it is not an effective means of gaining access to the United Kingdom. If that is successful, and I believe it will be when this bill is passed, then that is a very sound use of money, because it's not just preventing the additional cost to social society in this country and to the services, physical services, but it is protecting the lives of some of the most vulnerable people in the world whilst writing a gross unfairness in the approach to our asylum system. So I'm really grateful for that intervention. I will give way again.
I'm grateful to my honourable friend for giving way, and I think he's making an extremely important point, particularly in response to the intervention received in relation to the money and the costs involved. Clearly, he's made a powerful point in response, but is he also aware that the President of Rwanda has reported in the media today that the UK could well be refunded if all of that resource is not used because of challenges along the way?
Well, I'm very grateful again for that intervention from my own friend. I wasn't aware of that, but it adds grist to the mill and strength to the arguments of the government to proceed with the Rwanda policy, and I will give way again.
Will he give way, and can I pay tribute to him in making his speech? And he took the intervention from the other side of the House, which pointed about safe and legal routes. One of the biggest problems we have with the system is we haven't heard how many, where from, and what these safe and legal routes would look like. There are 100 million people supposedly displaced across the world. So if 1% of them even decided to come to the UK, that's 1 million people that have to be processed and found a country. If we do this as a one individual country when it's a worldwide problem, we create and facilitate not only a problem in our shores, but in the shores when you open those centres. And does he believe that there is a plan from the opposition over where these would be, how would we man these centres, how much they would cost, and what all those safe and legal routes look like, especially when people are leaving from France, when France is a safe country?
I'm very grateful for that intervention as well. The phrase safe and legal routes, it feels right, doesn't it? It feels like we should be in favour of safe and legal routes. And speaking personally, I do think they are part of a solution, a wider solution to immigration policy in the future. But the Honourable Member for Bosworth referenced that there may be up to 100 million people seeking asylum currently in the world. I think from memory, the figure from the United Nations report is actually 108 million people. I will give way there and then there, but I will come back and answer that question.
I'm grateful to my honourable friend giving way, and he's making an excellent speech. Of course, this bill is dealing with a lot of the pull factors, or at least references or infers approaching those in a more constructive and positive way. But on the push factors, and he sits on the Council of Europe delegation, I know, does he agree with me that this domestic policy should not perhaps be disaggregated from foreign policy and our overseas aid policies? So, for example, in sub-Saharan Africa or in the Sahel, let's take the Sahel as an example, where the French have recently exited or are about to exit, where the UK does have an important counter-terrorism presence, that where we have states that are fragile states becoming failed states, that they are causing more push factors. Also, there are some adversaries of this country, such as Russia, through its proxies in Africa, trying to disrupt democratically elected governments, again in order to create a crisis of migration. Quite happy to see people coming up through North Africa and coming into Europe. So does he agree with me, given his international experience, that we have to have a more holistic view of this policy in the context of global foreign policy?
I'm very grateful. I mean, those are excellent points, and it is one of the reasons why the merging of the development department with the FCO, as it then was, become the FCDO, has the potential, at least, to link those two areas of policy in a way that the Honourable Member describes. The challenge here is very substantial. I will come on in a minute, but I've got a few answers to give before I give way again. The challenge with push factors is that they've only just started. You're quite right. The Honourable Member is quite right to reference malign actors such as Russia in the short and medium term. But there is a much bigger factor which we need in this House to consider over the next 20 to 50 years, and that is climate change. Because the likelihood is that there will be very, very significant mass migration from sub-Saharan Africa at a time when large areas of countries, perhaps entire countries, may become functionally uninhabitable through water scarcity and heat. then what we've seen currently in push factors will be nothing to what we see in the future. So it behoves us as a responsible government to design and implement now an immigration policy that is fit for purpose, not just for now, but the future. We, returning to the point of my honourable friend Bosworth, so you might have to remind me what it was. No, not the point.
How many places, how many centres?
Actually, rather than going with that, I'm going to give way to the honourable member and then on. Sorry.
I'm giving way. I was just going to make the point that, would you agree? I do find it frustrating, Sir Roger, when especially the opposition benches talk about the need for safe and legal routes. As a statement of fact, there were 10 safe and legal routes into the UK in the past decade. There are currently 9 safe and legal routes into the UK, which have been responsible for 50,000 refugees coming from, of those safe and legal routes are responsible for 50,000 refugees coming to this country from 2015, and overall the numbers of refugees or people granted asylum in this country from 2015 to 2016 is a number approaching the population of Manchester now. You're talking about something in the upper 400s, twice the size of the city of Portsmouth. So when people talk about the need for safe and legal routes, I mean, I'm just assuming that none of the benches opposite have any clue what they're talking about. Would you care to comment?
I agree certainly with that last sentiment. We've had very significant and welcomed. We've been a place of safety for I think it's about 80,000 from Ukraine. We've opened our arms to Hong Kong, British nationals of Hong Kong descent, some 250,000 from there. We've got the Syria programme, which is, from memory again, about 20,000, as well as the Afghan resettlement programme, which was about 18 to 20,000. All of these have been safe and legal routes. And the big difference, Sir Roger, is that the British government, representing the British people, decided that those were the people we wanted to help. They were the most vulnerable, and we took the decision, not criminal gangs from abroad. I will give way, but then I will make some progress.
I'm very grateful. And it's exactly that the British people decided. Does he believe that it's right that the government is consulting on asking local council authorities how many asylum seekers and refugees they can support, come up with a number that Parliament will then have a decision on to vote on, which is exactly the right thing to say, to be pragmatic and practical while warm and welcoming to those who need that help?
The Honourable Member for Bosworth makes another very good point. One of the most important things that we must not forget in this place is that our asylum policy depends on the support and acceptance of our people. And if we have a policy that is rejected by people, that they feel is unfair, that doesn't represent their views, then we really run the very genuine risk of throwing the whole baby of asylum and welcoming people with vulnerabilities from around the world out with the bathwater. And we need, this bill helps to maintain a welcoming stance to asylum seekers which are decided on by the government, whilst maintaining public support for the policy as a whole. And I'm going to give way over there, and then I will conclude.
Just to shed a little light on this to help him here, as the author of the Safe and Legal Routes Amendment in the Illegal Migration Bill, he is quite right. We have very generous safe and legal route schemes already. The trouble is they are mostly limited to set groups of people, and the importance of the schemes that the government are working on is for those people who are genuine asylum seekers, genuinely fleeing persecution, war zones or whatever, can be accommodated in some way. But it will be subject to a cap. So although there are potentially hundreds of thousands and millions who may want to come here, the illegal migration bill sets a cap for safe and legal routes. So it's the number of people that we can cope with, but they're the right people, the most vulnerable people we can take in, and then separate out them from those people who have no credible case for coming to the United Kingdom, which is why this bill is so important.
With every point that my honourable friend made, we've got real anger on the doorstep. So I'm very lucky. I represent the seat of Broughton and Fakenham in Norfolk. I was knocking on doors just before Christmas. Of the 100 or so doors I knocked on, I had 20 conversations, decent conversations with constituents of mine. This is rural Norfolk. 19 of those 20 conversations raised illegal migration as one of the key issues. That is the reality of the views of the people who I represent, and we would be mad in this House if we did not accurately reflect those views. My final intervention.
Sir Roger, I'm grateful to my honourable friend for giving way. Would he join me in paying tribute to the work of the East of England Local Government Association and the East of England Strategic Migration Partnership, who've done such amazing work supporting the resettlement of British passport holders from Hong Kong, Syrians coming through the Syrian resettlement scheme, through Homes for Ukraine? And does he agree with me that it'd be much more acceptable to those constituencies referred to hear that those individuals have come to the UK through arrangements agreed with local authorities who have the capacity to support them, rather than, as I witnessed when I visited the jungle camp in Calais, done by a rate sheet of smugglers? The more you can pay, the more likely you are to be able to break into the UK through a back door.
My honourable friend is exactly right. That my constituents are generous-minded, they are welcoming, but they don't like the unfairness. They feel that this is inherently unfair. So we've got young men aged 18 to 40 typically. Where are the women? Where are the children? We've got young men 18 to 40 who are relatively rich because they've been able to pay £3,000 to £5,000 to the smugglers, or worse still, will be indented and end up in slave labour trying to pay back a debt that will never be repaid. You've got, this is a terrible situation which needs to be addressed. Now, the government has taken really effective action, and we can see that, not because I just say it, but because in the hard data that we've seen this in the last year. In a time when migration into the European Union is going up by about a third, and in Mediterranean companies by fully 80% last year, the effect of the suite of interventions that the government has already made has been so effective that it has reduced migration down in this country by 36%, over a third. That's not because of Rwanda, it's in addition to Rwanda. It's because we've increased French patrols on the coast by 40%. It's because we've been tracking down boat supply in places like Romania, removing that production from the ability of these gangs to physically get people across the channel. We've increased the raids on illegal workplaces, which were part of the pull factor for the illegal migrants. And perhaps more important than anything else, we have cut a deal with Albania, demonstrating that where the year before, I think about 20,000 people came from Albania, claimed asylum, with the returns policy, recognising that Albania is a safe country, just as Rwanda is, by the way, that the number of potential migrants coming across the channel has decreased by in excess of 90%. So if we need an example of why the Rwanda policy should work, look at Albania. Look at the results that we have already achieved, and this government, for who, I commend them for the hard work, the hard yards, the incremental gains, which have shown, we're not all the way there, but 36% reductions already and counting. And if we add on what we propose in this bill for the Rwanda relocation deterrence, I think this is going to really make an enormous difference. And we've heard from government lawyers that the current process is likely to reduce the number of appeals by 99.5%. Yes, there may be the odd one who continues to appeal, but that last-minute process of repeated appeals, that will be removed. And that's why I don't feel the necessity to support the proposed amendments in this bill, and I will be supporting the government.
Michael Thomas.
Sir Roger, thank you very much indeed. With your permission, may I, on behalf of His Majesty's Government, pass on my sincere condolences to the family and friends of Sir Tony Lloyd, the former Member of Parliament for...
Order. I'm sorry to have to interrupt on such a sensitive issue, but Mr. Speaker intends to make a statement about that later.
I'm very grateful indeed for that guidance, and thank you for that. May I start, therefore, by turning to those who have contributed during the course of this debate. May I start with my honourable friend, the member for East Worthing and Shoreham, thanking him for his powerful points, his challenging, forensic, learned even points that he made. He once again questioned what solutions are being offered by the party opposite. He's right to do so. Answer came there none. May I thank my right honourable friend, the member for South Holland and the Deepings. As so often, he debates in poetry, and I'm going to come back to some of the remarks he made in due course. May I also thank the Chairman of the Select Committee, the Right Honourable Member for Kingston upon Hull North. She was right, and she ensured she didn't make a second reading speech, but she did mention one or two other matters and amendments, and I'll turn to those in due course. I thank my honourable friend, the member for Ruislip, Norwood and Pinner, always thoughtful, measured, and so often right, and I'm grateful to him for his contributions and also for his interventions during the course of the latter stages of this debate. The honourable member for Glasgow Central cited Robert Burns and asked what he would have to say to the benches opposite. And my honourable friend and neighbour, the member for North Dorset, rather cheekily from a sedentary position, suggested that Robert Burns might say to the benches opposite, "How can I join you?" That wasn't the gist or the thrust of her speech, but it was a cheeky intervention that I enjoyed nonetheless. I'll turn to her amendments in due course. My honourable friend, the member for Don Valley, I listened carefully, as I always do, and I hope to be able to turn to some of the points that he made and hopefully allay some of the fears that he has. He said that it sometimes happens that the chamber empties or isn't as full when he speaks. It sometimes happens to ministers as well, but not everyone is back when the minister is responding to their contributions. But he is here, and he is in his seat. And I'm grateful to him for sitting through so much of this debate and also for his characteristic courtesy. My honourable friend, the member for Ipswich, spoke with passion, as he always does, and I'm grateful to him for his contribution. My honourable friend, the member for the Isle of Wight, again spoke at some length. I'm grateful to him for that. He delved into the principles of the ECHR, and he was enticed by my right honourable and learned friend to make some pronouncements on some of those judgments. And I thought that was a little bit mean of my right honourable and learned friend, the member for South Swindon. But he did at least proffer one suggestion, namely the case of Hurst, and I'm grateful to him for that. My honourable friend, the member for Broadland, again, I'm grateful to him for his intervention and for being on duty not only in Westminster Hall, but also here in this chamber. Sir Roger, the course of this debate has been constructive. On the whole, I agree. It has been broadly thoughtful, instructive. We've had references to scripture. We've had an exchange on that. And as a lawyer, it was a joy indeed to hear the word otiose. And we didn't hear it once. We didn't hear it twice. We heard it several times. We once even heard otiose with bells on, from my honourable friend, the member for Bromley and Chislehurst, and I'm grateful to him for that. I've not heard that expression before, but I feel sure that it is a legal reference that I must have brushed past in my youth. We've also heard about box sets. We heard that from my right honourable friend, the member for Newark. We heard about that from the honourable gentleman, the member for Glasgow North, and I'll need to do a bit more research on that, I think. And we also touched on ECHR membership, although rightly, my right honourable friend, the member for Newark, said this was not the place to have that full debate. But he set out some of the parameters for the future debates that I'm sure we will have. Sir Roger, may I turn firstly, please, to Clause 1. This clause sets out the rationale of the bill. It sets out the legal obligations and how the treaty to which the government of Rwanda have agreed addresses the concerns that were set out by the Supreme Court. Amendments 39, Amendments 40, 41 and 42, tabled by the Honourable Member for Glasgow Central. We heard her address those points. And also Amendments 43 and 44, tabled by the Honourable Member for Aberdeen South. They seek to exclude the core of these provisions. And once again, the Honourable Member was very clear about her intention in that regard. But the treaty is binding in international law. In accordance with Rwandan law, the treaty will become domestic law in Rwanda on ratification. And, Sir Roger, that's set out in detail and it's confirmed in Article 3(6) of the treaty. It rules out anyone relocated to Rwanda being removed from there, except to the United Kingdom. That is an important part of the treaty set out in Article 10.3. And this is regardless of whether the individual is found to be a refugee or to have another humanitarian protection need. This removes the risk of refoulement. Everyone relocated to Rwanda will receive the same treatment. Those with refugee status, those with a humanitarian protection need, or even without that status, will be able to stay in Rwanda and receive the same rights and treatment. This addresses head-on the concern that the Supreme Court set out. The asylum decision-making process is being significantly reformed. And Annex B of the treaty, and if I have time, I might turn to the details of that in due course, but Annex B contains strengthened monitoring arrangements to ensure, and there are also strengthened monitoring arrangements to ensure adherence to the obligations. I'm very grateful indeed to my right honourable and learned friend, the member for Kenilworth and Southern. I'm very grateful for his engagement. I don't believe that his concerns are right. He said offensive or otiose. I would suggest neither is right, and I hope to be able to reassure him with what I say now, because Clause 1 makes clear that Parliament is sovereign and that its acts are valid notwithstanding any interpretation of international law. And he will understand that I'll come back to that notwithstanding terminology that has been so contentious, perhaps, in recent history. But what it doesn't mean is that doing so legislates away our international obligations. The purpose of the bill is to say that on the basis of the treaty and the evidence before it, Parliament believes that those obligations have been met. It doesn't mean that we do not care whether or not they have been met. He mentioned dualism. He was right to do so. The parts of this clause to which my right honourable and learned friends' amendments are directed, they do no more than make clear what we mean by a safe country, which is a key definition applied to Rwanda, namely that the United Kingdom can remove to that country in compliance with its international obligations, and that Rwanda will not remove anyone in breach of any international law. My right honourable and learned friend also mentioned, as a former Attorney General, the Law Officers Convention. I was very grateful to him for that, for so often in this chamber it goes unnoticed. It is an important convention, and as a former law officer myself, I abide by it very strictly, as I know he does as well, and I'm grateful to him for reminding the House of that fact. May I turn to the amendments tabled and the speech of my right honourable and learned friend, the member for South Swindon. I'm grateful again to him for his contributions, not just yesterday, but today as well. It's important that the will of Parliament is made clear, and that following the mammoth efforts between our government and the government of Rwanda, the obligations that we have agreed are fully set out. This clause, Clause 1, ensures that it's crystal clear that it's Parliament that has considered and concluded that Rwanda is a safe country. I know my right honourable friend's concern about this sort of clause. He will know that it's not unique and that it's not dissimilar to the Illegal Migration Act and the Clause 1 that was there as well. And I suspect he's encouraging me not to pray that in aid, but it is a fact all the same that it is there. It is not unprecedented to have a clause such as Clause 1 in the bill. May I turn, Sir Roger, please, to Clause 3. The United Kingdom has a long-standing tradition of ensuring that rights and liberties are protected domestically and of fulfilling our international human rights obligations. We remain committed to that position, and we will ensure that our laws continue to be fit for purpose and work for the people of the United Kingdom. Though some of the provisions in the bill are novel, the government is satisfied that the bill can be implemented in line with the Convention rights. However, it has been clear that people will seek to frustrate their removal by any means. Therefore, this bill goes further than the Illegal Migration Act taken through by my right honourable friends, the members for Newark and for Fareham. As we have heard, that bill only excludes Section 3, or it disapplies Section 3. This bill and this clause disapplies further elements of the Human Rights Act. And the effect is that the duty under Section 6(1) of the Human Rights Act is disapplied from any public authority, including any court or tribunal that is taking a decision that's based on the duty under Clause 2 of the Bill to treat the Republic of Rwanda as safe. May I turn directly to my right honourable friend, the member for Newark, and for his amendments, firstly his amendments 11 and 18, if I may. The bill, he's right, does not seek to disapply Section 4. It does not, in fact, disapply the Declaration of Incompatibility provisions in Section 4. This is the only substantive remedy against the conclusive presumption that Rwanda is safe. Retaining declarations of incompatibility is important, but of course, the final say on this matter will remain rightly with Parliament and with the government, because of Section 4, subsection 6 of the Human Rights Act makes it clear that a declaration cannot affect the operation or the validity of domestic legislation. I will give way.
I think he makes a very important point there about the extent to which the courts should and can intervene on issues relating to the compatibility of primary legislation with the ECHR. The Section 4 procedure allows the courts to express a view, but doesn't trespass directly upon the functions of this place in order with dealing with the problem. It simply gives Parliament an opportunity to then rectify any situation, or not, frankly. Does he agree with me that Section 4 is a much better mechanism for the courts to use than the clunky and inelegant and sometimes very problematic Section 3 procedure?
Indeed, to my right honourable learned friend, I heard what he said about Section 3 and I agree with him wholeheartedly and entirely. He's absolutely right to describe it as clunky, and it has been disapplied in this bill as well as the Illegal Migration Act. But may I say directly to my right honourable friend, the member for Newark, that I accept entirely his comments when he says that he is here to help the government, that he believes passionately in this policy, and he has had several very frank, open and honest conversations with me about that, both in this chamber and outside. I'm very grateful to him for the way that he put his points so ably and so clearly. But the disapplication of these sections within the bill significantly reduces the extent to which public authorities are bound to act as a consequence of the Convention rights. May I turn to some other amendments, Sir Roger? May I turn to Clause 5 and the further amendments tabled by my right honourable friend, because this bill makes clear in Clause 5 that it is only for a Minister of the Crown, and only they alone, to determine whether to comply with an interim measure of the Strasbourg courts. It also makes it clear that the domestic courts may not have regard to the existence of any interim measure when considering any any domestic application flowing from a decision to remove a person to Rwanda in accordance with the treaty. What happened with the Rwanda flight in June 2022 was frustrating, as many honourable members have mentioned. It was a deeply flawed process and raised issues of natural justice, but changes have been made since then, not least in the Illegal Migration Act. And since then, the Strasbourg Court has, on the 13th of November, announced the outcome of its review into the rules concerning interim measures. And the changes include the naming of judges, and that interim measures should be communicated as formal decisions. And it confirms the existing practice in parties being able to request reconsideration of a decision in the rules. And the United Kingdom has responded formally to that court's consultation. Sir Roger, I know that colleagues have raised concerns that, assuming this bill passes and succeeds in closing down the vast majority of individual claims, our deterrent will be frustrated by a Rule 39 interim measure. May I say directly to my right honourable and honourable friends that I understand those concerns. No one who was here in June 2022 and saw the last Rwanda plane left on the tarmac, can fail to understand the importance of fixing this issue. That is why the Prime Minister has been clear that he will not let a foreign court block these flights. We simply cannot let an international court dictate our border security and stop us from establishing a deterrent. And that is I must complete this point. I must complete this point. That is why we have inserted into Clause 5 of this bill, which is crystal clear, that it is for ministers and ministers alone to decide whether to comply with Rule 39 injunctions. We would not have inserted Clause 5 if we were not prepared to use it. And I can confirm to the House that we can and will lawfully use that power if the circumstances arise. The discretion is there. But we go further still, and we confirm that the civil service must implement any such decision. Today, the Permanent Secretary for the Home Office has confirmed that if we receive a Rule 39, instead of deferring removal immediately, as currently is the practice, officials will refer the Rule 39 to the Minister, not to be too grandiose, but Sir Roger, in this case to me, for an immediate decision. As the Cabinet Office has confirmed, that is the responsibility of civil servants under the Civil Service Code to deliver that decision. Sir Roger, colleagues have confirmation that we have the power, we would use the power, and the civil service will give effect to it. If a plane is sitting on that runway, this government will not stop until it takes off. And we all know what the opposition would do. They would campaign for it to be grounded. Will my honourable and right I will give way to my honourable friend.
Thanks, Sir Roger. I'm grateful to the Minister for giving way. With the point he's just referred to, he said that there will be circumstances in which we will ignore these pyjama injunctions. What are the circumstances of which the government will not ignore and therefore comply with them?
I couldn't have been clearer. There is the confirmation that we have the power, we would use the power, and the civil service will give effect to it. May I respond directly to my right honourable? I won't. I don't have the time. May I respond directly to my right honourable and learned friend, the member for Fareham? She spoke powerfully, as she always does, and I always listen carefully to what she says. She set out a number of cases, Sir Roger, where medical reasons were cited in court, medical arguments were presented, which she said frustrated the will of this place. But in fact, in Section 39 of the Illegal Migration Act, the very act that my right honourable and learned friend took through this place with my right honourable friend, the member for Newark, addresses that exact point about medical records and medical evidence. The following, Sir Roger, are examples of harm that do not constitute serious and irreversible harm, namely where the standard of healthcare available to the person in the relevant country is lower than that available in the United Kingdom. It is there. It is in the statute. It is in the bill that we passed last year. Any pain or distress resulting from a medical treatment that is available to a person in the United Kingdom not being available to a person in the relevant country is not, does not and will not constitute serious and irreversible harm. My right honourable learned friend is right to be concerned about that, but those concerns have been addressed and have been met in the legislation that we have passed and in the legislation that is mirrored in this bill that we are taking through today. May I turn to Clause 8 and the important provisions that are there? And may I address directly, please, the Honourable Member for Belfast East and his submissions in response to new Clause 3. Nothing in the Windsor Framework, including Article 2 or the Withdrawal Agreement, affects the Bill's proper operation on a UK-wide basis. Any suggestion to the contrary would be to imply that the scope of the rights, safeguards and equality opportunity chapter of the Belfast Good Friday Agreement is far more expansive than was ever intended. I will not give way. We are unequivocal that that is simply not the case. And Article 2 of the Windsor Framework is not engaged. I would be happy to write further to the Honourable Gentleman and to the Right Honourable Member for Lagan Valley on this point to set out further detail. I hope I can reassure him that we have already achieved what the aim that he seeks. I will give way. He must be conscious that we are up against a very tight deadline.
On the statements he made with regard to Rule 39 and so forth, can he explain to the House how the government would be able to prevent a judicial review of the decision taken by the Minister without legislation?
My honourable friend has heard what I said on that point. I respect him and admire him. He knows the esteem that I have for him. We have a good faith disagreement on the effect of this. Clause 5 is clear. It is for a minister to decide, and a minister will decide. May I finish this point in response to the honourable member for Belfast East? I hope I can reassure him that we have already achieved the aim that he seeks. The bill will apply across the whole of the United Kingdom, in line with the application of our sovereign immigration policy across all 4 nations of the United Kingdom as a territorial whole. I am grateful to him for his kind and generous comments about me personally. I'm grateful to him for his engagement, and I will continue to engage with him on this issue. Sir Roger, we have made progress towards stopping the boats, with small boat crossings down by 1/3 in 2023. But we must do more. The only way to do this is if it is abundantly clear that illegal entry will never lead to a new life in the United Kingdom. The power of deterrence is proven beyond reasonable doubt by the success of our agreement with Albania. Sir Roger, Parliament and the British people want an end to illegal immigration, and we need a deterrent. We have a plan. We have a plan to stop the boats, and I invite all honourable and right honourable members to back it.
Order. Amendment 11 has been proposed. Mr Jenrick, do you wish to press it to a vote, or do you wish to withdraw it?
With your permission, I'd like to withdraw it, but if you are agreeable to press Amendment 23 instead.
We'll come to that in due course. Is it your pleasure that Amendment 11 be withdrawn?
Aye.
Amendment by leave withdrawn. Under the order of the House of the 12th of December, I must now put the questions necessary to bring the proceedings to a conclusion. The question is that Clause 3 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. Aye. Division, clear the lobbies.
Quickly. Sorry, Sir Roger. Thank you.
The question is that Clause 3 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes. Rob Logan and Aaron Bell. Tell us for the noes. Kirsty Blackman and Stephen Bonner. Lock the doors. Order, order.
The ayes to the right, 339. The noes to the left, 264.
Thank you. The ayes to the right were 339. The noes to the left were 264. So the ayes have it. Unlock. We now come to Amendment 23 to Clause 5, which has been selected for separate decision. Robert Jenrick to move formally.
Beg to move.
The question is that Amendment 23 be made. As many of that opinion say aye. Aye. Contrary, no. No! Division. Clear the lobby. Amendment 23 be made. Does many of that opinion say aye? Contrary, no.
No!
Tellers for the ayes, Sir Jacob Rees-Mogg, Miriam Cates. Tellers for the noes, Rob Logan and Aaron Bell.
Lock the doors. Order. Order.
The ayes to the right, 65. The noes to the left, 536.
The ayes to the right, 65. The noes to the left, 536. So the noes have it. The noes have it. And look, the question is that clauses 5, 6, 7 and 8 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. Aye. Division, clear the lobby. Order. If members could resume their seats, please. The question is that clauses 5, 6, 7 and 8 stand part of the bill. As many of that opinion say aye. Of the contrary, no. Tell us of the ayes, Robert Largan, Aaron Bell. Tell us of the noes, Kirsty Blackman and Steve Bonner. Order. Order.
The ayes to the right, 340. The noes to the left, 263.
The ayes to the right, 340. The noes to the left, 263. So the ayes have it. The ayes have it. Unlock. We now come to Amendment 36 to Clause 9, which has been selected for separate decision, and I call Stephen Kinnock to move formally.
Formally, sir.
The question is that Amendment 36 be made. As many of that opinion say aye.
Aye!
Of the contrary, no. No! Division. Bills lobbies. Order. If members could resume their seats. The question is that Amendment 36 be made. As many of that opinion say aye. Or the contrary, no. No. Tell us for the ayes. Andrew Weston, Samantha Dixon. Tell us for the noes. Robert Largan, Aaron Bell. Lock the doors. Order. Order.
The ayes to the right, 263. The noes to the left, 339.
Thank you. The ayes to the right, 263. The noes to the left, 339. So the noes have it. The noes have it. Unlock. The question is that clauses 9 and 10 stand part of the bill. As may I have been say aye? Aye. Or the contrary, no? Aye. Division, clear the lobby. Order. The question is that clauses 9 and 10 stand part of the bill. As may I have been say aye? Aye. Or the contrary, no? Tell us for the aye, Scott Mann, Mark Fletcher. Tell us for the noes, Kirsty Blackman, Steve Bonner. Lock the doors. Order. Order.
The ayes to the right, 340. The noes to the left, 264.
Thank you. The ayes to the right, 340. The noes to the left, 264. So the ayes have it. The ayes have it. Unlock. We now come to new clause 8, which has been selected for separate decision, and I call Stephen Kinnock to formally move it.
Move formally, sir.
The question is that new clause 8 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. Order. The question is that new clause 8 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Andrew Weston, Samantha Dixon. Tell us for the no, Scott Mann, Mark Fletcher. Fingertip control. Thank you. Order. Order.
The ayes to the right, 264. The noes to the left, 338.
Thank you. The ayes to the right, 264. The noes to the left, 338. So the noes have it. The noes have it. Unlock. The question is that Clause 1 stand part of the bill. As many other opinions say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. Order. Order. That concludes the proceedings of the House in Committee on the Safety of Rwanda, Asylum and Immigration Bill.
Order. Before I ask the Whip to report, it is with great sorrow that I inform the House of the death of Sir Tony Lloyd. He was a valued colleague who spent his life in public service. He'll be remembered on all sides of the House with respect and affection. I'm sure the House will join me in sending our sympathy to his family in their loss. There will be an opportunity for members to participate in a minute's silence tomorrow and to pay further tributes at a later date. So I want to do that.
Point of order, Mr. Speaker.
Point of order, Keir Starmer.
Thank you, Mr. Speaker. I know there'll be tributes in due course because many people in this House will want to speak in that session. But I'm grateful for this point of order just to say a few words about Tony and this terrible loss this afternoon. We are all deeply saddened at the loss of Tony. I spoke to him last Thursday when he left hospital for the last time to spend as much time as he could with his family and was able to pass on to him our thoughts, our respect, our affection for him, his commitment, his public service and, frankly, his sheer decency. I know that's not just felt across the Labour Party and the Labour movement, it's felt across this House and beyond. And can I just say thank you to those opposite who have sent messages. It is a great comfort to his family to know the respect that he was held in across this House. And our thoughts, of course, Mr. Speaker, this evening are with his family at this difficult time.
I say, minute silence tomorrow, and we'll give the House an opportunity for further tributes to be paid. Right. Order. Whip to report.
I beg to report that the committee has gone through the bill and directed me to report the same without amendment to the House.
Third reading. Minister. No. There we are. Minister to move the third reading. Right. Okay. Minister.
Thank you. Thank you, Mr. Speaker. I, of course, echo the tribute to Sir Tony.
Should just let the room just clear. Yeah. Minister.
Thank you, Thank you, Mr Speaker, and I of course echo the tribute to Sir Tony. And I beg to move that the bill be now read a third time. The Prime Minister, the Government, I have been clear that we will do whatever it takes to stop the boats. And we have, of course, been making progress on that pledge, reducing small boat arrivals by over a third last year. But to stop the boats completely, to stop them for good, we need to deter people from making these dangerous journeys, from risking their lives and from lining the pockets of evil, criminal, people smuggling gangs. The new legally binding treaty with the government of the Republic of Rwanda responds directly to the Supreme Court's concerns, reflecting the strength of the government of Rwanda's protections and commitments. This bill sends an unambiguously clear message that if you enter the United Kingdom illegally, you cannot stay. This bill has been meticulously drafted to end the merry-go-round of legal challenges. People will not be able to use our asylum laws, human rights laws, or judicial reviews to block their legitimate removal. And the default will be for claims to be heard outside of this country. Only a very small number of migrants who face a real and an imminent risk of serious and irreversible harm will be able to appeal decisions in the UK. And if... I will give way.
Grateful, Mr Speaker, to the Home Secretary. As things stand, can the Home Secretary confirm that if this bill receives royal assent, that it will not breach international law? Yes or no?
My right honourable friend raises an important point and gives me an opportunity to be unambiguous and clear. As drafted, as we intend this bill to progress, it will be in complete compliance with international law. The UK takes international law seriously, and the countries that we choose to partner with internationally also take international law seriously. Because under our I will, and then I will make progress. Yeah.
The intervention just now was extremely apposite. Could the Foreign Secretary be kind enough to give me the advice as to why he said what he just said about no breaches of international law?
My honourable friend will know. My honourable friend will know that the government does not make its legal advice public. We have put forward, of course, an explanation of our position, but I am absolutely confident that we will maintain our long-standing tradition of being a country that not just abides by international law but champions and defends international law. Under our new legislation, migrants will not be able to frustrate the decision to remove them to Rwanda by bringing systemic challenges about the general safety of Rwanda. I will.
I'm grateful to the Home Secretary, Mr Speaker, but could you give us assurance that if this bill is passed tonight, there will be a system in place that will accurately test its success, month by month, week by week, so that we know all this anger, all this frustration, all this work is not for nothing?
Mr Speaker, I think honourable gentleman speaks certainly for a number of people in the House, maybe not too many people on his own benches, because it certainly sounds as if he wants this to work. And I know there are plenty of people across the other side of the House who have tried to frustrate our attempts to deal with illegal migration. But we will, of course, want to assess the success, because we want to be proud of the fact that this government, unlike the parties opposite, actually cares about strengthening our borders and defending ourselves against those evil people smugglers and their evil trade. I want to make it clear that we will disapply the avenues used by individuals that blocked the first flight to Rwanda, including asylum and human rights claims, because without that very, very narrow route to individual challenge, we would undermine the treaty that we have just signed with Rwanda and run the very serious risk of collapsing the scheme, and that must not be allowed to happen. But if people attempt to use this route simply as a delaying tactic, they will have their claim dismissed by the Home Office and they will be removed. The bill also ensures that it is for ministers and for ministers alone to decide whether to comply with the ECHR interim measures, because it is for the British people and the British people alone to decide who comes and who stays in this country. The Prime Minister said he would not have included that clause unless we were intending and prepared to use it, and that is very much the case. We will not let foreign courts prevent us from managing our own borders. And, as reiterated by the Cabinet Office today, it is a responsibility, as the established case, that civil servants under the Civil Service Code are there to deliver ministers of the Crown's decisions. Mr. Speaker, the bill is key to stopping the boats once and for all. And to reassure some of the people who have approached me with concerns, I would remind them that Albanians previously made up around a third of small boat arrivals, but through working intensively and closely with Albania and their government, more than 5,000 people with no right to be here have been returned. And the deterrent was powerful enough to drive down arrivals from Albania by over 90%. Strasbourg has not intervened. Flights from Rwanda have not been stopped, and the House should understand that this legislation, once passed, will go even further and be even stronger than the legislation that underpins Albania.
We obviously support the Albania agreement, but will he confirm that only 5% of Albanians who've arrived in the country over the last few years on small boats have actually been returned or removed? What's happened to the other 95%?
As I said, this is about deterrence, and the deterrent effect is clear for anyone to see. Over 90% reduction in the number of Albanians who have arrived in these shores because of the deterrent effect. And I'm glad that she chose this point to intervene, because it reminds me, of course, that the Labour Party have, of course, no credible plans at all to manage our borders. They have tried to obstruct our plans to tackle illegal migration over and over again, more than 80 times. They even want to cut a deal with the EU that would see us receive 100,000 extra illegal migrants each and every year, and they cheer. She's pleased with the idea that they're going to receive an extra 100,000 every year. They can laugh, but we take this issue seriously, because it is not what our country needs, and it is not what our constituents want. Mr. Speaker, we are united in the agreement that stopping the boats and getting Rwanda partnership up and running is of the utmost importance. And having a debate about how to get the policy right is, of course, what this House is for. That is our collective job, and I respect my good friends and colleagues on my side of the House for putting forward amendments in good faith in order to do what they believe will strengthen the bill. But, Mr. Speaker, whilst my party sits only a short physical distance from the parties opposite, the gulf between our aspiration to control our borders and their blasé, laissez-faire attitude to border control could not be more stark. Stopping the boats is not just a question of policy. It is a question of morality, and it is a question of fairness. And it is this government, this party, the Conservative Party, which is the only party in this House taking this issue as seriously as it should. I urge this House to stick with our plan and to stop the boats.
The question is that the bill now be read a third time. Shadow Home Secretary Yvette Cooper.
Thank you, Mr. Speaker. Can I first just add my tributes to Tony Lloyd, who did such wonderful work in policing as well as in this place. Mr. Speaker, what a farce today and yesterday have been. Just another day of Tory chaos and carnage. A Prime Minister with no grip, while the British taxpayer is continually forced to pay the price.
former Tory cabinet ministers, deputy chairs from all sides queuing up to tell us it's a bad bill, it won't work, it won't protect our borders, it won't comply with international law, it's fatally flawed. The only thing the Tories all seem to agree on is that the scheme is failing, the law won't solve it, and the Prime Minister £1 million that sent more Home Secretaries than asylum seekers to Kigali, and that will only apply to less than 1% of those arriving in the UK. Less than 1%. The third Tory law on channel crossings in 2 years, it will get through tonight, just like the previous two did, even though they failed, just like the last two, a total con on the British people. And this chaos leaves the Prime Minister's authority in tatters. He's in office but not in power. No one agrees with him on his policy, and the real weakness is that he doesn't even agree with it himself. A Prime Minister who is so weak he's lost control of the asylum system, lost control of our borders, and lost any control of the Tory party. 60 Tory MPs voting against the government, 2 deputy chairs sacked, a Home Secretary and Immigration Secretary formally lost, cabinet ministers briefing openly they don't support the bill. The Home Secretary himself thinks it's batshit. The Prime Minister tried to cancel it, and yet, so weak, they're still going ahead. And under the Tories, we've seen border security weakened while criminal gangs take hold because they've not taken the action that we need. The backlog soar, the budget bust. Criminal smuggler convictions have dropped by 30%. Returns have halved. And instead of the practical plans that Labour set out to set up the new Returns and Enforcement Unit to stop the Home Office just losing thousands of people that it cannot keep track of, to stop the halving of the Returns Unit, to set up the new security powers to go after the criminal gangs, to stop this 30% drop in criminal gang smuggler convictions, and to have the additional cross-border police unit that we could be investing in if we weren't spending so much money on this failing Rwanda scheme. Because it's £400 million of taxpayers' money going to Rwanda, all without a single person being sent, all in addition to their whopping multi-billion-pound hotel bill. And of course, if they get flights off, it's probably another 10 to 20 million for every 100 people they actually manage to send. And President Kagame, an astonishing intervention this afternoon, saying he's happy for it to be scrapped and maybe offering to refund the money. Think what we could do with £400 million, Mr Speaker. It's more than a third of the budget of the National Crime Agency. But the Kigali government have clarified the position this afternoon, and it's even worse. They've said, under the terms of the agreement, Rwanda has no obligation to return any of the funds paid. If no migrants come and the UK government wishes to request a refund of the portion of funding allocated to support, we will consider this request. Unbelievable. The government signed a deal, signed a whole series of cheques to send hundreds of millions of pounds of British taxpayers' money to Rwanda for a scheme they were warned would not work, that they were warned might be unlawful, they were warned would not work as a deterrent, and they were warned would be unenforceable and at high risk of fraud. Yet they signed it because they don't give a damn about taxpayers' money. And now they want to pass this bill and spend even more taxpayers' money on this failing scheme, a scheme which is only likely to cover less than 1% of the people who arrived in the country last year. Over 90,000 people who applied for asylum. And the Court of Appeal said Rwanda only had capacity for 100 people. The Immigration Minister admitted it's just a few hundred and not any time soon. And if they ever finally implement the Illegal Migration Act, that will immediately create a list of 35,000 people the Home Secretary is supposed to immediately send to Rwanda. And at this rate, it will take the government 100 years to implement their own failing policy. Although, to be honest, it is probably even worse than that, because they can't even find most of the 5,000 people that they put on the initial Rwanda list. Totally unbelievable. The Prime Minister and the Home Secretary, in the space of about 18 months, have literally lost 4,200 people they planned to send to Rwanda. I bet the Prime Minister wishes he could lose a few of those Home Secretaries he managed to send. And he did indeed lose his Immigration Minister. It's part of the chaos of the last few weeks and months. I give way to the former immigration...
for giving way. If she doesn't like the Rwanda policy so much, why did she brief the Times over the Christmas holidays that she was in favour of an offshore processing scheme, a scheme that everyone knows is more expensive than a scheme like Rwanda and has a far less deterrent effect? So it seems to be that everything that she doesn't like is her plan, except she didn't have the guts to put her name to it, so she briefed the Times anonymously.
Yeah. Nice try with total nonsense from the former immigration minister, who does have a history of making things up. Let's be clear. It's not clear that there's anything on the planet that is more expensive per person than the government's Rwanda scheme, £400 million, in order to send nobody to Rwanda and to totally fail. But look, the former immigration minister, I give him credit, he has exposed the real front-bench plan, the real government's plan, the real Prime Minister's plan. It is just to try, in the former immigration minister's words, to try and get a few symbolic flights off before a general election with a small number of people on them. Not to worry about handing over a small fortune to another country, not to worry about the fact that all this focus on one small failing scheme means they're failing to go after the gangs and they've lost thousands of people the Home Office should be tracking. Not to worry about the fact that this new law is so badly drawn up that, frankly, they may be ordered by the courts to bring people back at further huge cost to the British taxpayer, turning the whole thing into an even bigger farce. That is not a workable policy. It is a massive, costly con. They're trying to con voters, trying to con their own party, but actually the fact is everybody can see through it now. He's a £400 million Rwanda scheme for a few hundred people is like the Emperor's new clothes. And the Prime Minister and his immigration ministers have been desperately spinning the invisible thread, but we can all see through it. The Home Secretary is just wandering naked round this chamber, waving a little treaty as a fig leaf to hide his modesty behind. I admit he doesn't have much modesty to hide. Mr. Speaker, there are things the Home Secretary and I agree on. We agree on working with France. We agree on the deal with Albania. We agree on the importance of stopping dangerous boat crossings that are undermining border security and putting lives at risk. And I think he probably agrees with us about the failings of the policy he is trying to defend today. We need stronger border security and a properly controlled and managed asylum system, so the UK does its bit to help those fleeing persecution and conflict, and those who have no right to be here are returned. We need Labour's plan for the new security powers, the new cross-border police, the new security agreement, the new returns and enforcement unit, the clearing of the backlog, the ending of hotel use, keeping track of the thousands of people that the Home Secretary has lost. But they'll get their law through tonight. This third new law in 2 years, the third Home Secretary to visit Rwanda with his chequebook, the third bilateral agreement with Rwanda. The Tory backbenchers have been saying it should be 3 strikes and you're out. Yeah. Well, we're now on 3, 6, 9 strikes and they haven't even got to first base. Because every time they bring forward a new law, it makes things worse. The first new law failed because the main provision's now suspended. The second new law failed, the main provision's not even implemented. Forgive us for not believing a word the government says and for voting against a third failing bill today. The only difference now is that none of their backbenchers believe them either. Broken promises on clearing the backlog, on ending hotel use, on stopping the boats, on returning people who come. It's chaos and failing on smuggler gangs, failing on returns, and failing to get a grip. Britain deserves better than this Tory asylum chaos.
Sir William Cash. Well, thank you very much indeed, Mr. Speaker. Very simply, I just simply reply to the Labour Party. We have no intention, certainly I have no intention, if I vote in this division this evening against this bill, to do any single thing to support their propositions as just put by their front-bench spokesman. I get that completely clear. They're not doing anything. They have no plan. I want this bill to succeed, and the sole reason why I shall be voting against this bill will be because on third reading, I don't believe, to use the Home Secretary's own words, that this is the toughest immigration legislation that we could produce, nor do I think we've done whatever it takes. I can only say that in this context, but it's about the law. I am deeply worried, and this is my main concern, that there will be another claim which comes as a result of this. I don't think anybody expects anything else. And when it does happen, it will go to the Supreme Court. And when it goes to the Supreme Court, the question in front of that Supreme Court is going to be very, very simple. And I put this in my speech yesterday, and I don't retract a single word, and I'm extremely grateful for those people, very senior, and some members of the government, who said to me privately that they agreed with every word I said. And it is simply for this reason that I say this, that actually, if the Act of Parliament is sufficiently comprehensive, using the notwithstanding formula, and at the same time, the words used are clear and unambiguous, then there is no doubt at all that we will win that case in the Supreme Court. Sadly, I just don't think that that's going to happen. I explained yesterday why. There's no need or reason for me to go into it now. I've said what I've said, and all I can say is I wish the government well, but I do have to say that I can't support this in all conscience because I've set out my case and I'm not going to retract it on principle.
We come to SNP spokesperson Alison Poulos.
Thank you very much, Mr Speaker. The front page of this tawdry, pathetic piece of unworkable legislation says, in the name of the Home Secretary, I am unable to make a statement that, in my view, the provisions of the Safety of Rwanda Asylum and Immigration Bill are compatible with the Convention rights, but the Government nevertheless wishes the House to proceed with the bill. It is another illegal bill that will not work, will not fix the problem, and it is a bill for which this Government has no mandate. The 2019 Conservative Manifesto said, we will continue to grant asylum and support to refugees fleeing persecution with the ultimate aim of helping them to return home if it is safe to do so. Nothing about flights to Rwanda, nothing about extradition, nothing about ripping up people's fundamental human rights. Since then, there have been 2 unelected Prime Ministers, there have been 4 Home Secretaries and no mandate for this bill. The UNHCR also say that, and I quote from their assessment of this bill, it maintains the position that the arrangement now articulated in the UK-Rwanda Partnership Treaty and accompanying legislative scheme does not meet the required standards relating to the legality and appropriateness of the transfer of asylum seekers and is not compatible with international refugee law. Rwanda have been clear that they don't want to sign up to an agreement that breaches international law. This bill breaches international law. It is very clear, and it is very dangerous that the government is going down this road. We cannot make a country safe simply by legislating that it is so. It is a fantasy that this government is engaged with. And more dangerous than that, they ask the courts, they ask public servants, and they ask all of us to also engage in that same fantasy. It becomes upside down, topsy-turvy, that the right is wrong and wrong is right, and all of those things make no sense. You cannot make a country safe simply by legislating it so. And we know that it is no deterrent, because the supposedly harsh bills that came before have not been a deterrent either. It's been 181 days since the last tough, harsh, difficult deterrent piece of legislation was passed, and those measures are not even yet in force from their previous tough, difficult, harsh bill that would be a deterrent. So we cannot believe them now. And you will also find that the tiniest number of people are actually going to be sent to Rwanda anyway. A tiny, less than 1% of the crossings this year would be sent to Rwanda. What happens to the rest of people left in immigration limbo to wander the streets of these islands? They can't say, they don't know, and they have no idea for what they will do when people have no rights and they are out looking for assistance. Mr Speaker, this bill amounts to nothing more and nothing less than state-sponsored people trafficking. Far from, they don't like to hear it, but it is the truth. They don't like to hear it. And I will explain to them exactly why. Listen to my description and see what they think. Far from dismantling criminal gangs. This government has become the criminal gang, breaking international law, moving vulnerable people across the world without legal process, no right of appeal, no concern for the safety or human rights of asylum seekers, to a country they do not know, involving money and involving profit. It involves people. It involves people that this government will never meet, will never look in the eye, will never sit across the table and watch them in tears because they can't be safe. Robert Burns said, that great humanitarian of Scotland said, man's inhumanity to man make countless thousands mourn. I mourn what this government is doing to human rights, to the undermining of international law and international principles. And I give this assurance, when Scotland gets our independence, we will take our place in the world, we will take our responsibilities seriously, and we will play our full part in the world as an independent nation.
Sir Liam Fox.
Mr Speaker, can I begin also by adding my tributes to Tony Lloyd, one of the most charming and civilised politicians in this House, a model that would do well to be replicated more widely than it sometimes is. It's very clear from the debates in the last couple of days that it is this side and this side only that understands the concept of deterrence when it comes to the old lady has had her hysterical say, I will have mine. When it comes to the importance of dealing with illegal immigration. And it's in stark contrast, I have to say, to the intellectual vacuum that now passes for today's Labour Party. On this side, the debate has been entirely about workability of the bill. And there have been some exceptional speeches, if I may single out my right honourable friend for Newark, in those debates in the past couple of days. Now, I don't believe that we should be demonising at any point those who want to get a better future for themselves by seeking asylum or migration to the United Kingdom, a fine, fair, tolerant society that anyone would want to come to. But the principle of territorial assignment, the right to access the national asylum system upon putting foot on land, has already had a coach and horses driven through it by the fact that many of these are not coming from a dangerous country by boat, they're coming from France. And that cannot be tolerated if we are to have control over our borders. And even more important, a point made very frequently by my right honourable friends, is the need to curb the evil of people smuggling and destroy the economic model of those who traffic in this most disgusting trade. And I have to say, Mr Speaker, political infringements of the ECHR are nothing to the duty to stop people suffocating in lorries or people drowning coming across the channel, particularly when France is a country that is perfectly willing to ditch the judgments of the ECHR when it suits them, when it comes to deportation. Our deterrent will be even greater if we pass this legislation and can convince other countries to do the same in a synergistic way. Now, this bill may not be everything that everybody wants, but it is much better than what we have today. If I were only to have voted for legislation that I agreed with 100%, my voting record in the past 32 years may have been different from it is today. And I hear those in my own side saying, actually, we can replace this bill with something else. Well, we can't, Mr Speaker. As you well know, Erskine May says, and I quote, when a bill has been rejected or lost through disagreement, it should not, according to the practice of Parliament, be reintroduced in the same session. This is the one chance that we get to pass this legislation. What we do will be judged by our voters according to their priorities. If we leave tonight with nothing, that judgment will be harsh, or worse, leave us to the cringing mediocrities that make up His Majesty's opposition.
Tony Lloyd, who I sat with for his last speech, which was in Westminster Hall, on human rights, on this very issue we're discussing now, and he spoke with such wisdom, and we will all miss him. I also am shocked to hear a member calling another member, female member, hysterical. It's a classic call-out of misogynistic term, and I was shocked to hear it, Mr Speaker. So this is the third reading of the third bill to try and stop the channel crossings in 2 years. The first, the Nationalities and Borders Act, has been partially suspended because it was making things worse. The second, the Illegal Migration Act, has mainly not been implemented because the Home Office believes it's unworkable. And so here we are for the third time. This is the fail again and fail harder version. Unaffordable, unworkable, unlawful. It weakens our national borders. It undermines international courts, those courts that protect and that we rely on as British citizens. And I've been very concerned about the attacks on the European Court of Human Rights during debates on this bill. And the costs are spiralling. £400 million, plus £2.1 million already spent in legal bills alone by November 2023. This latest gimmick, not a plan, lets down people fleeing persecution and won't deliver on fixing the immigration system. It will leave nearly 100,000 cases in a backlog, 56,000 people in hotels, and, as we've now heard, more than 4,000 people missing from the system. It won't fix the system that the Conservatives have broken. It won't be that deterrent. It's too small and unworkable. It doesn't respond to the international situation with increasing climate change impact and conflict around the world that is driving people to seek safety. It feels like the Conservative Party can't cope with international reality and have stuck their fingers in their ears and are chanting something about Rwanda instead of facing up to reality. And this lets our country down. What will stop the boats and the dreadful deaths in the cold seas is Labour's plan. We will clear the backlog with a new fast-track system and 1,000 officers. We will end hotel use, saving the taxpayer over £2 billion, and improve enforcement with a new returns and enforcement unit to reverse the collapse in returns for those who have no right to be here. Look, the Conservatives started this by employing some temporary new officers, and it started working. So why not invest in things that work instead of this gimmick? That they have started clearing their backlog. The Tories have also started smashing their gangs with work that they are doing in France. Again, it's beginning to work, so why not invest in those things that work, not the Rwanda plan? It's a nonsense to start something but not finish it and leave a half-baked plan in place. What works is smashing the gangs and working with France. We would smash the supply chains with new powers and a new cross-border police unit, which will stop the boats reaching the French coast in the first place. We would work in partnership internationally to address some of the humanitarian crises which are leading people to flee from their homes. We believe in strong border security and a properly controlled and managed and fair asylum system so that the UK will do our bit to help those fleeing persecution and conflict, but return those with no right to be here. And we believe in stopping the gangs, who are the only winners from this bill. Under the Tories, we just have costly chaos. Thank you.
So Therese Coffey.
Thank you, Mr. Speaker. It's important to speak in this bill today. I have to say I was somewhat astonished by the speech of the shadow Home Secretary, who can't even get the name of the country right, talking about the Kigali government. We're talking about Rwanda, a respected country that has recently been president of the Commonwealth. In that regard, though, Mr. Speaker, I also want to associate my comments with those respecting the sad loss of Sir Tony Lloyd. I'm conscious that both as Member of Parliament in both Manchester and Rochdale, that he was assiduous for his constituents, assiduous when he was in government, and he will be much missed from this House. The reason I stand today is that I am very keen to make sure that this bill gets through third reading with the largest majority possible, so that we can say to the other House, the elected House has had its say, and we're doing this bill solely because, having had excellent bill taken through by my right honourable friends, the members for Fareham and Newark, the Illegal Migration Act, which we should all remember, the Labour Party opposed religiously, blocked everything that we tried to do. But the Supreme Court, after disagreeing with the High Court, pointed to the issue about Rwanda specifically. And I think it's important that Parliament stands up, addresses that specific point, so that we can get through this stage and then commence the relevant sections of the Illegal Migration Act, particularly regarding having a safe third country. Now, I'm very conscious that temperatures are pretty high, but there is a genuine passion on this side of the House to respect the will of our constituents who want to see a fair, legal migration system and not this vague plan, which really isn't a plan by the Labour Party. But I want to say to my right honourable and honourable friends, do support this bill tonight so we have the biggest majority possible. And I point to clause 2 of the bill, where specifically it says in law, and I appreciate what other members have said, but it's very specific that when decision makers are making these decisions, that Parliament has given its full confidence that when people go to Rwanda, that they will be treated fairly, that the conventions will be applied, and then we will have that effective process, but also that effective deterrent, which I think actually the whole House seeks. So, Mr. Speaker, let's be clear, let's talk as one voice. I wish that the opposition would come on this side. I know from their track record of opposing the Illegal Migration Act that actually they might talk the talk, they're full of bluster, they don't really mean it, they don't really care. But I know that this Conservative government cares, I know that every Conservative MP cares, and we need to make sure that the Lords listen to the elected House.
I just want to say I'm personally gutted by the loss of Sir Tony Lloyd. He was a decent, kind, wise man and an excellent Member of Parliament, and we will all seriously miss him. As for this debate, they do say that the smaller stakes, the more ferociously over which they are fought, and the small stakes are that 1% of the asylum seekers who come to this country might just, if this bill works, end up being sent to Rwanda at the cost of £240 million and counting. And we know it won't be a deterrent. We know that people have travelled from the Horn of Africa, as I said earlier on, and through Libya, through over the Mediterranean, through Europe, to that tiny fraction of people who end up trying to cross the English Channel, as if that will put them off, the 1% chance they may go to Rwanda, having taken all the risks they've taken to get as far as France. And of course people travel from France, because they're not going to blooming sail directly from Libya, are they, for pity's sake? People will come from France. The French government could turn round to the Spanish and to the Italians and say, no, you're a safe country, stay there. You see where I'm going from all this. If we don't work cooperatively, then the whole thing falls down. The real issue is a 165,000 backlog of asylum cases that this incompetent government has failed to clear. The issue of deterrence I've already tried to cover, but one issue that I think will come about is that people may well decide, the people smugglers may well decide to bring people into this country, and they will simply go under the radar, not claiming asylum at all. So you won't reduce the number of people coming here, you will massively increase the number of people who end up in the black market, being in people trafficking, being victims of sexual slavery and so on. Only a quarter of those few people who are denied asylum, who do go through the system, only a quarter of them are actually removed by this government. So what we've got is a government that talks tough and acts weak. If you actually wanted a deterrent, then you'd make sure that there was a system that actually dealt with those 165,000 people, and you removed the ones who weren't genuine asylum seekers. Even the government's own figures, though, show that 75% of those people who come here claiming asylum are legitimate and genuine refugees. If you want to deter people, assess them and then return the ones who are not genuine refugees. But the weakest thing of all about this bill is it's predicated upon the government's desire, because they think somehow the electorate likes this, that they would demonise those people who are the most vulnerable in the world. I want to say, Mr. Speaker, that they have misunderstood and massively underestimated the British people and certainly my constituents, who are better than they think they are. I can tell you about my community. 1945, half of the children who survived the death camps in Nazi-occupied Europe came to our shores. In fact, they came to the shores of Lake Windermere. They were the Windermere boys, the Windermere children, and we are proud of that legacy, because that speaks to the kind of people we are in the lakes and the kind of people we really are in Britain. When you speak to people, and I've visited some of the camps in Europe, when you visit people and you speak to those people who are seeking to come to the United Kingdom, and by the way, there are 19 European Union countries that take more refugees per head than the United Kingdom, which is an important thing to remember. When you talk to those people who do want to come here,
here? What is it that drives them to come here? It's not benefits, it's not the NHS, it is a belief in Britain. They believe Britain is the kind of place where you can raise a family in peace, where you can earn a living, where you can have religious freedom and other liberties. And the thing is, that reputation is built on hundreds of years of experience, a proud experience of what it is to be British. Our forefathers and foremothers have built that reputation. It will take more than this tawdry government and this shabby piece of legislation to undermine that reputation overseas. They want to make Britain unattractive. They will fail. This bill will fail. It is a costly, expensive failure, and it deserves to be rejected by this House.
Mr. Speaker, I'll be quick, but it's been a very useful debate already, because we've heard from the opposition parties where they stand. We've heard from the SNP that they want Scotland to take its place among the nations of the world. What we didn't hear is whether they want to take Scotland to take its fair share of the refugees of the world, because so far they don't do it. And we heard from Labour, which was very good to hear, that they do in fact have a plan to stop the boats. It's our plan. It's everything that we're doing already, just without the Rwanda bit, which is the one essential piece of the jigsaw that will act as an effective deterrent and stop the boats. I honour the honourable gentleman from the Liberal Democrats and his passionate speech there, but I think what he was saying is that we should just be more like Europe when it comes to refugees and asylum, and I'm not sure that's what the public want. Mr. Speaker, I just want to pay tribute briefly to a few people. The government whips, first of all, have done a brilliant job today. My congratulations to them, and I honour their efforts. They've been more successful than I have been today, but I'm very glad that we're all more or less united again as a party. Can I pay particular tribute to the Minister who has worked with colleagues across our party and across the House, in fact, to address the concerns that we had. And I'm pleased to say there have been some commitments today and in the last few days. I don't think they go far enough. And I want to just acknowledge the really important work that my honourable friends from Stone and from Newark have done through the committee stage of this bill, because I think that the amendments that they tabled and that so many of us have supported in the last 2 days would have made significant improvements to the operation of this bill. We are all on the same place, as many colleagues have said. We all want to do the same thing on this side of the House, which is to establish an effective deterrent that would ensure that people who are across the channel are immediately detained and removed. I don't think this bill is going to work as it's currently drafted, I'm afraid to say. I think that, in fact, we will see legal challenges that will clog up the process and ensure that the deterrent is not enforced. I regret that we are not honouring the trust that we had made to the people to effectively control our borders, which is what they voted for in 2016 and 2019 so decisively, and what all the opinion polls, all our constituents tell us, all common sense tells us, is such an essential part of our commitment and our responsibilities in government. And I regret that the essential principle of parliamentary sovereignty, while the bill pays tribute quite ostentatiously to the concept, does not in fact ensure that that is going to be the case. We believe that statutes passed in this place have supremacy over judge-made law and certainly over the jurisdiction of the European Court. And I'm afraid to say that the bill as it stands, much as the government agrees with the principle I've just established, the bill as it stands still allows lawyers to use foreign international law commitments and protocols to override the supremacy of Parliament, and I deeply regret this. My view is that we could have got a better bill through Parliament in this session. I think we could have developed it, and I understand it would have been possible to bring forward a bill of a different scope that would have achieved the same ends. So I regret that we're not doing that, but I understand this is where we are. Many of my colleagues, and I honour them for their decision, have decided to vote with the government tonight because they don't want to cause the political disruption which a government defeat would ensue. I respect that greatly. I think that's a very honourable position. My view is, I said at the outset that the bill needed these improvements. I don't think it'll work. I think we could have done better. Nevertheless, the fundamental fact is that we on this side of the House are united in our commitment to stopping the boats through this policy. The real division is not this gangway, it's that aisle. And the great value of the debates that we've been having is that it exposes the position of the parties opposite. They don't believe in stopping the boats, and we all do. Thank you.
Thank you.
Mr Speaker. The tribute I received about Tony Lloyd today came from the ex-Chief Constable of West Midlands Police, who used to be the Deputy Chief Constable of Greater Manchester Police, and he said that Tony was one of the best people he had ever worked with, and so I stand here to say that. I want everybody in here to know that they are about to vote for a bill that they have absolutely no idea how much it's going to cost. Like, we haven't been given that information. I was in for the committee stage of the debate. Earlier, and the chair of the Home Affairs Select Committee said that there was a view that each person that was sent to Rwanda would cost £169,000. And it piqued my anger so greatly, because I had just come from an event with the Home Secretary around it being a year on from the independent child sexual abuse inquiry, and what progress we have made since then. And I was holding in my hand a piece of paper that said that in 2022, 100,000 children were sexually abused, and came forward and said it. And then I looked up how much money the Home Office was allocating for their Sexual Abuse Against Children Fund in 2022, and it was £4.5 million, which I worked out was £42 for every child who'd been raped in that year. And I thought, what political capital of walking round and round and round and round for now the third bill for something that won't work. And 150 judges can be found yesterday under the, the sofa by the Prime Minister, when cases in my constituency of rape victims waiting 7 years to get in front of a judge. Frankly, Mr Speaker, people who think that the amount of time spent on wasting taxpayers' money on something that hasn't worked the last 2 times we tried it and will not work this time, frankly, Mr Speaker, should be ashamed of themselves for voting for something when they don't have any idea how much it's going to cost the people in their constituencies. I hope they feel shame for the amount of airtime and the amount who turned up today, but not for the victims of child abuse. Excuse me, would you like to intervene? No. The other thing I want to say is that I was in a British court last week, not a foreign court, a British court. I was in a British court with a victim of human trafficking. She'd been trafficked twice. We deported her once already as a trafficking victim, and she was re-trafficked back to this country. And I went to the upper tribunal with her last week. She has 2 children born of the repeated rapes that she suffered as a victim of human trafficking. And the Home Office was trying to deport her again, to which the judge scolded the Home Office lawyers for daring to bring it in front of them. And because I was sat in the courtroom, the Home Office lawyers were not so keen to give their evidence in front of me, so they didn't really give any. Yeah, I wonder why they didn't want to talk about how it was fine for a woman who'd been ritually raped repeatedly and repeatedly to have to go back to the country where that had happened and she had been trafficked to here. I have heard nothing today in any of the debates about when we scoop up all these people without any appeal, what happens to the victims of human trafficking? What happens to them? Because currently I've sat in courtrooms where this government is abusing them. I would never vote for this. Not today, and neither should anybody else.
Jeremy Corbyn.
Thank you, Mr Speaker. I was first elected to this House on the same day as Tony Lloyd in 1983. He was a brilliant friend, brilliant comrade, voted against the Iraq War, student tuition fees, and against the renewal of Trident, and was a brilliant Shadow Northern Ireland Secretary, and he will be much missed by many good people all over this country. This bill, Mr Speaker, is an appalling piece of legislation. It fails to take any account of the human suffering of people that are forced, through lack of any other alternative, to try to make a very dangerous crossing across the Channel. I have met people in Calais who are desperate, who are poor, are confused, have travelled from Afghanistan and other places. They are victims of war, of human rights abuse, and of poverty and so much else. The government is now claiming that the only way to deal with this is to attack what they euphemistically call as a foreign court, when in reality that court is the European Court of Human Rights, which is part of our judicial system, and that they are trying to offshore their obligations under international law and international treaties. Look at it on a global stage. It is the wealthy countries of the world, such as Australia and Britain, that want to offshore issues surrounding asylum and the rights of people to seek asylum and pretend that somehow or other they're doing the world a favour. We have to work with other countries to deal with the issue of the desperation of so many refugees in Europe, far more in other parts of the world. This bill blames those people for being victims, plays into the narrative of the most backward, horrible remarks made in our national media and national newspapers about asylum seekers, without ever recognising that those people that have sought legally to seek asylum in this country, it's always legal to seek asylum, that's there in treaty. Tomorrow, eventually, there'll be our doctors, there'll be our lawyers, there'll be our teachers, there'll be our engineers, as they are all over Europe. But it's playing into this sort of racist trope against refugees all over the world, and it is attacking refugees because of where they come from. And so I hope that the House tonight rejects this bill, but I hope in future we don't come back to this kind of debate. Instead, we start to look at the issues of human rights abuse, victims of war, victims of environmental disaster, and the needs of those people to be cared for on this planet as fellow human beings, rather than making them out to be the enemies they certainly are not. Desperate people are looking for a place of safety. Surely it's our obligation. The Home Secretary is getting very excited, but it's his obligation to try and make sure they do have a place of safety in which to survive for the rest of their lives.
Mr. Speaker, I too pay tribute to Tony Lloyd. He was a far, far better man than most of us in this House, I think we would all admit. And those of us who have survived thus far advanced cancer often feel a particular poignancy. I know the Home Secretary will agree with this point, when someone is lost, a friend is lost to cancer. So my condolences go to his family, and I hope we will have a proper time to commemorate him, as you've said, Mr. Speaker. Mr. Speaker, I want the boats to stop, not because I don't value the lives of those who've paid thousands of pounds to risk their lives on the high seas in unseaworthy vessels, but because I do value their lives, because I despise the people traffickers, and because I don't want the generosity of the British people to be tested to breaking point. I'm voting against at third reading today for 4 reasons, though. First, I agree with the right honourable members, they're not all here now, I'm afraid, but for Newark, for Stone and for Devizes, this bill won't work. It's a false promise, and I'm sick of false promises. It's a waste of money, and I'm sick of the government wasting our money. And I'm very sceptical that it will actually act as a deterrent. After all, if the freezing waters of the Channel that can take a life in a matter of minutes are not a deterrent, how will a 1% chance of being transported to Rwanda act as a deterrent? Second, this bill is based on a heady mixture of gross exaggeration, preposterous wishful thinking, and miserably misconceived machismo. Look at the exaggerations. The Right Honourable Member for Newark said yesterday, millions of people in the world want to make that journey in a small boat. Where on earth is his evidence for that? The Right Honourable Member for Fareham said that there are many instances of asylum seekers purporting to be homosexual to receive preferential treatment in asylum applications. Where on earth is her evidence for that? Many have claimed that the vast majority of those arriving in small boats are economic migrants. But the evidence is that when the Home Office has investigated, it has granted 65% of them refugee status. Third, the Right Honourable Member for Newark said yesterday that the law is our servant, not our master. But it is wrong that even without amendment, this bill places ministers above the law. It means, Mr. Speaker, that even if a dog is factually a dog, and a court, having interpreted the law, has adjudged it to be a dog, the government can declare it nonetheless to be a cat. The former Attorney General said earlier, quite rightly, that we rely in the UK on international law. It's the basis of how we protect ourselves and our interests. So how can we argue that China and Russia and the Houthis should not renege on international human rights law when we ditch it when it's inconvenient for us? And how many of us condemned Russia, quite rightly, when it declared by statute law that Luhansk and Donetsk were part of Russia when they are patently part of Ukraine, as laid down in international treaty? Fourthly and finally, Mr. Speaker, the Right Honourable Member for Newark said yesterday, we are not a parish council. I agree. So let's stop behaving like Handforth Parish Council. Let's behave like the House of Commons. Protect ancient liberties, including the right to appeal, respect the rule of law and honour our international commitments, like honourable members.
Okay, well, the committee's gone through the House and it's not made any amendments, any of the varying and contradictory amendments from the varying and contradictory factions on the Tory parties. And what we're left with is a bill that in reality nobody actually wants. The hardliners on the Tory party right don't like it, something to do with foreign courts. The Tory left don't particularly like it because they realise how close it sails to breaching our international human rights obligations. The official opposition don't like it, I think, because it's too expensive. And on the SNP, we are opposed to this bill and the entire hostile environment policy in principle, because this is just completely the wrong way to deal with some of the poorest and most vulnerable people who come to these shores seeking refuge and safety. We want to welcome refugees and encourage them to contribute to our economy and society. But, Mr. Speaker, it seems even the Republic of Rwanda is getting cold feet, and no wonder, notwithstanding the fact that the United Kingdom continues to grant asylum to asylum seekers from Rwanda. Why should a country that aspires to be a prosperous, stable African democracy allow itself to become a political football for wannabe leaders of the opposition who currently inhabit the Tory benches? According to the Prime Minister today, the best, or perhaps the worst thing about Rwanda is that it is not the UK. And the very fact of not being the UK is a deterrent for people to come here because they might be deported to it. So by the same logic, if the government threatened to deport people to Disneyland, that would also be a deterrent because Disneyland is not in the UK. Now, of course, Disneyland is a place where dreams are supposed to come true. But I think the former Home Secretary and indeed the former Immigration Minister's dreams of flights taking off to Rwanda are not going to come true. And neither are their dreams of becoming the next leader of the opposition after the election. But the dream on these benches of an independent Scotland, the dream which will never die, of an independent Scotland that has its own independent, humane asylum system which recognises human rights and wants to welcome refugees, that dream will come true, and sooner rather than later, Mr. Speaker.
The question is that the bill now be read a third time. As many of that opinion say aye. Aye. To the contrary, no. No. Division, clear the lobbies. The question is that the bill now be read a third time. As many of that opinion say aye. Aye. The contrary, no. No. The tellers for the ayes are Mark Fletcher and Scott Mann. For the noes are Sam Dixon and Andrew Weston. Lock the doors! Order.
The ayes to the right, 320. The noes to the left, 276.
The ayes to the right, 320. The noes to the left, 276. The ayes have it, the ayes have it. Lock! I'll just let the chamber clear and then we'll...
Thank you, that's a good idea.
Nobody's objecting.
Right. I think that's it.
I'm going to put motions 3, 4 and 5. Minister to move.
I beg to move.
The question is, as on the order paper, as many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it.
I beg to move that this House do now adjourn.
The question is, this House do now adjourn. Simon Jupp.
Thank you, Mr Speaker. I'm delighted to have secured today's important adjournment debate on hospice funding in Devon. I welcome the Minister and colleagues to this debate. A few years ago, at a dinner hosted by the Rotary Club of Exeter, I was sat between the Bishop of Exeter and Dr John Searle, the